Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Dr. Amory Brown, Senator the Honorable Paula Gopi-Schoon, and Senator the Honorable Rohan Sinanan, all of whom are out of the country. Honorable Senators, I have received the following correspondence from Her Excellency the President, Christine Carla Kangaloo, OR, TT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Christine Carla Kangaloo, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Mr. Ndali Young. Whereas Senator the Honorable Dr. Amory Brown is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Ndali Young, to be a member of the Senate temporarily with effect from the 31st of May 2023 and continuing during the absence from Trinidad and Tobago of the said Senator the Honorable Dr. Amory Brown. To Ms. Yukima Bethelmi, whereas Senator the Honorable Paula Gopi-Schoon is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a), the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Yukima Bethelmi, to be a member of the Senate temporarily with effect from the 31st of May 2023 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Paula Gopi-Schoon. To Mr. Harvey Boris, whereas Senator the Honorable Rohan Sinanan is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Harvey Boris, to be a member of the Senate temporarily with effect from the 31st of May 2023 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Rohan Sinanan, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 31st day of May 2023. Honorable Senators are required to take the oath.
I, Ndali Young, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
I, Yukima Bethelme, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Harvey Boris, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives. The Miscellaneous Provisions Establishment of the Borough of Diego Martin and the Borough of Siparia Bill 2021 in the name of the Minister of Rural Development and Local Government. The Valuation of Land Amendment Bill 2023 in the name of the Minister of Finance. And on the supplemental order paper, the Municipal Corporations Extension of Terms of Office and Validation Bill 2023 in the name of the Attorney General.
Attorney General.
Mr. President, in accordance with Standing Order 62(1)B, beg to move that the next stage of the Municipal Corporations Extension of Terms of Office and Validation Bill 2023 be taken later in the proceedings.
Honourable Senators, the question is that the next stage of the Municipal Corporations Extension of Terms of Office and Validation Bill 2023 be taken later in the proceedings. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The next stage of the Municipal Corporations Extension of Terms of Office and Validation Bill 2023 will be taken later in the proceedings. Acting Leader of Government Business.
Mr. President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the Valuation of Land Amendment Bill 2023 be taken on Friday, June 2nd, 2023.
Honourable Senators, the question is that the next stage of the valuation of Land Amendment Bill 2023 be taken on Friday, June the 2nd, 2023. Those in favor say aye. Those against say no. I think the ayes have it. The next stage of the valuation of Land Amendment Bill 2023 will be taken on Friday, June the 2nd, 2023. Acting Leader of Government Business.
Mr. President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the miscellaneous provisions, establishment of the Borough of Diego Martin and the Borough of Siparia Bill 2021 be taken on Tuesday, June 6th, 2023.
Honourable Senators, the question is that the next stage of the miscellaneous provisions, establishment of the Borough of Diego Martin and the Borough of Siparia Bill 2021 be taken on Tuesday, June the 6th, 2023. Those in favour say aye. Those against say no. I think the ayes have it. The next stage of the miscellaneous provisions, establishment of the Borough of Diego Martin and the Borough of Siparia Bill 2021 will be taken on Tuesday, June the 6th, 2023.
Papers.
Acting Leader of Government Business.
Mr. President, I have the honor to lay on the table excuse me, the following papers as listed on the order paper and supplemental order paper in the names of the Minister of Finance, the Prime Minister, and the Minister of Planning and Development. The second reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Agricultural Society of Trinidad and Tobago for the years ended December 31, 2006 and 2007. The ministerial response of the Office of the Prime Minister to the first report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of the Urban Development Corporation of Trinidad and Tobago Limited, UDCOT, for the financial years 2014 and 2015. The ministerial response of the Office of the Prime Minister, Communications, to the fifth report of the Joint Select Committee on Finance and Legal Affairs on an inquiry into the implementation of a regulatory framework for the development of financial technology, fintech, and e-payments. The ministerial response of the Ministry of Planning and Development to the fifth report of the Joint Select Committee on Social Services and Public Administration on an inquiry into the state's capacity to provide support for victims of domestic violence and family conflicts, with specific focus on the availability of support mechanisms during the COVID-19 pandemic. The Value-Added Tax Bond Payment Refund Amendment Regulations 2023. A special report of the Auditor General of the Republic of Trinidad and Tobago on the audit of Sustainable Development Goal 3, Target D, contributing towards a strong and resilient national public health system, 2016 to 2021. The ministerial response of the Ministry of Finance to the fifth report of the Joint Select Committee on Finance and Legal Affairs on an inquiry into the implementation of a regulatory framework for the development of financial technology, fintech, and e-payments. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Environmental Management Authority, Environmental Trust Fund for the year ended September 30, 2022.
Reports from
Senator Mark.
Yes, thank you, Mr. President. Mr. President, I have the honor to present the following report as listed on the order paper in my name. The 12th report of the Public Administration and Appropriations Committee on an examination into the accessibility and availability of diagnostic imaging services at public health institutions in Trinidad with specific reference to regional health authorities under the purview of the Ministry of Health.
Urgent questions.
Senator Mark.
Thank you, Mr. President. To the Honorable Minister of Energy and Energy Industries. In light of claims of the illegal dumping of oil in the Caroni River, which would have a negative impact on the country's ecosystem, can the minister indicate what immediate measures are being taken to address this situation?
Minister of Finance.
Thank you very much, Mr. President. Speaking as Acting Minister of Energy, the facts are as follows. Immediately upon being informed of this incident, the Ministry of Energy activated its protocols and sent officers to the scene, where they met with officers from the Environmental Management Agency to commence investigations into the report. To summarize, what is being done is that a specialist contractor who has expertise in the cleaning up and dealing with oil spills has been mobilized. This is a contractor that would normally work with Heritage Petroleum. And more importantly, the spill was attended to by the Ministry of Energy, as the ministry is the lead agency for the National Oil Spill Contingency Plan. So it is the responsibility of the Ministry of Energy to determine, based on the scale of this spill, whether the National Oil Spill Contingency Plan requires activation at a particular level. The ministry also seeks assistance, as has occurred in this case, from oil operators to mobilize oil spill response equipment and resources to treat with the spill. Specifically, when the Ministry of Energy and EMA officers visited the site of the complaint, no oil was seen at the alleged location, or the reported location is a better word, in Bamboo number 2. Accordingly, the officers went further downstream, along with Heritage Petroleum staff and Heritage's oil spill contractor. They assessed the river up to its mouth. Not much oil was seen, just in small pockets with some stained vegetation. Samples are to be taken from areas where the dumping was observed and along the river. The river and shoreline assessment continues, and as of this morning, very little oil was seen. The Forestry Division has also been contacted to assist with the shoreline assessment. I want to say at the outset, Mr. President, that the government takes the question of oil spills very, very seriously. And the Ministry of Energy will continue with this right through to the end, after the samples have been taken and assessed, to determine the source of the oil, if at all possible, and to take action against the perpetrators. We are grateful that so far the information indicates that the effect of the spill has not been so severe to cause the activation of the National Oil Spill Contingency Plan at a high level, but we are monitoring the situation and will take all appropriate action.
Senator Mark.
Yeah, thank you, Mr. President. Mr. President, through you to the Honorable Minister, can the Minister indicate what measures will be taken as a result of this particular development to ensure, through monitoring mechanisms, such occurrence or occurrences do not take place in the future?
So, Senator Mark, the answer to that question is contained in the answer given by the Acting Minister.
Can I ask through you, Mr.
Just
President?
second supplemental, Senator Mark.
Yes. Can I ask through you whether the Minister can share with this Senate whether the Ministry of Energy has done any assessment of the quantum or quantity of oil that would have been spilled or dumped in the Carney River thus far?
Acting Minister of Energy and Energy Industries.
Thank you very much, Mr. President. I want to repeat that the ministry and the government we are taking this very seriously. Any spillage of oil in the marine environment causes damage and is something that must be addressed in the most serious manner. The action was taken based on a report. Somebody who is a resident in the Bamboo area reported to the ministry that a truck or tanker had dumped oil in the river. However, as I've indicated, when the officers went to the site in Bamboo, there was no evidence, no obvious evidence of any spillage of oil in that location. And they had to go all the way downstream, and they really didn't find that much except at the mouth of the Carney River where it meets the sea. There are some small traces of oil. But notwithstanding the fact that it appears on the face of it that the amount of oil that was put into the river is not a huge amount, we will treat with this with the utmost seriousness to find out who exactly did this and take action against the perpetrators.
Questions on notice, questions for oral answer.
Acting Leader of Government Business.
Thank you very much, Mr. President. Mr. President, there are 3 questions that qualify for oral answer, and the government is prepared to answer all. There's 1 question for written answer, and that answer has been provided and will be circulated.
Senator Mark.
Thank you, Mr. President. Question number 58 to the Minister of Public Utilities.
Minister of Public Utilities.
Mr. President, the Water and Sewage Authority has advised that the Las Alturas housing development is supplied with potable water via a 2-chair tank and pumping system in which WASA supplies the tank farm directly, and the HDC, the Housing Development Corporation, distributes the water from the tank farm throughout the development via pumping system. It should be noted, Mr. President, that WASA's normal schedule for supplying water to the tank farm at the development is on Tuesdays and Fridays from 12 p.m. to 6 a.m. on both days. WASA investigated the complaints of residents at the development and determined that the primary reason for the lack of a potable water supply to the residents was malfunctioning HDC pumps. To solve this problem, WASA and the HDC collaborated, and the HDC repaired the pumping system 2 months ago. As a result, the residents of the development are currently in receipt of their regular supply of water as per their normal schedule.
Senator Mark.
Yeah. Can I ask the Honourable Minister what plans are there to improve the supply of water to the residents of this particular development on a more frequent basis from what you have just said, Tuesdays and Fridays only between certain hours? Is there any plan to address that situation?
That question does not arise. Senator Mark. Next supplemental.
May I go on to 59? Question number 59 to the Minister of Health.
Minister of Health.
Thank you very much, Mr. President. Equitable access to COVID-19 antiviral therapy remains elusive. In fact, Paxlovid is still out of the reach for many countries around the world, and its availability has been limited thus far to high-income countries like the United States. In addition, Pfizer's monopoly also means that middle-income countries may be asked to pay up to 10 times more for Paxlovid than a generic equivalent. It should also be noted that while the drug has had emergency use authorization
from the US FDA since 2021, late 2021. The FDA only granted full approval to Pfizer's oral antiviral COVID-19 treatment, Paxlovid, on May 25, 2023, barely 1 week ago. Notwithstanding this, Mr. President, the government continues to explore all options as it relates to the procurement of Paxlovid, including through the CARICOM Secretariat, where a request was made over 1 year ago on February 2nd, 2022, and also bilateral arrangements with international manufacturers. Thank you.
Yeah, I'll go on to number 60. Question number 60 to the Minister of Health.
Minister of Health.
Thank you. Yes, to improve the outcomes in non-intubated patients with COVID-19 pneumonia and to make these drugs available to the general population, the government has increased its stock of steroids, such as tocilizumab and methylprednisolone. Stocks of the sedative propofol have also been increased. Thank you.
Yes, Government Business Bill, second reading.
Attorney General.
Thank you, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Amend the Terms of Office of Councillors and Aldermen elected in December 2019 to provide for elections in 2023 and to validate the actions of the said councillors and aldermen between the 2nd of December 2022 and the 18th of May 2023 be now read a second time. I have the privilege, Mr. President, today to pilot the bill brought from the House of Representatives. The bill is short and comprises 5 clauses to achieve 3 principal objectives. 1, the extension until the 18th of May 2023 of the terms of office of councillors and aldermen whose terms expired on the 2nd of December 2023. 2, to provide for elections within 3 months of the 18th of May 2023. 3, to validate the functions and actions of those councillors and aldermen between the period 2nd December 2022 and the 18th of May 2023. Mr. President, 2 significant circumstances have promoted the need for this bill and deserve appropriate reflection. The first is the mandate of this government to empower the people of Trinidad and Tobago to improve their lives within their communities. The second concerns an important part of the history of this country and the considerations which have informed the passage of local government legislation and which serve to lend clarity to the approach which we take today. As to the first, the mandate of this government, Mr. President, is to empower the people of Trinidad and Tobago. The Honourable Prime Minister has placed on record already of this Parliament the amendments introduced in 2020 by this government to bring about comprehensive reform of the Municipal Corporations Act 2020. That record exists in the Prime Minister's statement delivered in the House on the 24th of May 2023. Without repetition, it suffices for me to say that as part of my pilot today, I entirely adopt that statement of the Honourable Prime Minister as informing our considerations today for the passage of this bill into law. This brings me, Mr. President, to the second point of importance, the clarity and simplicity of this bill against the historical evolution of our local government legislation. That clarity promotes the passage of this bill today by a simple majority so that the people's business may proceed, respecting the government's adherence always to democratic principles, consistency in governance, and respect for due process and the rule of law. Mr. President, local government in Trinidad and Tobago started in Trinidad in 1927, when Trinidad was divided into 8 counties by the Division of Trinidad Act. County councils were established in 1945, with further legislative enactments in 1967 by Act No. 22 of 1967. In the consultations informing our constitutional ethos and development after independence, the topic of local government was addressed by national stakeholders before the 1974 Wooden Commission, as citizens contributed to the drafting of the 1976 Republican Constitution of Trinidad and Tobago. In 1990, Mr. President, the Municipal Corporations Act was brought into force. Throughout, the law governing local government has remained under development, driven in particular by this government. As we know, further amendments of a novel nature were introduced by the 2022 Act, the Miscellaneous Provisions Local Government Reform Act No. 11 of 2022. Mr. President, here we are today, therefore, with the benefit of the most recent judicial interpretation of the Municipal Corporations Act as amended, pronounced by the Judicial Committee of the Privy Council on the 18th of May 2023 in the Maharaj case. The Privy Council accepted the Court of Appeal of Trinidad and Tobago's record of the historical evolution of this legislation up to the proclamation of Section 11.4 and 12.5 of the Municipal Corporation Act. The Judicial Committee has held that the extension of the term of office of incumbent councillors and aldermen by 1 year constituted no violation of the Constitution of Trinidad and Tobago, but that that extension by amendment could not be interpreted as applying to the incumbent councillors and aldermen whose terms expired on the 2nd of December 2022. Assembled as we are here today, Mr. President, our task today is simple. We accept the ruling of the Privy Council. Every statement by and on behalf of the government since that judgment has been unequivocal and clear, because this is a democratic government which respects due process and the rule of law. Mischief makers, Mr. President, would seek to suggest otherwise, but I am confident that the discerning, intelligent population of this republic will not allow misrepresentations to cloud the clarity of the government's intention. We accept that today we must provide with the clarity that this bill provides for the period that has run its course since December 22nd to the 18th of May 2023, the date of the decision of the Privy Council. Mr. President, permit me briefly to address a concern which has been put on the record of this House by the Honourable Senator, Honourable Dr. Varma Diyal Singh, who appears from recent contributions in this very Senate on the 23rd of May to be troubled by the majority of the Privy Council ruling as it did. He appears from his remarks to be troubled by the fact that he considered that this Honourable Senate somehow participated in taking away the rights of persons to vote. Mr. President, I ask your leave to reassure the Honourable Senator and this House that there exists no reason for his concerns. This Senate can stand proud and hold its head high for that which it did in passing the 2020 Act into law and the subsequent proclamation which brought Sections 11.4 and 12.5 into force in November 2022. I give this assurance, Mr. President, to the Honourable Senator and to this House for the following reasons. One, the clarity of that which was effected by the Senate has the support of 6 judges of our higher judiciary of the 9 who pronounced on this matter. And this is not sophistry, Mr. President. Those 6 of the 9 judges accepted the wisdom and clarity of that which was approved by this august House And the difference which held sway was really only, as far as the majority was concerned, limited to a question of statutory interpretation of words used in the bill at the time. 2, nothing passed by this Senate has violated the Constitution of Trinidad and Tobago, and nothing passed by this Senate has taken away the constitutional right to vote of the citizens of this country. All 5 judges of the Privy Council were unanimous on this, as were the 3 judges of the Court of Appeal. The very history of Trinidad and Tobago, to which I have earlier referred above, carefully reviewed by our Court of Appeal from paragraphs 46 through 69 of its decision dated 10th February 2023, for those who wish to take the time to read that illuminating judgment, affirmed in significant measure by the Privy Council, is an aid, an interpretative aid, in construing the passage of legislation which is accepted by the very Privy Council in one of the cases relied on by the Court of Appeal when it adjudicated on the act at the time. I refer, Mr. President, to the case of the Commissioner of Prisons and CPASAD from this very country, reported at 2021 UK PC 13, cited by the Court of Appeal in the Mirage case, and the advice of Sir Bernard McCloskey in these terms, quote, "The board considers that the court engaged in the interpretation exercise must be alert to the historical context of the constitutional instrument in question. It is trite to add that the constitutional provision under scrutiny must be construed by reference to the whole of the instrument in which it is contained. Accordingly, Mr. President, 3, in its judgment in this local government case, the Privy Council was informed by the historical review of local government in Trinidad and Tobago, so carefully reviewed by our Court of Appeal, and was able for that reason to reject unequivocally the main constitutional plank which had been argued by the applicant, Mr. Mirage, in the case before the High Court and the Court of Appeal in these terms, and I quote from paragraph 20 of the Privy Council majority judgment, quote, "On any footing, the absence of any detailed provisions concerning local government elections leads to the inevitable conclusion that a change in the length of the terms of office of incumbent councillors and aldermen cannot amount to a contravention of the Constitution. The term for which representatives have been elected is important, but an increase by 1 year in the term of incumbent councillors and aldermen does not of itself breach any provision of the Constitution." Close quotation marks. Mr. President, let me be clear, as I have been since I have spoken to and about this judgment of the Privy Council. This government accepts the interpretation ruling of the majority of the Privy Council, which ruled that the amendments effected by sections 11.4 and 12.5 of the 2020 Act do not apply to the incumbent councillors and aldermen. It is why we are here today, to pass this bill into law, to, among other things, provide for an election to take place within 3 months of the 18th of May, 2023. I emphasize what I have said above, Mr. President, by way of comfort and reassurance to the Honourable Senator Dr. Dayal Singh. Indeed, Mr. President, it is instructive that the minority in the Privy Council and the majority in the Maharaj case disagreed with the majority on this point of interpretation at paragraph 59, subparagraphs 1 and 2 in these terms, and I quote from that minority judgment. "The plain language of section 11.4 of the MCA, read on its own and in its context, as part of section 11, uses councillors as including incumbent. Both its language and its functional purpose apply to incumbents for whom election is a past event. If councillors were to mean only those to be elected at the next election, there would be no statutory provision in the Act at all specifying the term of office of incumbent councillors, That is a strange vacuum which construction should, if possible, avoid. Close quotation marks. Permit me further, Mr. President, in speaking to the decision of the Privy Council, which has us here today, to refer to an authoritative column written by the nationally respected Dr. Terence Farrell and published on Sunday, the 21st of May, 2023, in the Sunday Express. And I read from parts of that Sunday column in order to give the reassurance for the last time to the Honorable Senator Dr. Varma Diyal Singh that there has been no violation of the Constitution by this Senate. Because I would not wish the listening public to think that it's only this gentleman at the podium at the moment who holds the view which I now read. And if you will permit me, in the first column of 6, I quote, "It is certainly true that the majority rules in the appellate court decisions. However, dissenting judgments have in many instances proved to have been correct. Lord Atkin's dissent in Liversidge is famous. Sat Sharma's dissenting judgment in Sinanan on whether a person accused of murder could access bail proved to be correct. Lord Bingham, perhaps the finest English jurist of his time, and 3 other judges dissented in Matthew, which sadly was unanimously reaffirmed by the Judicial Committee of the Privy Council in Chandler. Lord Bingham has also dissented in Surat. Dissenting judgments, says Dr. Terence Farrell, are often quite valuable, if nothing else." And I commend this to the Senator Dr. Varma Diyal Singh. "A dissenting judgment suggests that the matter is complex and not susceptible of easy resolution." Mr. Farrell, Dr. Farrell continues, with your leave, Mr. President. "In a detailed and powerful dissent, Lord Briggs and Lord Kitchen, examining the history of the Municipal Corporations Act, argued that it was obvious that sections 11 and 12 applied to incumbents. In fact, they point out that the majority's interpretation leads to absurdity." And in the last column of Dr. Farrell's opinion, this is what he says. "The dissenting opinion of Lord Briggs and Kitchen in support of an excellent Court of Appeal judgment by Justice of Appeal Prakash Musai and agreed with by Justices of Appeal Abood and Lucky effectively laid to rest the constitutional challenge, and they perceived no lack of clarity in sections 11 and 12. In my respectful view," Dr. Farrell concludes, "in this case, the minority were right and the majority got it wrong. While there are perhaps serious political implications, the majority judgment, which drew out both the President and Deputy President of the United Kingdom Supreme Court, has added nothing to our jurisprudence." If I may continue, Mr. President, I emphasize the above by way of comfort and reassurance to the troubled Senator Dr. Diyal Singh. Mr. President, the compelling reality for purposes of this bill and until this judgment was delivered on the 18th of May, 2023, is that the corporations continued to function lawfully, consistent with the provisions of the Municipal Corporations Act, Chapter 2504, and supported until then by the unanimous decision of the Court of Appeal of Trinidad and Tobago. This reality is put beyond doubt in the applicability, if it were needed, of the de facto officer doctrine, which is summarized in the authoritative text, Wade and Forsyth, Administrative Law, 9th edition, 2004, from pages 285 to 286, if I may quote, Mr. President, with your leave. "The acts of an officer or judge may be held to be valid in law even though his own appointment is invalid and in truth he has no legal power at all. The logic of annulling all his acts has to yield to the desirability of upholding them, where he has acted in the office under a general supposition of his competence so to do." Unquote. The incumbents In this particular case, the aldermen and councillors continued in office initially on the basis of the view held by the government that the proclaimed amendments applied to them as incumbents, thereby extending their terms of office from 3 to 4 years. This was plainly not an unreasonable view, Mr. President, held in good faith, and particularly since this was also the view of an unanimous Court of Appeal. More directly, the incumbents acted in their offices after the 10th of February, 2023, the date of the Court of Appeal decision, pursuant to that decision, which held on that date that the 4-year term applied to them. It is plain, therefore, that the incumbents acted under the general supposition that they were competent so to act, and the logic of annulling all of their acts has to yield to the desirability of upholding them. It follows then, Mr. President, that despite the 18th of May decision of the Judicial Committee, the actions of the incumbents should be considered legitimate in the eyes of the law. The incumbents continued to perform their functions, and the state duly paid their salaries in exchange for their services. In addition, the wider public received the benefit of those services. Indeed, there is a case to be made that the government need do nothing to alleviate the uncertainty created by the decision of the Privy Council that the term of office of the incumbents expired in December 2022. Mr. President, this is a responsible government. There is a good case, therefore, to be made for legislatively validating their acts. The public interest advantage of doing so is that it removes uncertainty, any uncertainty which has been created with regard to whether the public may rely on their acts and decisions, and avoids any continuing uncertainty and indeed any potential for mischievous, opportunistic maneuvers. I turn now, Mr. President, to the clauses of the bill. Clause 1, the short title. This act may be cited as the Municipal Corporations Extension of Terms of Office and Validation Act 2023. That speaks for itself. Clause 2, interpretation. In this act, Mr. President, as amended in the House on Monday the 29th, on an amendment which I moved, Clause 2 reads, councillors and aldermen mean the persons who served in the corporate office of the council during the period December 2nd, 2019 to May 18th, 2023. The rationale for that clause is that it is intended that this act to apply to all councillors and aldermen who served in that period, 2019 to May 18th, 2023. Clause 3, the extension of term of office of councillors. It reads, the terms of office of the councillors and aldermen which expired on 2nd December 2022 are hereby extended until the 18th of May 2023. The rationale, we have already acknowledged, Mr. President, the applicability of the de facto officer doctrine based on public policy, so that this provision is indeed in obedience to the further public interest principle being introduced, as Latin scholars would say, ex abundante cautela. The advantage of doing so is that it removes any uncertainty which has been created with regard to whether the public may rely on their acts and decisions, and avoids the possibility of further litigation. Councillors and aldermen are required to represent effectively the interests of the electoral district, municipality for which they are elected, and deal with constituents' inquiries and representations. Councillors work continuously, diligently, and tirelessly to improve the lives of all persons in their communities within the remit of local government. These local government responsibilities include, among others, public health, municipal police, spatial planning and building inspectorate, disaster management, repairs and maintenance to government schools and specified public buildings, cemeteries and crematoria. Clause 4, an election referred to in Section 11.1 of the Municipal Corporations Act for the year 2023 shall be held within 3 months of the 18th of May 2023. The rationale for that, Mr. President, The incontrovertible reality is that the proclamation issued on the 2nd of November, which brought a small number of the provisions of the 2022 Act into force with effect from the 8th of November 2022, substituted 4 years for 3 years as the periods of office of councillors and aldermen. During the currency of the challenges brought in the High Court and the Court of Appeal, the law remained in force. The government, led by the Right Honourable Dr. Keith Rowley, Prime Minister of Trinidad and Tobago, fully endorses that local government elections must now be held so as to ensure the continuity of the life of local government corporations for all persons throughout the country. This clause provides for the period being within 3 months of the 18th of May 2023, and that the writs of election shall be issued in due course by the Elections and Boundaries Commission. This ensures that each member of the public can exercise his or her right in accordance with the Municipal Corporations Act and related legislation to participate in the local government election. Clause 5. And this brings me, Mr. President, to alert this Honourable Senate that I will be moving an amendment at the appropriate time. Clause 5 reads, where the councillors and aldermen under Section 3 exercise the functions of councillors and aldermen between the 2nd of December 2022 and 18th of May 2023, and thereafter exercise the functions of councillors and aldermen up until the commencement of this Act, the exercise of those functions and all acts or things done pursuant thereto shall be deemed to have been as valid and effectual as if the Municipal Corporations Act expressly empowered them to exercise those functions. I should say from the outset, Mr. President, by way of explaining, which I will do in more full detail, the amendment which I shall move is that I have reflected since Monday on contributions which have been made to Clause 5, and I have benefited from a very illuminating conversation which I've had with Independent Senator Dr. Paul Richards, which I acknowledge publicly. The rationale, Mr. President, of Clause 5 will be, in due course, to validate the functions and all acts or things done by councillors and aldermen for the period between the 2nd of May 2022 to the 18th of May 2023. The hard work, diligence, and daily achievements, progression of projects vis-à-vis the use of plant, machinery, and equipment by the councillors and aldermen in these 2 limited periods are recognized and do not go unnoticed by this government and are to be validated by this bill once it becomes law. In the period between the 18th of May 2022 to the date of the election, when that election is called within the prescribed period, the mayors remain in office, and that speaks to the continuity that is provided for by Section 15 of the Municipal Corporations Act. Local government bodies have several responsibilities which are well known. They are set out. I need only mention a few of them. Construction and maintenance of local roads and bridges, construction and maintenance of minor drains and minor water courses, local health, general sanitation and rodent control, garbage collection and disposal, development and maintenance of recreation grounds, parks, and public spaces.
AJ, Attorney General, I think a senator would like to give way. Senators, just a reminder, you can raise in your seat and ask the speaker if they would give way.
I beg your pardon. Apologies to the senator. Yes, Senator, I give way.
Senator, thank you, Attorney General. Just to confirm for the record, so the amendment that you have moved in relation to Clause 5 is deletion of the words "and thereafter."
Yes, the amendment which I will be moving is when you look at Clause 5, the words to be deleted will be "and thereafter exercised the functions of councillors and aldermen up until the commencement of this Act."
Thank you.
That will be the amendment which I will propose. Thank you. So just to conclude, as I was about to, and I'm grateful to Senator Vera for that clarification. In conclusion, Mr. President, this bill underscores the government's vision for an effective local government system to facilitate the transformation and modernization of local communities to which this government has been committed. Indeed, the policy on local government reform in the Cabinet-approved 2016 policy document states, and I quote with your leave, "Local government is the democratic representative of communities. It is closer to the people than central government and can be dubbed the voice of communities. The People's National Movement will ensure that with the devolution from the Ministry of Local Government, the municipal corporations report directly to the Ministry of Finance, particularly on fiscal matters, and are adequately equipped and resourced to provide quality service to their communities and may improve the quality of life for all citizens." Mr. President, thank you for this opportunity to provide clarity and explanation as to the purpose and remit of the 5 clauses within this short bill, which has significant impact as part of the package of the government's legislative amendments encompassing local government reform. I beg to move.
Honourable Senators, just before I put the question, just a reminder that during the course of the debate, if you do have amendments, to please circulate them prior to committee stage through the clerks of the House. Honourable Senators, I shall now propose a question for debate. The question is that a bill entitled "An Act to Extend the Terms of Office of Councillors and Aldermen elected in December 2019 to provide for elections in 2023 and to validate the actions of the said councillors and aldermen between the 2nd of December 2022 and the 18th of May 2023 be now read a second time." Senator Mark.
Thank you, Mr. President. Mr. President, I rise at this time to address a very dangerous piece of legislation that the government has brought to this House, having been exposed by the law lords of the Privy Council for their, or I should say, in their attempt, according to the law lords, and I shall refer to their judgment and ruling later on in my contribution. It was a clear attempt, and I will demonstrate, by this government to deny the electorate, the voters, from exercising their rights to elect their own representatives. And don't matter how they try to spin it, you could quote Terence Farrell, you could quote who you want. The reality is that the government attempted to deny the citizens of their rights to elect, Mr. President, their representatives. You know, I want to also quote a very famous statement by a famous writer known as Sir Walter Scott in 1808, when he told us, Mr. President, "Oh, what a tangled web we weave when first we practice to deceive. Mr. President, let us be clear. The origins of this bill that is before us cannot escape the clear intention of the government not to hold local government elections when those elections were due on the 3rd of December 2022. And I'll tell you why. We are dealing with 5 clauses, as the Attorney General has said. And what are the essence contained in this bill? There are essentially 5 areas that I would like to draw to your attention, Honorable President. The bill seeks to do the following things. All councillors and aldermen whose terms of office expired in December 2022 shall be deemed to have continued in office until the 18th of May 2023. The other area that the bill seeks to address is to validate the actions taken or decisions made by councillors and aldermen between the 2nd of December 2022 to the 18th of May 2023. The third purpose of these 5 clauses is to provide that the local government elections for the year 2023 shall be held no later than the 18th of August 2023. And Mr. President, it is extremely regrettable that when the alternative government represented by the UNC puts forward cogent, reasonable amendments to improve the quality of the legislation, to ensure that there is no untoward inadvertence, the government rejects it. So in the House of Representatives, an amendment was put, and I'm going to put it today, to delete Clause 5. The government rejected that in the other place. But we heard a short while ago from the Attorney General and Senator Vieira sort of clarified even further that he's going to amend Clause 5. And he went on to indicate the sections of Clause 5 that he's going to amend. Mr. President, it is the same amendment that was put by the leader of the opposition in the House of Representatives. And the minister, the Honorable Attorney General, found no favor. But he tells us a short while ago he has found favor. And he's going to now amend by deleting Section 5 or Clause 5, and that was clarified. So why would an Attorney General seek to undermine, and I use that advisedly, all right, let me withdraw it, undermine. But why would he, Mr. President, seek in a matter that the elected representatives of the people are seeking to hammer out provisions in the legislation to make it good law? Why would the Attorney General not support the amendments? Why? Mr. President, let me indicate why. This debate on local government reform started way back in 2019. It continued when the Parliament was dissolved in 2020 to facilitate the general elections of August the 7th. When it came back, Mr. President, it was referred to a joint select committee. We in the UNC proposed and we submitted a minority report because we did not agree with the majority report. Mr. President, a debate ensued subsequent to that. In 2019, when this matter was addressed in the other place before it was sent to a joint select committee, I want to give you the date. It was on the 26th of June, 2019. Hansard, page 182. The honorable leader of the opposition, with her discernment, given the repeated attempts by the PNM under Patrick Manning, may his soul rest in peace, postpone local elections not once, not twice, but 3 times. And because we were aware of the PNM pattern of conduct and behavior, the honorable leader of our opposition, leader of the next government in this country, put on the record of Hansard the following, Mr. President, and I want to quote, because, Mr. President, there is no doubt in my mind that the PNM sought to deceive the population on this matter of local government reform by extending the period from 3 years to 4 years without informing the members of the Houses of Parliament. The independent was not informed. The opposition was not informed. But later on, the local government minister would hold a press conference in November of last year to tell Trinidad and Tobago that the cabinet has taken a decision to extend the life of local government by 1 year. You know what the Privy Council said in response to that? And I'll quote for you in a short while. The Privy Council said in essence, Mr. President, that no cabinet no executive, no parliament have the power to elect their representatives. No cabinet, no parliament can substitute for the electorate in Trinidad and Tobago. None. And what the PNM attempted to do by surreptitiously postponing the local government election through the local government minister acting on behalf of the cabinet. Mr. President, let us make it very clear. It is not the Honorable Faris Alwari, the Minister of Local Government and Rural Development, that extended the life of local government from 3 years to 4 years. That was taken by the government when in the House of Representatives presenting this report, which contained that amendment from 3 to 4 years, Mr. President, at no time did the mover of that report, the Honorable Camille Robinson Regis, told the Parliament, we search, Mr. President, we scrutinize with a fine-tooth comb the contributions of all our colleagues in the House. We scrutinize the contributions of our colleagues in the Senate. And Mr. President, at no time did the government tell the senators, independent senators, opposition senators, and in the House of Representatives, same, that the purpose of changing this particular section or word from 3 to 4 years was aimed at postponing the local government elections for 1 year. Now, if that is not deception, tell me what is. Didn't the government not know that that was their objective? Because I'll tell you why it turned out to be their objective. And they misled us, hoodwinked us, mamagayed us, and they arrogated unto themselves the power to elect councillors. They arrogated unto themselves the power to elect aldermen. Democracy is on trial in Trinidad and Tobago. That is what we are dealing with here. And it is not Kamla Prasad Bisasa. It's not Ravi Maharaj. This is a victory for the people of Trinidad and Tobago. The people saved their democracy from a rogue government that was seeking to hijack and kidnap the people's rights in Trinidad and Tobago. I know Terence Farrell, no Dr. Terence Farrell, could erase that stain of the government's attempt to kidnap the rights of the people to elect their own representatives. Mr. President, let me quote for you. It was on the 26th of June, 2019, when the Honorable Leader of the Opposition, in speaking, made the following points. I would like Hear what she said, Mr. President. I will like us to insert in there. The drafters will help us, except that should not be prior to the expiry date of the present councillors. So in that way, we are very clear in law that it will not extend beyond the 3-year term. So I think that is something I think is very important. The leader was advising the government on June the 26th not to make the error by inserting this from 3 to 4 years, extend the term and have that extension applied to the incumbent. She goes on, the honorable leader that is, in any event, were you to do it that way, it is going to be chaotic. There is no new way. The very complex activity and administrative thing that have to be done can be done in time for that to take place. So that is my first point. And I make the point again. I think it is very important for us to ensure that we do not extend the life inadvertently of these councillors. That is what was said. I make the point that the delays have been. There is a poor track record in holding local government elections in this country. End of quote. So here it is, the leader of the opposition was telling the government back in 2019 on June the 26th, be careful with that amendment. You might inadvertently increase the period from 3 to 4 years and inadvertently extend the life of the incumbents, the current councillors and aldermen. Mr. President, so said, so done. So said, so done. And you know what is even more alarming? Is the Honorable Minister with responsibility. At that time, he was the Attorney General. And he responded to our leader at that time by saying, and I quote, as the Prime Minister says often, poppycock. Absolute nonsense. Because, Mr. Deputy Speaker, we have to be reminded that the Honorable Prime Minister said an election will be called when it is due, and they thumped their desks, Mr. President. Mr. President, what is the reality? The reality is that when the Honorable former Attorney General was unceremoniously kicked out, removed from office, and the other one, who is the current Attorney General, replaced him, what did we have? We have two things emerging that you, Honorable President, need to be aware of. The first thing that emerged was a Cabinet Note number 1935, dated the 2nd of November, 2022. Brought, and the headline is, or the heading, Proclamation of certain sections of the Miscellaneous Provisions Local Government Reform Act 2022. Who brought it? The Attorney General. Who is the Attorney General? The Honorable Reginald Amor, Senator, the Honorable Reginald Amor. He brought it to the Cabinet Mr. President, on the 2nd of November. And among other things, he said, and I quote, "In light of the foregoing, the Attorney General and Minister of Legal Affairs recommends that the Cabinet is asked to approve and agree the making of a partial proclamation by Her Excellency the President to proclaim Section 1, 2, 3B, 3C, Roman 1, 3C, Roman 3, 3C, Roman 4, 3D, Roman 3, and 3.4 of the Act to come into operation on the 8th of November 2022. The last line, Mr. President, Cabinet is asked to agree. So our Attorney General took a note, Mr. President, to proclaim only 3 clauses in the Act to give effect to the postponement of local elections by 1 year. Did not the Attorney General study this thing carefully? Is not the Attorney General in a position, after he spent $1.4 billion on 104 lawyers, 110 lawyers, the Honorable Attorney General could not bring senior counsel to advise him on this? So the entire Cabinet is guilty. And that is why the case was not brought against the Attorney General alone. The Prime Minister, who heads the Cabinet, approved this note and took away the rights of 1.1 million electors to elect their own representatives and put it in his hands and in the hands of the Cabinet. So when the Honorable Minister of Local and Rural Development held his press conference sometime on the 5th or the 7th of May, and he announced to the nation, Mr. President, that local government is extended, postponed, whatever language he used, by 1 year, the entire Cabinet was found guilty by the Privy Council for taking away the rights of the people of Trinidad and Tobago. So Terence Farrell could say whatever he wants to say. He cannot escape from the fact that he and the rest of them were party to a plot to deny the people of Trinidad and Tobago the right to elect their own representatives, Mr. President. That's a criminal act that this government committed against the people of Trinidad and Tobago. And don't come here and try to play footsie with the people's interests, Mr. President. This is serious business. And Mr. President, today I tell you and I tell the Honorable Senate that democracy in Trinidad and Tobago is on trial. The jury system that the government wants to abolish will make a decision very shortly.
So,
the same jurors.
Senator Mark, that road that you're going down is not relevant to what is in front of us right now.
I know, but it's just an analogy.
No,
you will allow me?
No.
Okay.
Because that particular
okay, I understand you.
road that you're going down is still being dealt with. So it's not relevant to what we have in front of us. I will ask you to come back to the bill.
Mr. President, I am guided by you. All I can tell you is that very shortly, the masses of people will deliver a guilty verdict on this criminal administration when they go to the polls. Mr. President, they could jump high they could jump low. They could wind left, they could wind right. They could do whatever they want. They cannot, Mr. President, get away from these words from the Privy Council, which will haunt them for life. This PNM is like dead people walking towards their political grave right now as we speak. Dead people walking to their political grave. That is what the PNM is today. Mr. President, if you wanted, and Terence Farrell, my good friend, Terence, what wrong with you? You're going mad? You're going crazy? I'm studying if I should continue my friendship. Mr. President, listen to this carefully. Mr. President, listen to this carefully. Hear what the Lord said about this government. This government has been found wanting. This government has been found guilty. This government sought to deny the rights of the people to elect their own representatives. And they could say whatever they want. The reality remains that the PNM under Rowley, the Honorable Prime Minister that is, attempted to hijack, kidnap the rights of the people.
Mr. President, on a point of order, please. 46-4.
Please allow the point of order to be raised.
46-4. He continues to be very offensive and insulting in his language. Please. Hijack and kidnap and...
So, Senator Mark?
Yes, ma'am.
In continuing your contribution, just temper the language a little bit as you continue on towards the end of your contribution.
Thank you, Mr. President. Mr. President, listen what they said in paragraph 33 of their judgment. And this is what will go on the campaign trail. This is what will be taken to the people in local government elections. And you could say what you will or want. Mr. President, listen carefully. Hear what our Lord said. I say thank God for the Privy Council. So long as the UNC is here, the Privy Council will remain here as our highest court. Without the Privy Council, we're dead in Trinidad and Tobago. Mr. President, listen to this. A democratic society will necessarily engage other rights like freedom of expression and association, for example. But the election, Mr. President, of representatives for a fixed or maximum period is the foundation on which it is built. And hear what the brilliant Lords sent us in paragraph 34. It goes on. It is inimical to a representative democracy that the representatives are chosen by anyone other than the electorate. Mr. President, it goes on. It is not for Parliament, not even us in the Parliament can substitute for the people. It is not for Parliament, still less the government, to choose the representatives. But if the amendments to Section 11 and 12 are construed to apply to the incumbent councillors and aldermen, the effect will be that they have been chosen as representatives for an additional year. Not, Mr. President, may I emphasize, not by the electorate, but by the government which brought the amendments into force, while those councillors and aldermen were still in office. Mr. President, you see this paragraph 34 tells it all. No government, no cabinet, no parliament, no executive can substitute for the rights of the people to elect their own representatives, Mr. President. So that is why when the government led by the Prime Minister and the gang that runs this country, called the cabinet, when they took the decision, Mr. President.
Senator Mark, there's a point of order.
Yes.
46-4, please. Constantly is being vitriolic.
So, Senator Mark, as you continue to wrap up once again, just temper the language.
Mr. President, I am suggesting to this honorable House that from the 3rd of December right up to today's date, Mr. President, I think today, is it the 1st, Mr. President? Today, the 31st? Today is the 31st? Mr. President, December, January, February, March, April, May. Mr. President, almost 6 months. The government took away the rights of the people to elect their own representatives, and that was given to the cabinet. And they use a simple majority in the parliament, which they have, in order to pass the legislation. So for 6 months, Mr. President, the cabinet headed by the Honorable Dr. Keith Christopher Rowley appointed these councillors and aldermen for 6 months.
Senator, you have 5 more minutes.
That is what, thank you, Mr. President, that is what this is about. And the government stark naked at the level of the Privy Council comes to this parliament and trying to use what? Majority judgment in the Court of Appeal. 2 minority in the Privy Council. So 5 is more than 3. So 5 win. That is the kind of argument we getting from the Attorney General. The arithmetic. But the last time I checked, Mr. President, the Privy Council is the highest court in this land. And for me, 3 is more than 8. You want to play numbers? The majority won. 3 of them. And that is why we're in Parliament today. We are in Parliament today because 3 voted in favor of saving our democracy in TNT. That is why we're here today. So, Mr. President, I know that this is a very serious matter. And I'm very passionate about it. You know why? I'm a Democrat. And anybody who is attempting to undermine our democracy, they have to face me and the UNC. You're facing us. We like a bulldozer. You can't pass. So understand that. So, Mr. President, I want to make it very clear. We are proposing an amendment, and our amendment is to delete completely Clause 5 of this bill. We proposed it downstairs, they rejected it. We are proposing it upstairs, rejected again. So, Mr. President, it is very clear to us. We have a dictatorship in the making in Trinidad and Tobago. And, Mr. President, in closing, let me just indicate to you and Trinidad and Tobago. Don't ever come to the conclusion that democracy has been saved only because of Ravi Maharaj Balgobin, or Anand Ram Logan, or Jayanti Lakshmi Diyal, or the people the lawyers who defended us in that place called London. Mr. President, they were just the channel. They were just the tribune. They were fighting for the people of Trinidad and Tobago. So when we called for international observers, is not Kamla calling for it? Is not Ravi Maharaj calling for it? It is a judgment issued by the Privy Council that this government sought to hijack, kidnap, undermine, subvert the democracy of our country. And because of that, the judgment is telling us we cannot trust the government. And we have to have international observers to make sure the PNM does not rig, does not thief the elections. That's what it's about. So, Mr. President, what are you afraid about? So we are demanding international observers. Mr. President, I know my time is out, but I want to close by telling the people of Trinidad and Tobago, time is longer than twine. It's only a matter of time. I believe, Mr. President, in my heart, I tasting it, I feeling it. The people are ready for change, and change is coming. We started off with local elections, and as soon as that is over, general election, and the political cemetery is the future of the PNM. I thank you, Mr. President.
So, as much as you may want to support the speaker on your bench, there's an established way to do so by thumping the desk. There's no need to shout and raise your voices. Senator Vera.
Thank you, Mr. President. This is a relatively short piece of legislation, and I hope not to be too long. Essentially, as we have heard from the Honorable Attorney General, it has basically three purposes: to preserve or save the appointments of councillors and aldermen whose term of office had been held by the Privy Council to have expired on the 2nd of December last year, to provide for elections, and to preserve or save all work established, granted, or done by the councillors and aldermen while they were technically out of office since the 2nd of December last year. In other words, this legislation is a necessary corollary of the judgment of the Privy Council given on the 18th of May 2023, namely the case of Ravi Balgobin Maharaj against the Cabinet of the Republic of Trinidad and Tobago. That judgment and this legislation are inextricably linked. Indeed, the raison d'etre of this bill is that judgment. Now, much has been said in Parliament and in the public space regarding the meaning, scope, and effect of that Privy Council decision. And I will also share my reflections on the matter for what they're worth. insofar as they impact the legislation before us. However, before getting to that, I should just like to make a few general observations. First, and I say this with all due respect and deference to the Privy Council, which is our final court of appeal, and to the judiciary in general, this case offers a good example of the adage that trials are a lottery, meaning that the outcome of a trial or legal proceeding is unpredictable and no guarantees can ever be given. It recognizes that the results of a trial may not necessarily reflect the true merits of the case, but may have been influenced by unpredictable factors, such as a witness not coming up to scratch, or one getting a judge who just doesn't see things your way. In this case, experienced draftsmen, multiple lawyers for the state, the lower court, our Court of Appeal, and two senior law lords saw the issues one way, but a majority of 3 judges in the Privy Council saw things differently. Now, I agree. In the final analysis, the majority view holds sway. There is no getting away from that. Under the rule of law to which we subscribe, the country must abide with their decision. However, one can't help but wonder, had a different panel been drawn, whether the judgment might have been different. In particular, one can't help but wonder whether the presence of 2 Scottish judges in the majority, namely Lord Reid and Lord Hodge, had a discernible effect on the outcome of the case. Now, I say this because when you look at paragraphs 30 to 34 and 40 to 42 of the judgment, they strike me as gratuitous. And I'm talking now about the paragraphs highlighting the essential characteristics of a representative democracy and the individual rights enjoyed by each person entitled to vote. They strike me that apex court, which is the Privy Council, which comprises senior law lords of the UK Supreme Court, was sending a signal to the UK Westminster Parliament, which right now is embroiled in heated debate on the Scottish independence referendum. Heated disagreement over purpose and effect of referendum legislation, and whether a referendum is within the powers of the Scots as a people, or whether such powers are reserved solely to the UK Westminster Parliament. Now, my take on these paragraphs is that the UK Supreme Court, the Privy Council, was firing a shot across the bow of the UK Westminster Parliament. While I don't disagree with the message or the legal learning involved in those paragraphs, it seems to me that those paragraphs are aimed at a wider target than just Trinidad and the miscellaneous provisions Local Government Reform Act 2022. Indeed, one wonders if these paragraphs are foreshadowing leanings or concerns of the UK Supreme Court in the event it is called upon to adjudicate on the Scotland Act 1998 and renewed calls for Scottish independence in the wake of Brexit. Consider, for example, the wide ambit of the following dicta at paragraph 42. The fact that the democratic process and the voting rights of individuals in that process are derived solely from statute does not diminish their fundamental importance. Agreed. At paragraph 31, the essential characteristic of a representative democracy, whether at a national or local level, is that the representatives are chosen by popular vote. All individuals having the right to participate in the popular vote, subject only to specified conditions and disqualifications. I agree. At paragraph 32, the rights conferred by a democratic system of government are not only individual rights enjoyed by each person entitled to vote, it is also the right of all members of the relevant community to be governed by representatives chosen democratically, whether or not individually they're entitled to vote or have exercised that right. I agree. And at paragraph 34, cited by Senator Mark earlier, it is inimical to a representative democracy that representatives are chosen by anyone other than the electorate. It is not for Parliament, still less the government, to choose the representatives. Now, my conjecture may be unfounded, but whether one agrees with me or not, it cannot be disputed that the dicta I have just cited represents a warning, not just to this Parliament, but to all parliaments in the Commonwealth, not to play fast and loose with voting rights and democratic processes, and not to make decisions pertaining to representation on behalf of citizens. Whether such dicta were even necessary in this case, given the circumstances, I leave as an open question. Given the court's findings that the miscellaneous provisions Local Government Reform Act did not breach the Constitution. I think this is very important to take on board. The court found that the legislation did not breach the Constitution. And I'm going to quote. Paragraph 16. The board, which is the Privy Council, the board can deal briefly with the appellant, which is Mr. Maraj, the appellant's submission based on the Constitution, which must, in our view, fail. Paragraph 35. Given that the application of the amendments to incumbent councillors and aldermen would not alter rights guaranteed by the Constitution, it is clear that it is within the legislative competence of Parliament to make the amendments if that were their effect. This is a majority speaking. It is clear that it is within the legislative competence of Parliament to make the amendments if that were their effect. Paragraph 53. Nothing in the Constitution of Trinidad and Tobago prevents Parliament altering the term of office of elected local government office holders from that in force at the time of their election, whether by extension or abridgment, or prevents Parliament from thereby altering the periodicity of local government elections. Claire, nothing in the Constitution prevents Parliament from doing what it purported to do with that legislation. Indeed, the major commotion, insofar as the majority were concerned, had to do with statutory interpretation and what they considered legislative drafting best practice. So in the event, it's not that there was a breach of the Constitution or that this Parliament couldn't pass legislation extending the period of office for councillors and aldermen. What troubled the majority of the court was whether the extension of 4 years applied to the incumbents, because if it did, then in the view of the majority, that was not sufficiently made clear in the legislation. So, in the view of the majority, the legislative language needed to be clearer. That is to say, they wanted to see express provision in the miscellaneous provisions Local Government Reform Act 2022 that the term of office for the incumbents shall be deemed to continue for the additional period. So far as the majority was concerned, if that was the legislative intention, it could not be implied or inferred. Now, as stated at paragraph 55, subject to the need for clarity, this is a question of statutory interpretation to be resolved on the usual objective basis. That is, divining the meaning of the language used by appropriate reference to its context and purpose. And That is consistent with the famous dictum of Lord Reid. This Lord Reid is R-E-I-D, not R-E-E-D, who is one of the Scottish judges in the recent Privy Council decision. But Lord R-E-I-D in Black Clawson International Limited and Papier Work, a 1975 decision. And he said, we often say that we are looking for the intention of Parliament. But that is not quite accurate. We are seeking the meaning of the words which Parliament used. We are seeking not what Parliament meant, but the true meaning of what they said. In other words, the search is for the objectively manifested meaning, not for somebody's unexpressed state of mind. So, accordingly, on the basis of this apparent lack of clarity as to whether the changes were to apply to incumbent councillors and aldermen, and what seemed to be a lack of transitional provisions, 3 out of 5 judges, as a matter of statutory construction, and bear this, they're going down statutory interpretation, but at the same time recognizing at paragraph 7 that the municipal corporations are tasked with a wide range of duties, many of which are essential to the proper functioning of their areas. So they recognize the importance of the municipal corporations and for them to be kept alive. But we're dealing with this bit of statutory interpretation. And 3 out of 5 judges take the view that the amendments were not intended to apply to the incumbent councillors and aldermen. And that's the nub of the decision. They look at it and they say, well, you know what? When we look at all of this and it's not expressly worded, we don't think that this legislation actually applied to the incumbents. And 3 out of 5 judges took the view that if Parliament had intended to give government such a power, it is reasonable to expect it would have done so expressly. Now, my personal view is that this seems a case of legalistic hair-splitting. In any event, I agree with Lord Briggs's dissenting opinion, with whom Lord Kitchen also agreed. And this is what they said. The plain purpose of the legislation was to extend the term of office of councillors and aldermen for 3 to 4 years. That was the plain purpose of the legislation. However, that is now water all under the bridge. The reason we are here today is not to rectify an egregious attempt on the part of government to breach constitutional rights. It's not to rectify an attempt to kidnap the rights of the people to elect their own representatives as alleged. The reason we are here today is to correct what has been held by the Privy Council to be a drafting error. In effect, an error of omission. As the bill declares, this is a validation act. It validates the extension of terms of office for councillors and aldermen in our municipal corporations to cover the period when their terms were held to have ended on the 2nd of December 2022 and the judgment of the Privy Council given on 18 May 2023, and to cover the period between the date of that judgment and commencement of this legislation. This bill also addresses the lack of transitional provisions bemoaned by the majority, in that provision is now made at clause 5 that all work done by the incumbent councillors and aldermen during the period under contention shall be deemed valid and effectual. In other words, and I have to agree with the Honourable Attorney General, in addition to the de facto officer doctrine he obliquely referred to, or the evidential maxim, omnia praesemuntur rite et solemniter esse acta, which posits that all acts of an official nature are presumed to have been done rightly and regularly, and persons acting in a public capacity who were duly appointed and authorized to act are presumed to have acted lawfully until the contrary is shown. In addition to these relevant doctrines and maxims, out of an abundance of caution, this bill expressly preserves or saves the work done by the councillors and aldermen through transitory provisions at Clause 5. In other words, this legislation will protect things properly done during the interim period. Mr. President, this is not dangerous legislation. It serves a useful purpose. It is necessary, and it is proportionate. I don't see how we cannot support it. The bill provides the clear intention of Parliament called for by the Privy Council. And as to whether the Privy Council's judgment is a victory for democracy or an expensive lesson on best practice for legislative drafting when transitioning from one statutory regime to another, I am inclined to believe it's more a case of the latter. Mr. President, I thank you.
Minister of Local Government and Rural Development.
Thank you, Mr. President. I believe it's the first time I'm addressing you as Mr. President. May I take this opportunity to do so with great compliment to that chair, Mr. President. Mr. President, may I ask how long speaking time is in the Senate?
40 minutes.
40 minutes?
Yes.
Thank you, sir. Mr. President, I rise to join in contribution to this debate to underwrite the views of my colleague, the Honourable Attorney General, and to also join with Senator Vera, who had, not unusually, much of the same content of reflection that I wish to put onto the record. Mr. President, the bill before us is a validation bill to become a validation act. And validation acts are not uncommon in the Republic of Trinidad and Tobago. Indeed, I have, in my own tenure in this Parliament, contributed to validation acts. In this Senate, certainly in relation to the Tobago elections, etc., we did so. Validation acts are standalone pieces of law. So, honourable members will notice that we're not dealing with amendments to the Municipal Corporations Act. We're dealing with a validation act. Why are we required to deal with a validation act? The crux of the validation is to be found in Section 5 of what will become the Act, Clause 5 of this bill. The Honourable Senator Mark made the submission that they wish to delete all of Section 5, Clause 5. I dare say that honourable members should just be conscious that that is the gravamen of what we are required to do. It is in Clause 5. Clause 5, quite simply, seeks to make normal what was legitimately in progress. What do I mean? There was a decision of the High Court, which was upheld by the Court of Appeal, and the Court of Appeal said that the effect of making councillors 4 years in their term was lawful, and that therefore councillors and aldermen could proceed for 4 years. That 4-year period would have ended in December 2023, specifically December 1st. The Privy Council, by its majority decision, has held in a split, but nonetheless by way of a decision which is binding upon us, that implementing a 4-year term is not to be viewed as applying to incumbent councillors and aldermen. In other words then, they interpreted the law to say those who came in as 3-year people, those aldermen who were appointed as 3-year people, they will continue as 3-year people and will not be converted into 4-year people because, in their view, express language had to be used to bite them. This was not an easy decision, nor was it one in respect of which there was unanimity of advice or reasoning. And I want to take you immediately, therefore, to the judgment of the Privy Council. This is the case of Ravi Balgobin Maharaj versus the Cabinet. And I would like to point out to honourable ministers, to honourable members, what starts off in the dicta of the minority judgment. And that is, with your leave, Mr. President, if I take you to paragraph 59. Paragraph 59, subclause 6 says this, and I want to say this in answer to the Honourable Senator Mark. I quote, "There is no basis for reading the MCA, the Municipal Corporations Act, as a whole as a hostile environment for the extension of the terms of office of elected local government officers beyond that in force when they were elected. On the contrary, Parliament has done so by amendments of this very Act on numerous occasions during the life of to date." So the Privy Council, in its own dicta, which according to Senator Mark shall haunt Trinidad and Tobago forever, the dicta of the Privy Council says that this is not the first time that life extension for councillors and aldermen is being engaged. If you look to Section 11 of the Municipal Corporations Act, Section 11(1) says how you are to come into office. It says that the life of the persons as councillors shall be 3 years. It says that the life of the council shall be for 3 years and shall expire 3 years after they were elected, and that an election shall be held within 90 days after the expiry. Section 12 deals with aldermen. But if you look to Section 11, you will see the history of extensions of lives of councils by aldermen and councillors. If you look to Section 273 of the Municipal Corporations Act, you will also see that there have been interim or transition sections inserted into the law to treat with life of councils. Now, what does the Privy Council decision tell us? The Privy Council decision tells us, as Senator Vera so capably and ably put onto the record, that the majority of the Privy Council and the minority of the Privy Council both agreed with the Court of Appeal and the High Court of Trinidad and Tobago to say that there is no breach of any constitutional right by the amendments which were proclaimed. No breach. What they say, the majority, is that we are to accept that Parliament's intention was not to extend the life of incumbents. They say that express language should be done. It was not a decision which everybody agreed with, but it is the majority decision. So what this law represents for us, as Senator Vera so capably put, is a corollary step that we must take following the judgment. But I'd like to submit that really and truly there is a fourth purpose that we must have our eyes on. You see, the bill, by validating the occupation of office in the period December 1st to May 18th, 2023, December 1st, 2022 to May 18th, it does that. That's number one. Because those people weren't there just because they decided to stay there. They were there because the Court of Appeal said they should stay there. And so did the High Court. And so did the minority. So that's one. Two, by extending the life to May 18th, we automatically kick in the fact that Section 11 will now trigger an election because we know the date for the expiry of their term ended when the authorization of the Court of Appeal ended. The Court of Appeal's judgment was reversed by the delivery publicly of the Privy Council judgment on May 18th. So their term of office expired. All councillors, all aldermen expired except a mayor pursuant to Section 15 of the Municipal Corporations Act, whose term of office continues until a new mayor is elected. And so too, arguably, a deputy mayor, because a deputy mayor acts in office as long as a mayor is not there. If the mayor is on vacation or the mayor is ill, the deputy mayor can come in. So only two office holders continue in office, arguably, certainly the mayor, the deputy mayor in default, after the expiry of the life of the council. So the second purpose of this law is to trigger an election. We now know, and the Honourable Prime Minister has confirmed it, that an election must be held within 90 days from the expiry of the term of office. The expiry of the term of office, the Privy Council, it delivered it on May 18th. 3 months 90 days from May 18th in accordance with the Representation of the People's Act and the Municipal Corporations Act, Section 11(4), says, 4A, says you must have an election. That's reason number 2. Reason number 3, which both the Attorney General and the Honourable Senator Vera put on the record, is again as innocuous as it can be. So extending the life to May 18th, validating their actions up until May 18th, and I'll come to that in a little bit more expansion, and triggering an election. But the 4th reason, which the minority judgment in the Privy Council accepted, was that this law must be viewed in context. And when you get to Lord Briggs and Lord Kitchen, they did not fail to see that we were talking about permanent changes to the Municipal Corporations Act in the context of reform. And in the context of reform, that is the deciding factor. On November 3rd, 2022, when I was authorized by the Cabinet to inform that the Cabinet had decided to turn on the 4-year provision, it was in the context of reform. What does this judgment do for us? And why are we grateful for this judgment? Paragraph 13 of the majority judgment says this: the 2022 Act contains no provisions as to whether these changes are to apply to incumbent councillors and aldermen. There are, for example, no transitional provisions. That's true. But in the context of what the government wants, which is substantive, significant reform, by putting in new sections 33 onward in the Municipal Corporations Act, we are asking for permanent reform to apply now. And we came to the population in November and said, the Cabinet said, we want reform. We're going to take 12 months extra to put on the provisions of reform. And we were met by a very important argument. The opposition, through its political leaders, said, you are wrong. Call the election now because you can turn on the reforms afterwards. That, for me, is the 4th reason that is most important above all. The issue here is not the grateful clarification of the law. Indeed, it could have gone in one of 2 ways. You could have taken the point of view as a lawyer, let's go and amend the Act the way it was done in 2003, 2005, 2007. Let's amend the Act. Let's amend Section 11. Let's amend Section 12. Let's insert transitions in Section 273. But those were transitional. Lord Briggs got it right. We have permanent reforms to put into effect. And so the Cabinet, in seeking 12 months to put on reform, we were met by a very strong argument coming from the opposition to say, no, have that law after you install the new people. But here's what the rest of the majority judgment says. The rest of the majority judgment goes on, and in particular for honourable members who have it, I'd like to refer you to paragraphs 13, 19, 20, 23, 27, 28, 29, 34, 35, 36, 37, 41, 45, 47, 49. Senator Mark quoted from paragraph 34, a standalone paragraph. Paragraph 34 follows from the Privy Council's majority saying, look, there's no breach of constitutional rights. It goes on to say that the secondary argument, because the primary argument of the UNC was, you're breaching the Constitution. That was rejected. The secondary argument was that the law does not apply to incumbents. But listen to what paragraph 35 says. Paragraph 35 of the judgment says, specifically, and with your leave, if I may quote from it, Mr. President, if my pages will allow me to get there. Given that the application of the amendments to incumbent councillors and aldermen would not alter rights guaranteed by the Constitution, it is clear that it is within the legislative competence of Parliament to make the amendments if that were their effect. The issue is whether, having regard to the context, sections 11 and 12, as amended by the 2022 Act, are to be construed as having that effect. Paragraph 37. The appellant submits that on a matter of such importance as the democratic basis on which incumbent councillors and aldermen have been elected, Parliament must make its intention clear. But when we get to the position saying, repeated again in 41, that Parliament must make its intention clear, when you get, Mr. Deputy Speaker, to the rest of the judgment, it says that you must ensure that the amendments which you want to put on clearly are viewed to apply to incumbents. Now, you can't have your cake and eat it in this case, because the argument of the UNC, which found favour in the majority decision, was that, look, these reforms don't have a transitional provision, and they will not apply to incumbents. If you take that judgment exactly as it is, and you had an election tomorrow morning, and you did not turn on full-time councils, municipal councils, standing committees, the property tax to allow hundreds of millions of dollars to come to local government, by this judgment, it will not apply to the councillors and aldermen and corporations comprised tomorrow morning if an election was had. You will have to wait 4 years for it to take effect. And that is not the intention of this government. The intention of this government is to deliver local government reform. And what is therefore a further corollary step beyond validation, beyond establishing the date for the time frame of the election, etc., the fourth point that I mentioned is getting reform right. So the corollary will have to be that we make an amendment or consider an amendment which will say that the reforms apply to councils to be installed or whomever is in office when the reforms are turned on. And the big point for the government, therefore, is getting reform right. Now, what are the acts of importance for us there? Let's deal with the fact that not only has the Privy Council in majority and minority reflected on the fact that extensions of lives of councils are not a thing that has never been seen in Trinidad and Tobago before. Permit me to put on the record that we have had 1968, we had the first local government election. 1971, we had the second local government election. There was a postponement in 1974 to 1977 because of the Black Power Revolution, as it was called. We had local government elections in 1980 and 1983. They were postponed in 1986 to 1987. They were postponed in 1990 to 1992. Why? In the context not only of the attempted coup in 1990, but because there was a significant change in the law. They were reforming the Municipal Corporations Act, and the new act, the 1990 Act, which is the act that governs us now, that came on in 1990. And who was in power in 1990? It was the NAR at that point, which the Honourable Member for Siparia sat in, which many members of the UNC sat in. So in the context of reform, in 1990, it was okay to extend the life of a council, to postpone local government elections for the bona fide purpose of reform. And the 1990 Municipal Corporations Act was deep in its reform. So too are the amendments to the Municipal Corporations Act, Property Tax Act, and 6 other laws in the 2022 Municipal Corporations and other Miscellaneous Provisions Act. These are deep reforms. Let me put it into context. In the 2022 reform package, we are delivering an amendment to the Property Tax Act. We are saying, insert a new 9A in the Property Tax Act, amend Section 10 of the Property Tax Act by Section 10 of the Reform Act. You know what that will result in? For Tunapuna Piako Regional Corporation, $67 million extra per year going to the corporation on residential taxes alone. You know what $67 million is equal to? Nearly 80% of the money that they get from the budget. So imagine getting 80% more money in that corporation, what councillors can do. What does reform ask for? It asks for mayors to control CEOs. It asks for corporations to hire, fire, and discipline their own workers. We are talking about constitutional reform for decades and decades. That law, by amending the manner in which you can discipline your own workers and hire your own workers, is as close to constitutional reform as you will get without a 3/4 or 2/3 majority change. You understand the depth of reform that we're speaking about? Where 141 councillors sitting closest to people, walking amongst people, can make decisions to spend money for the people from monies earned closest to them. These are not simple reforms that we are turning on. And therefore, there is a proportionality satisfaction that we have delivered by saying reasonably since November 2022, since July 2022, since April 2022, when we said we want to deliver reform. Are we guessing what the reform is? No. We know it in black and white as the Municipal Corporations Amendments contained in the Miscellaneous Provisions Local Government Reform Package 2022. We know it in black and white. They are reasonable. They are deep in structure. They are far-reaching. They inure for the benefit of people. They satisfy the conditions of proportionality because the legitimate aim is solid. They don't go much further than they need to go, and they are rationally connected with the purpose of the law. Those are the three basic grounds of proportionality and reasonableness to justify simple majority passage of laws. You remember, honorable senators, there was a time, we will get you, we will overturn your laws, you only know about Surat, you can't talk about nothing, all your simple majority laws will fall. Where are they now? Senator Lakshmi Dayal used to be leading that charge up and down Trinidad and Tobago. Faris, all your laws go fall. Until Suraj came along. Until Suraj came along and upheld the Surat principles and upheld, quite importantly to honorable members of this Senate, all the laws that we passed on a simple majority basis. All. Now, does this give the UNC much pleasure? No. Are they entitled to exercise the democratic principles of objecting? Yes. Can they reinvent their words? Well, surely they can. They can put a spin on it all they wish. But the deeper reform that we're looking at here is that this was a statutory interpretation claim. And I think, Senator Vera, if you read through you, Mr. President, if you read into what geopolitics looks like, and you look at the Scottish referenda in many different senses, and you look to the social fabric construction that the Privy Council is engaged in, I too share the view that you have espoused, that the minority decision was correct, and that this may be in preparation as a shot across the bow for other issues. But c'est la vie, as the Honourable Attorney General so capably put, this is not the first time that we're going to deal with law evolving. And let me give a real example as to why this bill is good. When we look to the fact that there was a time when we challenged the appointment of a commissioner of police, an acting commissioner of police, there was a statutory interpretation on a legal notice. That legal notice turned out to be 100% correct, according to the judge. Here, Jayanti, here, Senator Lakshmi Dayal, you're lost. Go back and read now. The fact is that the court upheld the thing which was challenged. What the court struck down was another legal notice. Legal Notice 103 of 2009, which said, all of those acting appointments that you made for commissioners of police who were going out of the jurisdiction and somebody acted for 2 days and 3 days, all of them needed to come to Parliament. The leader of the opposition acted on that hundreds of times. The law came along, it was changed, it was interpreted, there was a new reflection. If you look at Chandler upholding Matthews, but Matthews itself represented a reversal of the Privy Council on the death penalty matters, Matthews came along and reaffirmed that the death penalty in Trinidad and Tobago was lawful. So the law is a living, breathing thing. Section 54 of the Constitution, Section 53 of the Constitution, the enshrined rights, if you look at what we're treating with, this government has to make do with what it has. It only has a simple majority. It cannot rely on the UNC for an ounce of support on anything that is deep in structured reform. We would like to give more. We would love to put local government in the Constitution, but that will require 3/5, 3/4, and 2/3 majority, because we'll be affecting some rights that are enshrined in Section 54. And yet these are the same people that stand up and say, well, why you didn't put local government in the Constitution? Because you, the UNC, would not agree to a single amendment that requires constitutional majority. And therefore, Mr. Deputy Speaker, Mr. President, and therefore, Mr. President, what is shocking is the revisionism, the make it up as you go, the allegations put by Senator Mark, a shrill point, but I have to tell you, I enjoyed seeing Senator Mark in full flight again. I missed hearing his contributions personally. When you listen to Senator Mark say, democracy is gone, and it will haunt you forever. Well, I want the whole judgment to haunt me, not part of the judgment you choose to read. The whole judgment says there's a difference of views. When you start off, as Lord Briggs does, to say he's not pleased to disagree with the majority, but he must. And worse yet, when Lord Briggs goes on to say that, in effect, you're constructing an argument or a principle in a vacuum. As the judge said, those are not light words. But honorable senators, what I'm putting on the record now is that the most important objective is local government reform. That's the job that I was given. It's why I'm standing here today in support of this legislation, because the reform is the context in which the validation comes. It's the context in which the proclamation of the quadrennial period came about. It's the context as to whether it applies to incumbent councillors or not, because unless we take a hold of the corollary steps to be engaged in after this judgment, well, then we're not going to deliver what we promised and what we have a mandate to do, which is to deliver local government reform. Mr. Vice President, forgive me. Mr. President, forgive me. Mr. President, what are some of the things that we wish to validate? So for those people who are paying attention through you, Mr. President, the life of the council came to an end on 18th May 2023. As I've said before, Section 15(2) of the Municipal Corporations Act keeps the mayor alive until a new mayor is sworn in. The deputy mayor is kept alive pursuant to Section 21 of the Municipal Corporations Act. But what are the things that we need to validate? Why do we need to validate? Well, first of all, we're validating for all. There are 139 representatives. That number was changed to 141 by the EBC. There are 139 people elected in 2019. We had a few by-elections. A number of people in local government moved into central government. The Honourable Simon de Nobrega, the Honourable Vandana Mohit, the Honourable Kennedy Richards, the Honourable, Lisa Morris Julian, the Honourable Roger Munro. There are several people that moved into the House of Representatives. We had 5 by-elections. We had 1 alderman who came in, and we had another by-election in 2022 in Debe South, where there was a death, and we had to have a by-election. So that's why we say more than just the people elected in 2019. We have to cater for those other persons who came in 2021, and that 1 person who came in 2022. But when we look at this, the acts of the council, there are certain sections in the Municipal Corporations Act that only a council can resolve or treat with. We have Section 10(1), the power of the corporation shall be exercised through the council, its chief officers and staff. And chief officers are the aldermen, mayors, deputy mayors, etc. Section 45(1), council to fix establishment and appoint, discipline, suspend and dismiss employees. Section 46, council to consult with majority unions. Section 57(1), council to dispose of personal property used in commission of an offence. 66, 117, 137, 151, council to make rules, standing orders, regulations, bylaws, issue licenses. Very importantly, section 108, council to submit estimates of expenditure in accordance with the call for circular. 110, council to approve payments into and out of the mayor's fund. 112, council to approve unspent balances. 118, council to approve vouchers for payment of monies. 120, council to approve virements for approval of the minister. And it goes on. Section 130, 131, 132, 136, 138, 142, 162, 63, 172, 175 to 178. Council to show and issue cause-stop notices before magistrates. 163 and 168, council to approve building plans pursuant to enforcement. 189, 191, etc. These are the acts that we need to validate. Virements were used, monies were spent in the disaster relief that we managed in November when we had significant rainfall and damage. We complied with call for circular. We needed to make sure that the estimates that came in, local government has received the largest distribution of monies ever in its history under the office that I hold right now in the year that I have held it. Adding property tax to hundreds of millions of dollars means that we bring money inside. But honorable members, there is nothing wrong with validating the acts that I've just described. They're grounded in the Municipal Corporations Act. There's nothing wrong in saying how the trigger for an election will now happen. 3 months after the expiry, which was May 18th. Clarity of purpose. There is nothing wrong in saying that we should pay our councillors their salaries, their emoluments, their perquisites for the time that they were in office, lest there is challenge. We're protecting 139 people across 14 corporations, and interestingly, they are split 7-7. 7 to the UNC, 7 to the PNM. But if you accept Senator Mark's submissions today, none of them to get protection, not even the UNC councillors. I don't know if this is retaliation and retribution for so many people that are crossing the floor to the PNM. I don't know if that is what occupies Senator Mark's concern. Perhaps it is. Because I saw in the newspapers somebody attributed as saying, Kamala, go fix you. Is this the way that they're going to fix you? By saying you cannot have validation for your salaries and your terms and your perquisites? Perhaps. It's not the way the PNM would behave. But you must take them at their words, put on the record. Mr. President, may I ask what time is full time?
4:06.
Thank you, sir. Mr. President, when we look at the position of extension, I want to remind that on several occasions when the life of councils were extended, both prior to expiry of terms and after the expiry of their terms, there was the use of something called an advisory council. If you look to the Municipal Corporations Act, you'll see the use of advisory councils. I want you to note, Mr. President, that we are not in any form or fashion extending the life of councils beyond the date of their expiry, and we are not using advisory councils. And therefore, to say that there is some form of subterfuge to continue people on into office, that's not the case. We could have, as historically you will see, used advisory councils, used both by the UNC, the NAR, and the PNM in the past. We did not. What we are on about, Mr. President, is reform. Are there further corollary steps to be taken? Yes, there will be. Are we, no doubt, engaged in the process of considering all of these things? Yes, we are. Will the Honourable Attorney General bring advice to the Cabinet? Yes. Are we a Cabinet of collective responsibility? Yes, we are. Are there divergent views sometimes on how the law ought to be applied? Yes, there is. Are we safeguarded and protected? Yes, because of the separation of powers and the fact that the court will construe the law. Do we accept the decision of the Privy Council? Yes, we do. Do we accept it for what its real warning is? The real warning is make sure any future implementation you bring out of the reform package is expressly stated to apply to incumbents. Had we listened to the UNC, call the election, install people, and then turn on the law, they say, nah, hard luck. You missed the boat. Come back 4 years later, and then the Privy Council might, if its quorum was the same, have decided that it didn't apply to incumbents. And then where would we be? In happiness land for the UNC, because all the reforms that we talked about couldn't be delivered. That's what the real focus of attack is by the opposition. The focus of the attack of the opposition is to deny the implementation of local government reform. Is this law with precedent? Yes, it is. This bill has precedent. Is this proportionate, rational, reasonable? Yes, it is. Does it satisfy Surat and Suraj principles? Yes, it does. Mr. President, I don't think that there's much more for me to say, and therefore I thank you for this opportunity to address this august Senate and for allowing me the opportunity to make this presentation. Thank you.
Senator Lakshmi Dayal.
Thank you, Mr. President, for recognizing me to join in this debate. I must say that I'm astounded and confused and appalled. I wasn't so confused that I thought I could retrospectively apply laws and put people back in office for a period extended of which they, an extension and longer than they were elected for. But I'm confused by a minister of local government who could stand here and try to rewrite history about the numerous failures of this government, which we in the UNC have had to take to the court in order to get it fixed and to get it right. This minister, I know about the expression, take shame out of your face, but they take it to new heights. New heights, when they will stand here today and stoop so low as to dissect the composition of the highest court in our land. Exactly. And criticize and draw inferences about people's background to try to say that that had something to do with the judgment of the Privy Council. Let me tell you something. It doesn't matter if you're Scottish, Irish, Welsh, German, or French. You get licks in the Privy Council. You get licks. And we are here today on the heels of that licks that we put on them in the Privy Council, whether it was 3-2-4-1, it does not matter. Licks is licks.
Yeah. We don't go in the away goals. Let the Euro Cup.
We have Duckworth Lewis system in cricket, and now apparently we have Amor Al-Rawi system in terms of judgments, where we check in judges and working out a mathematical formula to see if we were very wrong or just a little bit wrong. You're wrong. Yeah. You're wrong.
Yeah, we're wrong.
And instead of coming to the population and saying, we were wrong, we got it wrong, we imposed upon you representation for a period of 6 months in contravention of the law. They're counting numbers and coming up with a formula to say, well, we wasn't really so wrong, you know. We wasn't so wrong. So that's okay. And coming here to talk about reform. Well, we will get to that just now on their track record of local government and their track record of reform. They came today to show contempt for the Privy Council. They came here today to show contempt for the citizens of this country, as they have always done, and particularly the track record of the PNM is one of contempt for local government and the right of the people to choose their representatives. They have come here today to say things that they directly contradicted when some of them gave evidence to the court on affidavit, sworn evidence on affidavit. Contradicting what they said, and I will take my time and go through all that was said in the course of that matter, because I had the painful experience of having to read it and wondering about the gall of some people who will misrepresent the law. It's one thing to stand in the parliament and misrepresent. That's politics. But it's another thing for people who call themselves attorneys and members of the bar to misrepresent the state of affairs to a court of law, and that is what was done in this case. So we are here today, yes, to validate, and I do not know where, somewhere in listening, that the Minister of Local Government got the fact that we were opposing the payment of salaries to councillors. Every single councillor and alderman in this country, PNM or UNC, is a victim, an innocent bystander of PNM incompetence. They are all concerned, they are worried. On the 18th of May, they were wondering, what should we do? And it took them 1 week. Because as I said before, they were left discombobulated. They did not know what to do with themselves. And while they sit down, check and judge from different levels of the judiciary, trying to come up with excuses, for a whole week, councillors and aldermen were left not knowing what to do. What was their status? Do we go to work? Nobody knew. The Minister of Local Government was hiding. I thought they put him in detention. All over the place, they're looking for him. We couldn't see him for a whole week. It is only when a cabinet note showing the population that it was the Attorney General who took the note to cabinet to speak about the proclamation somehow miraculously ended up in the public domain, that the Minister of Local Government resurfaced. I don't know about them and their domestic problems and what is going on inside of there, Mr. President, but I found it very strange that the Minister of Local Government has on several occasions that I've heard him speaking to the media, continuously making the point, and he made it again here today, that sometimes we disagree on the interpretation of law. So I don't know if this is the minister's way of saying that he does not take responsibility for the decision. But at the end of the day, the evidence in this case, the evidence that formed part of this case, was that it was the Minister of Local Government that went to the media and said, this is how the law is to be interpreted, and this is the way we are moving, and we are deferring the election. And they like to talk about this, the UNC and the UNC. Several people at that point in time wrote articles, editorials. It's all there as part of the case, but they cherry pick what they want to come here and talk about. Many people wrote about the fact and questioned whether the deferral of an election, whether it was interpretation or otherwise, was a misrepresentation. But I am here today to tell you that this was was a slap in the face of democracy. But I am here today to tell you that history will show that this was no error of interpretation. This was a deliberate act committed by our government, running from the population, running scared and still running scared. That's why we can't get the date up to now. Still running scared from the electorate because they have failed miserably, not just on local government, but on several areas, things which affect people and how they vote. Just throw your mind back to the time when local government elections were due and the councillors had to demit office in December. Go back and look at our newspapers. There was a countdown in every newspaper. We are heading towards 600 murders in this country. That had them frightened, not interpretation. All the talk about property tax, that had them frightened, that the population was resentful of it, not interpretation. And we know that it had nothing to do with interpretation, because when the issue was raised in 2019 by the brilliant, honorable, very hard-working, responsible leader of the opposition, the Minister of Local Government, before he lost his job as Attorney General, stood up and described such a suggestion as poppycock. But he sat down in a cabinet and allowed the poppycock to take place.
In relation to lollipop?
It is remarkable that the same individual who said that it was necessary when the leader of the opposition raised it in the other place, that it would be necessary to put in a clause to ensure that it doesn't extend the life of existing councils, said that is poppycock, as I quote my honorable Prime Minister. Well, what we are here today is to fix the poppycock. We are here to fix all of the poppycock that they have done.
Not a peacock, eh? Wait. A peacock.
No.
Peacock, eh?
And anybody, and I want to say the Attorney General, and I feel sorry for the Attorney General sometimes, because the Attorney General is the right one, not the one I get fired. The Attorney General is an experienced public law practitioner. I've had the privilege, and I still consider it a privilege, that in many matters where I was junior counsel to Mr. Ram Logan, the Honorable Attorney General appeared on the other side, and he understands the law. He understands public law.
We can't see that yet.
And he has come here today to quote an article from somebody who I have never seen in a courthouse in my life. I do not know what public law experience some of these people have, but they come to deprecate and criticize the Privy Council and say that it doesn't add to our jurisprudence. And I really do feel sorry for the Attorney General sometimes when he has to stand here and rely on these things and defend what I think he knows to be the indefensible. And I believe that he knows better. But be that as it may, he has to do his job.
If you know better, debate him.
And the Attorney General has raised the concerns which surfaced in the wake of this judgment by Senator Dialsing. And I want to spend some time talking about that as well. The record will show, when people are speaking about the way that the law was passed and whether Parliament had any role to play in it, this had absolutely nothing to do with the Parliament. The extension of time is valid to people who will be elected. That's what the judgment said. Instead of only reading Surat, what they should do is pick up a Benyon on statutory interpretation and understand that you cannot apply laws retrospectively, and that is what the argument in this case was about. They choose to say, and this is the other argument that has come forward from the government in defense of the indefensible, in defense of their loss, in defense of their massive defeat, costing the population millions of dollars in legal fees. They have come here to say that we didn't breach the Constitution. Since last week sometime in San Fernando, Constitution, everybody now is a constitutional law expert, and we didn't breach the Constitution. So you believe that not breaching the Constitution makes it okay to take away people's right to vote out an elected representative.
Break the law.
And that is why I say contempt for the population. Contempt. In this case, many people will not know because they read a judgment, or I don't even think many people read the judgments. I think they just read what is repeated in the newspapers. Certainly, I think many of them didn't read the judgments on that side. But the relief sought in this claim, the relief that was granted, is a declaration that the decision of the Cabinet and the Minister of Rural Development and the Minister of Rural Development and Local Government, look who they name in, That's who they name in this. He was named as a separate defendant, the Honorable Minister, was named as a separate defendant in this matter. Because it is that Minister of Local Government that telegraphed to the population that this is the decision and this is the interpretation that was put on this law. And the declaration granted in this case said that that decision is illegal, null and void, and of no legal effect.
Repeat that again.
Illegal,
Yes.
null and void, and of no effect. There is a difference between illegal and unconstitutional. That's fine. But we have laws in this country other than the Constitution, just like we have cases other than Surat. But that is something that this entire bench representing the government in this place seem to have missed.
Teach them.
They don't care if they have to bring poppycock and feed it to the population. They rather do that than face the licks that they will face again when they go back to the electorate.
Oh yes.
In 6 6 months that they have stolen from the population, they're running into Kokie, Taruba, and Marabala West, trying to do what they have not done in 3 years.
In 8 years.
That is what they're trying to do. And so they have...
I rise on...
There's a point of order, Minister.
I rise on standing order 46-1. Could we at least get to one provision of the bill?
So, one second, have a seat. So, Minister, what is happening right now is that the Senator is responding to arguments that have been put forward in the debate thus far. So what I would guide the Senator in is just to keep it tight, keep it connected to the bill that is before us, and continue.
Thank you, Mr. President. You see, the 3 speakers before me spent endless time talking about Scottish, Irish, German, and French and the Constitution. But they don't want to hear about the Constitution now. They don't.
I protest as an African.
They don't want to hear that you don't have to violate Section 4 and 5 of the Constitution, one of the Constitutional rights, to act illegally, and that is what they did. And no amount of spinning, you could travel around the world and look for everything that you could find and every excuse you could find and criticize who you want. The law, as it stands today in the Republic of Trinidad and Tobago, is that the government of Trinidad and Tobago, acting through the Minister of Local Government and Rural Development, acted illegally. Now, if we want to get to the issue of this bill and what it is tending to accomplish, it is very simple, please, Mr. President. I was going to say please, my lord. Anyway, Mr. President, and the learning from the Privy Council, it's very instructive. We must not interfere with voting rights. You must not interfere with voting rights except by clear and express language. And again, what makes this attempt to slip through the back door and extend the life of councils and run from the electorate even more horrendous and despicable is the fact that the model existed, plain as day. Plain as day. The Honorable Minister took his time to go through all the instances when local government elections were deferred, from when we had Black Power to NAR to everybody, and 3 times under Mr. Manning, their own party. And the manner in which it was done by someone who had respect at least for the Parliament is to come straight forward. And I give Mr. Manning some credit for that. Yeah, he didn't try to hide. He didn't try to hide and deceive the Parliament. He came straight forward, laid a bill in the Parliament and said, we are putting off the election because we want to, and I will borrow the phrase of the minister, turn on reform. At least they were honest and straightforward, unlike this government that tries on every turn to deceive. But thank God for the UNC, and thank God for Kamala Prasad Bisesta. They were not permitted to do that. So if they wish to come now and bring amendments to say that when they turn on the reform, it will apply to the sitting councils, well, do that. Do that for once. Try to be straightforward and say what it is you are trying to accomplish. Nothing is wrong with that. The minister acts as though that is some great difficulty that they will experience, as though being straightforward and honest and forthright with this Parliament is a difficulty for them. Come to the Parliament and say that we are having elections when they are due, and as we implement reforms, we will try to have them to take effect and to be applicable. Not all of the reforms will affect the councillors and aldermen themselves who were elected. I have all kinds of things about burial grounds and all kinds of things in this reform. What is stopping you from doing that whilst the councillors are elected? So I say all of this to make the point that this so-called error in interpretation, their error, not the Parliament's error. So let me be very clear, because we took no part in that, and anybody who wants to help bear that cross with the government is free to do so. But we took no part in that.
None. 6 of us.
None whatsoever. The 6 of us in here, in fact, I think we abstained from voting on that bill, because there are other things in this reform and this Municipal Corporations Amendment Bill that we don't agree with. We abstained from voting on it. But apart from that, even if we did support the bill, the interpretation rests solely with the government, and it is their interpretation. Just like, and I'm responding to what the minister said, so before anybody jumps up, on standing orders, the minister raised an issue of interpretation with the order that had to do with the election of the police commissioner. The minister then, before he was removed as Attorney General, went to the population and said, I have all confidence about this clause, that it is true and it is correct. I had the benefit of drafting it and so on. And again, it is only when, and leaking seems, more leak than wasa. Somebody leak the opinion that the government got from Mr. Justice Nelson, that they start to backpedal and pedal. The point of it is that the court found that by trying to avoid the Parliament with acting appointments, and that is what the clause was trying to do, that too was illegal and and should not be interpreted that way. So they were getting it wrong again. Go back to another order where they try to interfere with the process of appointing a commissioner of police by inserting the Minister of National Security. We brought a statutory interpretation claim, Haridat Maraj, again led by Honorable Rail Senior Counsel, Mrs. Kamala Prasad Bisasa and Anna Ram Logan. Very straight face, because I know what is real silk and what is polyester cotton. Polyester, not even real cotton, polyester cotton. That's real wool. That's good. That's real wool. That's real wool. And both of them again had to save the democracy of this country by bringing a statutory interpretation claim to show that the way that this government is intent on continuously interpreting law and making errors of interpretation in a way to achieve their own ends and their means, which is to take control and manipulate processes. And this case is no different. Every time, I think statutory interpretation will now become my core business, because every time they put an interpretation on some piece of law, we have to look at the ulterior motive behind it. They always have an ulterior motive. And in this case, deferring elections because they could not face the electorate at a time when the country was in total shambles. We're still in shambles. They haven't accomplished anything. But the kind of bad publicity and media was on them, and every group and everybody was criticizing them on their handling of crime, and the only response they could come up with is a minister who said, well, I know my responsibility. That was trending in December. That was trending all over this country in December, that we have a minister saying, well, policy is not my job. And that is why they made this interpretation.
46-1, please. She's now gone irrelevant.
So, members, just remember that when one is raising a standing order, the other will have a seat. I know our procedure is a little bit off because of the COVID-19 and the use of the booths, but just remember that that is how we operate. 46-1 is a standing order you raised, Acting Leader.
Yes.
Okay, so, Senator, as much as you are responding to arguments put forward before, bring it back to what is before us now. There's no need to continue on with the various examples.
Guided, Mr. President. Now, one of the things that was touched on by Senator Mark, and the minister is explaining it by saying, well, the judgment has now triggered the election, and by validating what was done up to the 18th of May, it now triggers the end of the term and the 3-month period. Mr. President, our law caters for that 3-month interregnum. Actually, it was the 3rd of December was the day that elected representatives were returned, and that is the date on which their term started. And so they were supposed to demit office midnight on the 2nd of December. We ought to have had an election within 90 days of the 2nd of December.
Yes.
We, the people of this country, were deprived of that right by this government. Judgment has come. And you know, the government isn't even eager now to announce when they will correct their sins and allow the population to vote. They're still frightened. They have not even seen it fit. There's a period of 35 days that are required in order to go through all of the processes set out in the Representation of the People Act. And a government that is, I would say, responsible, a government that acknowledges that they have cheated the people of this country of 6 months of elected representation, would have called an election date already and not wait 3 months. They would not. You see, they are not bound by the 3-month period in the Municipal Corporations Act because they throw away that long time. The government is now saying, well, we have 3 months, we could play with 3 months, but I want to take you all into this matter again very carefully and talk about this 3 months, because prior to the expiration of the term of 3 months, we went to the court and said, listen, what is going to happen is you're going to have people acting in office illegally. So said, so done. That's why we're here today. But the responsible opposition went to the court and said, do not permit them to carry out this erroneous interpretation and defer the election, because you are going to create a mess by having people paid, spending money, entering into contracts, etc. And you should put an injunction in place and prevent it from happening and ask for an urgent hearing before the court. At every turn, the government objected to that. And the Minister of Rural Development and Local Government went on affidavit to explain why that cannot work. I could give the little war room stories now. The matter is over. Behind the scenes, we used to call this the chicken licking affidavit. Because chicken licking came to the court and said, oh God, the sky is going to fall down if you do that. And I want to know how it is a minister could now say, well, it has triggered the 3 months and we have 3 months to call an election. Today is saying that. And in November, would have gone to the court and say, without councillors and aldermen, everything will mash up and everything will fall down in this country, and opposed. They opposed the grant of an injunction to prevent the illegality from taking place, because apparently they like illegality. Apparently they like chaos. They like to cause confusion. They like to leave people in the country in a state of, we just don't know what is happening. So they permitted, allowed, and fought for the illegality before the court. Let me tell you what the minister who is now saying, well, we have 3 months to hold the election, what that minister said on affidavit. This is sworn evidence given in the matter. With your leave, Mr. President, I will quote from it. At paragraph 6 of that affidavit, sworn in this matter, were the sitting councillors and aldermen to be restrained from acting or continuing in their various offices beyond the 3rd of December 2022, pending the determination of the substantive claim, the operations of municipal corporations throughout the country would be crippled and the corporations rendered powerless and ineffective. This would have a considerable wider adverse public impact. So from the 18th of May and the 3 months moving forward, nobody being crippled? Is nobody being crippled? We argued that when the term of office came to an end in December, there would be... No, I'm not giving way. You had it to you. Talk enough? Yes, I'm not. The minister has put enough erroneous information before this parliament today. I will not condone it and allow any more. Right? We went to the court and said that rather than having people illegally occupy office beyond the 2nd of December, that the court in any event, the law catered for a 3-month interregnum up until March, and we should restrain people from coming to work on the 3rd of December. That was opposed. It was opposed by the said Minister of Local Government. It was opposed by the government, acting through their attorneys. They said, no, that cannot happen. How could it happen now? How could it, after 6 months later, when they have deprived the population of the right to vote in an election that they were entitled to vote in, they're happy to wait the 3 months? Is it now not that they're saying that it will have irremediable prejudice if they could not act? And we made the argument, the same argument that they're coming here to repeat today, that chairmen and mayors will remain in office and perform their role to ensure that until a new mayor or a new chairman is elected, that the corporation continues to run through its officers, its CEOs and chief public health officers and engineers and so on. They oppose that, but they are happy to wait for the 3 months now. Mr. President, they have no right to come here and ask for another 3 months to call this election. They have no right after their illegal, not unconstitutional, but that doesn't make it any better, illegal act. After the illegal act, to come and say, well, it's okay, we could wait 3 months to elect a new corporation. And for 3 months, there would be no councillors and aldermen in office. So what will happen? What will happen? But that just goes to show that they have no problem misleading courts. And that is what was done in this case. They misled the courts when what ought to have happened. And if we had a responsible government that had respect for the rule of law.
I rise on Standing Order 46.4 and 46.6. Those are improper motives directed towards me, Mr. Deputy Speaker, Mr. Vice President.
Senator, as you are about 10 minutes away from your end of your contribution, I ask that you tailor your words accordingly. Thank you.
And Mr. Vice President, the truth offense. Sorry, I lost what I was saying. Yes, they have no right to ask for these 3 months. And I want to then get to the issue of this reform. The government tries to defend their illegality by saying that what they are concerned with is reform. They wanted the reform. And again, forming part of the evidence in this matter was actually the announcement made by the Minister of Local Government when he talked about the need to defer this election and the timetable that will be rolled out here. And I am quoting from an article dated August 10th, 2022. And the subtitle of this, the title of it is UNC Local Government Reps blank crucial meeting, because it was so important to them to have a meeting with local government representatives because they were talking about the rollout and the reforms and so on. Well, nobody's interested in them, what they have to say, because nobody believes anything that they have to say anymore.
Nothing.
But under the subheading, proclamation timetable, the government, through its minister, stated at that meeting and a press conference held after that meeting, which incidentally the Prime Minister didn't attend either. The minister is quoted as saying, in the proclamation timetable, 9 laws which we have amended in the local government reform, those 9 laws fall to be next operationalized by proclaiming the laws and saying they will begin to apply. Of the 88 amendments, 54 of them are capable of almost immediate proclamation. How many of the 54 have you implemented? In the 6 months that you have stolen from the electorate, how many of the serious, important local government reform that you're touting here today that you are so interested in, have you implemented? You stole 6 months away from the population and imposed representation on them. And you did, the government has done absolutely nothing for local government reform. And I go on by quoting again from the article. The Honorable Minister said 10 of them will require a month or 2 to have certain mechanisms put in place. 8 of them 3 to 6 months. So that is 10 and 8, 18. 18 things that could have happened in the last 6 months. How many? Not one. Not one. 16 of them can go on in the background, and that can take a maximum of 12 months. But in this particular exercise, we are able to immediately begin the cabinet consideration of how we will partially proclaim this law. This matters as it relates to a very few core concepts of local government reform. And then he went on to say, the Honourable Minister went on to say, among the concepts, he said, was moving local government from a 3-year to 4-year cycle, creating municipal council style similar to House of Representatives, and moving the Executive Council into full-time employment. And he went on to speak about full-time employment and, of course, the rollout of the dastardly decision to impose property tax on the population at a time when they are already suffering. But we come into that on Friday. Mr. Vice President, I raise this to show that all of this excuse, all of these reasons, all of this talk and rigmarole about reform and interpretation, and I could have go other way, it's poppycock. It's pure poppycock. And a minister who knew it was poppycock in 2019 led the charge to impose the poppycock on the population in 2022. And I want to tell him today that if you did not have a strong opposition, if you did not have a brilliant senior counsel as the leader of the opposition.
You have 5 minutes remaining.
Thank you. If you did not have the UNC standing in defense of democracy in this country, they would have gotten away with it. They would have gotten away with it. They would have gotten away on this deceit that they try to impose and manipulation that they try to impose on the population. Well, I will end today by telling them that everybody likes to come here with a quote. I like movies. I will quote from a movie, one of my favorite movies. You have been weighed, you have been measured, and you have been found wanting. Come back when you are worthy. And come back in the polls and show people of this country that you are worthy when you talk about reform, because you have been found to be most unworthy government to the people of this country.
Members. Members, I'm on my legs. Thank you very much. Senator Dr. Paul Richards.
Thank you, Mr. Vice President, for the opportunity to join this debate on the Municipal Corporation's extension of terms of office and validation bill 2023. I must say it's actually quite pleasant to be back able to speak with my colleagues at close range. The booth was quite separating. Anyway, Mr. Vice President, you know, our system of democracy is the system we've adopted as our system of governance, and is a powerful, but at the same time very fragile institution. Of course, we know the word democracy coming from the word demos, meaning the people, and kratos, meaning power. So democracy can be thought of as power of the people, or the way of governing which depends on the will of the people. And one of the most powerful components of a democracy is the will of the people and the ability of the people to choose a government and representatives of their choice. In other words, their vote. Now, we are gathered here today to debate the Municipal Corporation's extension of terms of office and validation bill 2023. So there are two important words in this title: extensions, which we all know what that means, and validation. So what is validation? So I did some checking, cursory manner. The action of checking or providing validity or accuracy of something. Another Oxford definition is the action of making or declaring something legally or officially acceptable. So if we have to declare something legally acceptable, it means there was some sort of doubt or question about its legality or position of illegality. So what prompted the need for a validation of the extension of terms of office of councillors and aldermen? Well, the government used an interpretation of the law to apply to existing councillors and aldermen passed December 2nd, 2022, which was challenged in our high and appeal courts and eventually made its way to the Privy Council, which delivered a judgment on May 18th, 2023, which invalidated, in effect, the extensions because of the nebulous language used. In my understanding of the judgment, which indicated the new 4-year term of office could only or should have only been applied to incoming councillors and aldermen. Of course, that day was a very red-letter day in this country's history. A flurry of press releases and press conferences ensued to avail the population of what the judgment really meant. And it was a day that was very interesting. For the moment, I thought, the Honourable Attorney General, and I advised him I was going to give him some political jousting today, so he's expecting it. For a minute, looking at the Honourable Attorney General's press conference, I was amazed at his ability and dexterity and agility. I thought he was a gymnast, a verbal gymnast, able to spin words very, very effectively. I think, AG, Honourable AG, you could have a career in the sport of gymnastics, given what I saw that day. With the greatest of respect, I look at the press conference, like thousands of citizens, and heard the Honourable AG indicate that the judgment of the Privy Council was out of the action of the Parliament of Trinidad and Tobago. Well, technically, yes, but let's make no mistake. This interpretation of the law and subsequent application of the law that gave the government the belief it had the power to extend the terms of the present councillors and aldermen to be included as a 4-year term is what has landed us here today. This, we know, was a government decision, not necessarily a parliamentary decision, because there are those in the other place and in this Honourable House who were opposed to that, and they made it very clear, and also persons in civil society. So let's make no mistake. The government has to shoulder the full responsibility of this situation. And I think they have, because they've brought this bill to us to rectify the ramifications of that situation, which I think is a responsible thing to do. I also, with respect, reject the proposal of my colleague, Dr. Varma Dayal Singh, that this is, quote, a shame on the entire Parliament. I believe this is part of our evolution as a relatively young nation, where laws will be tested and judgments delivered in terms of the interpretation and application of the laws. And this judgment, to me, was a check on the remit and reach of the executive, particularly when it regards, as it regards the calling of election and the vote of the people, which we should consider sacred, in a timely manner. But I think this is a necessary part of our evolution as a nation, and we can rest assured it will not be the last time that interpretations of laws by the executive and otherwise will be tested in the courts. I also need to place on the record that in light of the Privy Council judgment, I think the government has acted responsibly in response to the judgment and brought this bill to Parliament in quick time to the House of Representatives last week Friday, and of course now to the Senate, which seeks to validate the actions and decisions of the aldermen and councillors as to ensure their lawful actions and to remove even the slightest doubt related to their tenures after December 2nd, 2022. I also support for this bill today underscores our individual. I suggest the support for the bill today underscores our individual and collective commitment to lawfulness, despite the origins of the situation. And I think it's a responsible action to take. But even with that said, I wonder if this is the type of start we would have wanted for a new incarnation, a new dispensation of local government in Trinidad and Tobago, one which promised so much change, so much new ways of doing things, brought into being essentially with so much controversy. One of the reasons given for the extension, delay, postponement, whatever nomenclature you want to use, for the local government election and the extension of the aldermen and councillors' tenures was to make provisions for this new dispensation of local government. And I'm passionate about this, Mr. Vice President, because I had the honor to sit on the GSC related to local government reform bill, on which so many new proposals and new hope lay, given the challenges we've seen in local government over the past 40, 50, 60 years. Many changes which are proposed to make local government more effective, to effect devolution of power, and to put more gravitas in the hands of local government practitioners. That committee, which was led by former Leader of Government Business and former Agriculture Minister Clarence Rambarat, worked for months. The committee also included now MP Khadija Amin, MP for St. Augustine, Senator Timal, I think the Minister of Local Government and Rural Development was in that, and several others, who painstakingly met with scores of critical stakeholders and deliberated upon provisions that sought to improve the operations of local government bodies, including giving them more autonomy and resolving decades-long challenges in the interests of the people of Trinidad and Tobago and the Burgesses. So I asked the question, and this is a question I'm asking, and I hope somebody in the government bench can answer this question. After 6 months, what has been done? What has been done to prepare regional bodies, potential candidates, and the population for this new dispensation of local government? What can the population expect? What are the changes that will happen in terms of how the population should expect services to be delivered? We often bemoan the population's apathetic voter turnout in local government elections, primarily because of a lack of understanding, in some measures, to the roles and responsibilities and the impact of councillors and aldermen past when we have a flooding issue or when we want to build box drains. But what can the population expect in this new dispensation? I am a member of the media, and I have heard no public awareness campaign. I have heard no information, education disseminated to the population about what they can expect, what new responsibilities council and aldermen may have, what new conduits of interventions the population may have. And I think that's a travesty after 6 months, because now we will be going into a local government election in the next couple of months, and the new dispensation will start, and the population is equally as ignorant as 6 months ago. What will they expect? And I hope that following or leading up to this, because I know it's campaign season starting now in the run-up to when the Honourable Prime Minister announces the date, there will be a little time for that, but I hope on the campaign trail we can be apprised of what people can expect, because in many, many ways, because I was able to have the honour of sitting on the GSC, I understand some of the changes, but there's several significant changes in the way things are going to be done and what the population can expect. And if the population doesn't know what to expect, they cannot effectively take advantage of the proposed changes to make these bodies more effective and more accountable. So I'm proposing that a public awareness campaign be undertaken as soon as possible so the population is made fully aware of what they can expect, the changes in the workings of regional corporations and bodies, and what their representatives are due to provide for them in terms of services. I hope, given this controversy that lands us here today, we have not squandered the opportunity to reset the public appreciation for local government in this new dispensation, because I think also that would be really a waste of an opportunity. I think we have the obligation to raise the discourse related to local government and ensure by our collective action as legislators we bestow the appropriate respect and reverence to local government. That's the only way we're going to have the voter turnouts improved. Because if we keep treating local government the way we have, and several speakers before me, through you, Mr. Vice President, have expressed the instances where local government elections have either been delayed, postponed, extensions made, to the detriment of the population. So what we are doing, in fact, when we have these types of controversies, is continuing to diminish the importance and credibility of local government in the population. And that could not be good for our population, because local government is extremely important. And if you ask the average citizen, well, who is your councillor? Who is your alderman? They tell you they don't know. Because unless we have a flooding situation when local government really takes the forefront, or you have as someone said earlier on, cemetery cleanings, the market provisions and stuff, what is the population to expect from this situation? So I hope we can remedy that situation. Mr. Vice President, I wonder if it would even cross any mind, any executive member, to consider extending the terms of elected member of parliaments in any one of the 41 constituencies. And the answer is no. Because we obviously place a lot more respect on general elections compared to local government elections. And we understand why, because in general elections, we choose the executive, the cabinet. Well, we choose the executive in terms of the Prime Minister who chooses the cabinet. But in local government election, we still are operating under the paradigm that, well, it's not as important, so we don't place the kind of gravitas in it. And I don't think this situation in the last couple of months has helped that cause in any great measure in terms of the public looking on and having a different kind of respect and focus on local government and their participation in local government. It's interesting that one of the reasons that was proffered in terms of the extension and needing more time to put things in place was, of course, all the systems and proclamations that needed to be made. But we transitioned from one constitutional arrangement in 1976 to a Republican constitution, and we had no delay in elections. We had no extension of terms. Elections were called when they were due, and that was a much more significant transition constitutionally than this situation that arises here. So we have to ask ourselves again, are we really treating local government with the respect it deserves in Trinidad and Tobago? And is that being translated by us in the Parliament as legislators and, quite frankly, the executive in this action that has brought us here today to improving or increasing the importance in the eyes of the population and the gravitas of local government elections? We have to ask ourselves that question. We must respect, Mr. Vice President, our citizens' enshrined rights to vote in the prescribed time in any and all elections in Trinidad and Tobago. All other considerations must fall secondary, barring the threat to life. To me, that's the only thing that should delay or prevent an election in Trinidad and Tobago. And maybe this situation may also precipitate a national conversation on the issue of local government elections being formally enshrined in the Constitution, so that it's not left up to the machinations of politicians moving forward. To go straight to the bill itself, Mr. Vice President, the only clause I would have identified as having any concern, and the Honourable Attorney General addressed it in his presentation, is Clause 5, and I'll quote with your leave. Clause 5 states, where the councillors and aldermen under Section 3 exercise the function of councillors and aldermen between the 2nd December 2022 and the 18th of May 2023, and thereafter exercise the functions of councillors and aldermen up until the commencement of this Act, and the exercise of those functions and all acts or things done pursuant thereto shall be deemed to have been as valid and effectual as if the Municipal Corporation Act expressly empowered them to exercise these functions. And I believe that the amendment or the edit proposed by the Attorney General satisfies my concern in that regard. So I thank the Attorney General for his consideration and application of that edit. In closing, I also would like to echo the sentiments of many in the population that an election date, which we recognize as is the sole prerogative of the Honourable Prime Minister, to provide the population at the earliest possible time the date for local government election 2023. Mr. Vice President, I thank you.
Senator Runika Sagram Singh's floor.
Mr. Vice President, I thank you very, very much for the opportunity to jump in. My intervention is, of course, not going to be very long, recognizing, the contributions made by the Honourable Minister of Local Government and, of course, the Attorney General in, explaining to the population of Trinidad and Tobago and, of course, this most esteemed Senate on what is the purpose of this bill that we are here to debate today. But, of course, I have to jump in because there are certain things to the record I will want to at least place the government's position on the record. Before I do that, though, Mr. Vice President, Senator Lachmidial, throughout the length and breadth of her presentation, she kept saying she's astounded and confused. And I believe that the senator is indeed astounded and she's confused because apparently for a second, she thought this was spread pal with Munilal and this was not the Senate. You see, the Senate requires a certain level of decorum, Mr. Vice President. The Senate requires a certain level of behavior. And the way in which they will rise on a standing order if it's out of place. So anyway, as I'm saying, Mr. President, Mr. Vice President, I'm saying, Mr. Vice President, this is not a something and I drink something.
Senator Naked, I'm on my feet. Senator John, all present. I'm speaking. I am speaking. I am asking Senator Naked. I am on my legs. Senator Naked, I am on my legs. If you cannot wait your turn to speak, and in the manner that is deserved of this Senate, I would ask you to leave. This debate is veering down a very emotional pathway. And we are exchanging lots of words, and the dynamic of our Senate has changed because of the proximity of the speaking. I ask that everyone here tempers their comments and they live and abide by the standing orders, which requires us to speak and behave as senators. Thank you.
Thank you very much for that intervention, Mr. Vice President. I'm indeed guided, and that is why we on the government bench and we at the PNM, we are held at a different standard. And of course, complying with your advice, Mr. President, Mr. Vice President, we're going to bring some kind of sober contribution to this debate and be able to debate and relate to the people of Trinidad and Tobago what exactly we are here to debate today. As I said, this is not a knock something and a drink something. It is for us to be able to report to the people of Trinidad and Tobago what is the purpose of the bill. We're not here to debate the Privy Council decision. We are not here to debate who poppycock this and poppycock that. What we are here to debate is a validation bill, Mr. President. And that is what, as the government, and in my very simple contribution, what I'm going to attempt to do here. You know, the senator also said, and I'm going back to her statement that she's confused and she's astounded, and I believe she's confused and astounded because had she reminded herself that this is the Senate and she's a lawyer, she would have, that statement that she made, and the senator said, she said, according to Benyan's statutory interpretation, a government cannot create retrospective law. Madness, Mr. President. That is erroneous in law. What it says, Mr. Vice President, and I believe she's confused and confounded or astounded or whatever she said. In the law, Mr. President, retrospective laws are in fact possible, but shall not apply to criminal matters to sort of double penalize a convicted person. And it comes back to the position, and you're correct, Mr. Vice President, when you made the statement about us not being emotional and us not taking this debate along a particular part. I believe you. I agree with you 100%, because what we are here to do, Mr. President, is a validation bill. That is what we are here to debate, not the Monday night forum, presentation we were all just privy to, Mr. President. And I want to make one other comment concerning the contribution made by the senator. She spoke about a chicken, the chicken licking or some affidavit, in reference to the affidavit that was filed by the Honorable Minister of Local Government. I wouldn't get into that affidavit, but for a length and breadth of this debate, much was said about the Privy Council decision. And as the senator raised the issue about the sky is falling and the chicken licking affidavit, in that Privy Council decision, and I want to place this on the record now, in that Privy Council decision, the laws made reference to a particular affidavit made by a UNC councillor who stated on affidavit evidence that he was very disturbed when the term of office was extended because he personally didn't want to continue working. He didn't want to personally continue working as a councillor. And let me tell you, Mr. President, respectfully, Mr. Vice President, why I'm raising that affidavit? Well, I'm looking very closely and very cocky-eyed at that councillor because he swore on affidavit saying that he was particularly affected by, of course, when the term of office was extended, he was particularly affected, and of course that was a substantial affidavit that formed part of the pleadings that went before the Privy Council. So I'm looking at that councillor cocky-eye from now, and I want to see if when screening starts, if he offers himself for service, if he offers himself again to be screened, because there's affidavit evidence that speaks to him saying and going on the record before the court and the Privy Council going before the Privy Council saying that he was no longer interested in offering himself for service. So since the senator raised the issue about chicken licking affidavit, I want the honourable senator to know it have UNC councillors who went on affidavit for that said Privy Council matter that are watching them with a cocky eye to see if it is they true to form based on what they would have said on affidavit evidence. But Mr. President, Mr. Vice President, again, taking lead and taking guidance from what you would have suggested to us, I would just, my intervention and my contribution to this debate is, again, just to bring us back away from all the emotions, away from all the whatever we just experienced there from the other side, for us to go back to what is the purpose of the bill that we are here to debate. And as I would have indicated, Mr. President, the purpose of the bill is a validation bill. But I want to go, I heard the honorable senator as well, Senator Lakshmi Dayal in her presentation, and much of the opposition, they focused on the press conference that was held by the Minister of Local Government. And what is amazing, Mr. President, I want to take and I want to place on a record for the people of Trinidad and Tobago, paragraph 98 of the Court of Appeal judgment in this same matter. And if through you, Mr. President, I want to read what that paragraph 98 says. Paragraph 98 of that judgment said, firstly, there has been no challenge to the Parliament's right to amend the Municipal Corporation Act in the manner that it did. The only challenge was to whom it was intended to apply. Secondly, there has been no challenge lodged with respect to Cabinet's right to submit for proclamation the amended legislation on the date that they did. Thirdly, the language of the amended sections 11 and 12 does not suggest that it applies only to persons elected to office of councillor in the future. But the part of the judgment, the part of this judgment, from the excerpt of this judgment that I want to focus on, is where the Court of Appeal at paragraph 98 stated there has been no challenge lodged with respect to Cabinet's right to submit for the proclamation of the amended legislation. And why I'm raising that is because they come to the Parliament in this debate and they raise the issue of the proclamation. They raised the issue of the cabinet, the legal notice in which the cabinet made the decision to extend the term of officers. They raised it, and when this matter was filed, when this matter was taken to the courts of Trinidad and Tobago by their activists, by their people's champion, there was no part of the pleadings that they brought to the court that asked Mr. Vice President or sought to challenge that cabinet decision or sought to challenge the proclamation of certain sections. So how disingenuous it is that you come here and now you speak about the legal notice and the legality of the legal notice. And when you and your activists took the matter to the court, why didn't you challenge that proclamation? Why didn't you raise that as an issue in the pleadings that was filed before the court? Because they fully well know that the only issue that was for the court's determination was the interpretation of the proclamation of the clauses that were proclaimed and who it could apply to. So, Mr. President, I just wanted to also place on the record that excerpt that was taken from the Court of Appeal, decision. Mr. President, again, to remove and agreeing with you to remove the emotions from the debate and to take us back and to bring us back to what we are here to debate, I just want to springboard out of a comment that was made or a submission that, in passing, Minister Al-Rawi, Minister of Local Government, would have spoken about. And the simple point was that a validation bill is not new to our country. And I have to get into this a little bit more because for some reason, and that is the modus operandi of the UNCR, they're making it appear as if the bill that is here before us today is some way in which this government, as Senator Mark would have said, we're trying to hoodwink the population. Mr. Vice President, as I would have alluded to, a validation bill is certainly not new. Minister Al-Rawi would have also stated that. And it's not new to our jurisdiction because we have seen it. For example, Minister Al-Rawi would have spoken about instances where he came to the Parliament and would have passed certain validation bills. I am familiar to Mr. President, Mr. Vice President, with the companies, former Act Companies Validation Bill of 2002. So there was a validation bill there. We have the Sugar Industry Control Board Repeal Validation Act 2013. That is also another validation bill that was brought, and it was brought in 2013 under a UNC government, Mr. President. And then we have outside of our jurisdiction in the region, for example, in Barbados, we have the land valuation and validation bill. As far as Australia, you will have validation bills. The reason why I'm reading this into the record, I'm placing this into the record, is I want to start from a place where the population understands that the validation bill that is brought before this Parliament, which is what we are debating, not a Privy Council decision. What we are debating here is a bill that seeks to validate certain acts that have already been completed. And more so, this validation bill is not new to our jurisdiction. Mr. President, so as I indicated, validation bills are no stranger to the Senate, and as I said, it's certainly no stranger to the opposition. They themselves haven't piloted a validation bill with the Sugar Industry Control Board Repeal Validation Act in 2013. Now, why I want to get into a little, Mr. President, again, in order for the, and again, it's just for the benefit of the viewing and listening public, to understand the purpose of the debate, of course, because the Attorney General, I believe, would have done an excellent job in going through the law, going through the decision of the Privy Council, dealing with those issues. Of course, Minister Al-Rawi would have added to the contribution. But I need the public to be aware that this validation bill, again, to debunk the UNC's position that for some reason we are here to hoodwink the population, I'm here to reiterate to the public that this is not the purpose of the validation bill that is before us. So, for example, Mr. President, I want to go to, I would have mentioned the Sugar Industry Control Board Repeal Bill of 2013. And what is quite interesting, Mr. President, Mr. Vice President, is that in 2013, when that particular bill was debated in the House of Representatives and the Senate, there was actually Minister Imbert, who in Hansard dated the 17th of May 2013. In that particular debate, he said, all we are doing here today is authorizing the money to be deposited into the consolidated fund, full stop, and to validate all the actions of the various state officials involved with this matter for the last 26 years. Now, who could object to a piece of legislation like this? You know, so really, if the minister had not spent his time giving us tales of sugar, we could have been in and out of here in 5 minutes, because all we have been asked to do is come and do today, what we have been asked to do is to come and today is to agree that 800,000, that is the asset of the Sugar Industry Control Board that was accumulated over the last 20-odd years, that was paid into the consolidated fund, that the act of paying that into the consolidated fund was legal. And why I took that excerpt from the Honourable Minister Imbert, who was then an opposition MP at the time, why I take that excerpt is to remind the public, this is case on point as to what the purpose of this bill is here today. We could very well be over with this bill in 5 minutes if we literally stick to what is the purpose of the bill. The purpose of the bill, as you so rightfully say, is not to go down an emotional trade. It's not for us to prove who better than who or who made what mistake. The purpose of this bill is that we are here to validate certain acts that have been complete, that had taken place. We are here to validate the actions of our councillors. We are here to validate the actions of our aldermen. That is the mere purpose of what we are here today. And I believe that that excerpt taken, Mr. President, from, as I said, the Hansard dated the 17th of May 2013, it can also be applied. It certainly is applied to what is the purpose of this debate here today. And I think once as a responsible Senate, which I know we are a responsible Senate, that we pay attention to what is being debated here today and the purpose of this bill. We could literally be over with this debate, Mr. President, in a very short space of time, recognizing again and going back again to the purpose of today's debate. So I wanted to make reference to that. You know, Mr. President, again, I will go back and begin, and again, this is really for the benefit of the public, who, which I really, again, want to make a contribution, where I really want to focus on in my small contribution. You know, I want to go back to that, when that sugar industry control repeal validation bill was brought again in the House and the Senate. In the section 4, of that particular bill, Mr. President, then I will come to our section, our clause 4 and our clause 5 in our bill. But the section 4 of that, and I make reference to this particular bill, Mr. President, because as I said, this was a 2013 bill that was passed by the UNC government. And the clause 4, which is the section 4, it was closed at the time, the section 4 of that bill, Mr. President, it stated, and if you may allow me to read into the record, all acts required to be done under section 4 of the Act, which were done or purported to be done after the expiration of 6 months of the date of commencement of the Act, or were omitted to be done, are deemed to have been lawfully and validly done, or omitted to be done, and no legal proceedings or other action of any kind shall be entertained in respect or in consequence of such acts and omissions. And that is what the section 4 of that Sugar Industry Control Board Repeal Validation Bill of 2013 spoke about. Now, if we compare that to what our bill, so in this bill, what they were doing in 2013 was giving life and extending the actions or giving time for things that, as I would have said before, things that would have been lawfully and validly done or omitted to have been done. And that is exactly what, if we turn to our bill that is present, so this was their act, if we turn to our bill that appears before the Senate today, Mr. President, it says that where the councillors and aldermen under section 3 exercise the functions of councillors and aldermen between the 2nd December and 2022 and 18th of May 2023, and thereafter exercise the functions of councillors and aldermen up until the commencement of this act, the exercise of those functions and all acts or things done pursuant thereto shall be deemed to have been valid and effectual, as if the Municipal Corporation Act expressly empowered them to exercise those functions. Now, I have to read these two simultaneously, Mr. President, just simply for the benefit of the listening public to understand that is the mere purpose of the validation bill that appears before us today. As in 2013, when the UNC government would have passed a validation bill under a UNC administration in order, Mr. President, to add and to legalize, for want of a better word, acts that had already been completed or deemed to have been done by the Sugar Industry Control Board. Similarly, Mr. President, we are here in 2023 asking for the support for this particular bill, Mr. President, to simply be able, again, coming back to what is the purpose of the bill, to validate the actions of our councillors, to validate the actions of our aldermen. Of course, coming out of which many senators would have belabored the point of going through what the judgment at the Privy Council spoke about. So, Mr. President, that is one of the points that I wanted to simply read into the record, just so that, again, members of the listening public who are paying attention, that they can certainly understand that this bill is in no way attempt by the government to, of course, take away rights of our citizens. It is not the purpose. The purpose of this bill is not because, it is simply because we want to make it right. And I cannot understand, if a government is here to make something right, how that can be deemed as irresponsible. Respectfully, Mr. President, my submission is that is a sign of a responsible government. You know, Mr. President, the Attorney General as well in his piloting of the bill. He would have spoken about the de facto officer, and I know he would have gone into detail about the de facto officer. But what I want, my 2 pence adding and springboarding off of that point that the Attorney General would have made is to again remind the listening public and the viewing public that what we have is that the concept of that de facto officer in our jurisdiction, Mr. President, Mr. Vice President, is governed by case law. All right? So there is case law that speaks to what a de facto officer is conceived as. So for example, Mr. Vice President, there's the case of Foundry and Company versus Muffet. In this particular case, Lord Chancellor, who was one of the learned lords in this matter, he referenced, in that particular judgment, he referenced the case of the State versus Carroll. And a statement, one of the dicta coming out of that particular judgment, Mr. President, that dealt with the whole concept of the de facto officer was, an officer de facto is one whose acts, though not those of a lawful officer, the law upon principles of policy and justice will hold valid so far as they involve the interests of the public and third persons where the duties of the office were exercised. And the Attorney General, of course, in his presentation would have gone through at length what is the purpose and what is the meaning of a de facto officer. What I want to add to that contribution, Mr. President, and I will start where I began. So I said, in looking at the concept and the law as it relates to de facto officer, I said in our jurisdiction, that's an area of the law that is governed by the common law. What we are here to do, Mr. President, is to, with the bill that is before us today, reminding ourselves and remembering what we are here to debate, Mr. President. What we are doing in this particular bill, Mr. President, is of course now adding the legislative teeth to what the common law speaks about with a de facto officer. So yes, in the common law, it speaks to officers and it develops the jurisprudence on what a de facto officer is. But what we are here now, Mr. President, to do is to add the legislative bit to the creation or reiterating that these de facto officers now legislatively, not just via the common law, have the powers to operate. It would be within the parameters of this bill. They now legislatively have the power and would have had the power retrospectively to have made certain decisions, and the actions that would have been completed or conducted can be deemed lawful, not just according to the common law, but now also in accordance to legislation. And that too, Mr. President, I just wanted to add so that we understand and we come back to what is the purpose of the bill that we're here to debate, reminding ourselves of the purpose of the bill. One, of course, I would have mentioned that a validation bill is certainly not new to our jurisdiction by mentioning, of course, the 2013 Sugar Board Bill that was passed, which is now an Act of Parliament that was passed by the UNC administration. Our validation bill yes, of course, it treats with different issues, but it's not different because it seeks to simply validate the acts of officers. And then secondly, I would have gotten a little into the whole concept of that de facto officer, mentioning for the benefit of the listening public, Mr. President, Mr. Vice President, that currently in our jurisdiction, the role of a de facto or the concept of a de facto officer is governed by common law. And what this bill seeks to do is to now legislatively and through legislation state that these officers are now, their actions are now legal, not just according to the common law, but now relative to statute, relative to legislation. You know, Mr. President, a lot has been said by most of the government bench relative to what the purpose of this bill is. What was the purpose of this bill? So I will not belabor the point, only to add, Mr. President, that of course, what we are doing here of course, when you look at, for example, and I know Minister of Local Government would have gotten into some significant detail with it, we are looking at protecting our councillors. We are looking at protecting our aldermen, decisions that were made, from acts that were, of course, committed, decisions that were made, salaries that were even received for that period that, of course, the Privy Council would have ruled upon, just basically legalizing it. So, Mr. President, I want to remind, I just had to read that and make that simple contribution. Again, just simply to bring back this Honourable Senate and to remind the population of Trinidad and Tobago what is the purpose of the bill that we are here to debate. Going back to what Minister Imbert would have said in 2013, if we remind ourselves of what our purpose is, this debate could have really been completed in about 5 minutes, because we are here to rectify, we are here to validate actions of public officers. Mr. President, what I also want to read into the record, and again, it's for the benefit of the viewing and listening public, is just that general, and it's just for it to be a form part of the record of this debate, because a lot has been said about what we as a government have not done. A lot has been said about our failed local government reform attempts. You know, Mr. President, Mr. Vice President, as the Senate is aware, because most senators were a part of that debate. On October 1st, 2020, of course, this Senate saw the Miscellaneous Provision Local Government Reform Bill, and it was introduced into the Parliament by the then Minister of Rural who was the then Attorney General, who's now the Minister of Rural Development and Local Government. And that's where it started, Mr. President. As we are aware, and for the purpose of the record, Mr. President, in 2020, the bill, as we all know, was sent to the Joint Select Committee on the same day and eventually reported back to the House of Representatives, Mr. President, on the 2nd of July, 2022. Coming out of that bill, Mr. President, we had a report of the GSC, which was debated in the House of Representatives on the 23rd of March, the 8th of April, the 23rd of May, 2022, and then we had the 2020 bill was passed on the 23rd of May, 2022, with a simple majority, with the opposition abstaining. Now, I'm reading this into the record, Mr. President, to remind the public about the time lag or the time stamping the process of local government reform. So we remind ourselves that it was only in the 23rd of May, 2022, what we had, Mr. President, was that this bill was passed with a simple majority, both in the House of Representatives and the Senate. So from the 23rd of May 2022 to our current period, that is the time frame in which, if you have to hold the government accountable as to what you have done to operationalize, that is the period in which we should be focused on. Because the bill, Mr. President, was passed, as I said, Mr. Vice President, on the 23rd of May 2022, and now we are in May, we're in June, we're in May, we're still in May 2023. And within that period of time, from the passage of the bill to the current period, Mr. President, we were faced with litigation. We were faced with litigation. So when the other side asked the question about what have we done to operationalize, and absolutely nothing, I believe it was critical for me to just briefly go back and timestamp the chronology in which we dealt with local government as a responsible government, recognizing again and re-emphasizing again that this bill, Mr. President, it was on the 23rd of May 2022, we had the passage of that bill. And soon thereafter, Mr. President, we found ourselves tied up in litigation relative to the and then, of course, we had the proclamation of certain sections of the bill, and thereafter we were tied up in litigation. So I want to remind the public, when you ask yourself, or if the UNC or the opposition is making or trying to make an attempt or trying to place on the record that we speak about operationalizing and we have not done anything, Mr. President, I want to remind again the public about the period and just to emphasize again, when the bill was actually passed, to the current period, which is now May 2023, and within that period of time, and remember, within that period of time, and I know they don't like to hear it, within that period of time, COVID is still very much real. Yes, we were coming to the end of the pandemic, but we still had our challenges there, which we cannot get away from. Added to which, more significant than even that COVID story, is the litigation that we are placed with. A litigation that, yes, took us all the way to the Privy Council. And on the point of litigation, Mr. President, I want to also read into the record that, of course, yes, by legal notice number 206 of 2022, dated the 7th of November 2022, we had sections 1, 2, 3B, 3C, 1I, 3C3, and several other sections of the Act were proclaimed. And so we had proclamation taking place on the 7th of November. These parts of the bill, of the Act, Mr. President, in time stamping the way in which we have dealt with local government, let us also be reminded that it came into effect by the 8th of November 2022. And then by that time, when we had these matters, the High Court matters, so that's on the 8th of November 2022. By the 30th of November, Mr. President, Mr. Vice President, the 30th of November, we were faced with a High Court decision, because by that, before that time, we were in the courts. Upon proclamation, we were in the courts, and that is where we had to focus on the litigation that was before us. And it was on the 30th of November, Mr. President, 2022, we had a High Court decision. And mind you, it's a 33-page judgment, a 33-page judgment that was in our favor as a government. So therefore, we continued legally operating as we did, based on the interpretation of the High Court at that point in time. Further time stamping what has happened, Mr. President, from then to now, I want to go to the Court of Appeal decision. So it didn't stop at the High Court. And I'm reiterating this because people are going to be asking, okay, look how much time has passed. All you're talking about proclamation, you're talking about, it has been proclaimed, you're talking about operationalization. What have you all done? I want to remind the public, based on my time stamping of how local government was treated by our government and what we had to encounter, I want to remind the public why, probably more of what you had anticipated or hoped to see, what were some of the challenges as a government, Mr. President, that we were equally faced with. So I would have stopped at the High Court decision on November 30th, 2022, and it didn't stop there, Mr. President. We had by February 10, 2023, the matter was then at the Court of Appeal. And so again, how are we operationalizing when we have a Court of Appeal decision now, when we have a Court of Appeal matter that we had to treat with? The decision came, of course, on the 10th of November, on February 2023, but of course, we'd have been in litigation, active litigation, on the parts of the bill that had been proclaimed. And no doubt, once you are in litigation, what you will find is that no doubt it impacts on the manner in which and the haste in which you are able to operationalize legislation. Because, I mean, I think it was one of the honorable senators, I don't want to misquote a senator, I think it is Senator Vieira, who spoke about litigation really being, I think for want of a better word, it's like a lottery. I think the senator said litigation is like a lottery. It's either you win the lottery or you don't. And that is the reality. Those of us who are in the courts, we understand that is the stark, unfortunate reality, Mr. President, of litigation. Now, so by February 10, 2023, we have a Court of Appeal decision. And that Court of Appeal Mr. President, is a 42-page judgment that again was in the favor of the government of Trinidad and Tobago. So even by February 10th, 2023, when the government continued to act, we were still acting within the parameters of the law, because the Court of Appeal by that time reaffirmed the decision that was given on the 30th of November 2022, and we have a Court of Appeal decision on February 10, 2023, reaffirming that High Court decision. So we have a 42-page judgment now facing us as a government, and we continue to act legally. We continue to operate and continue now with this judgment before us, continuing the process of operationalizing local government. Mr. President, and then, well, of course, we all know what happened on the 18th of May, 2023. And
Senator, you have 5 minutes.
Okay, thank you, Mr. President. And then, of course, we have the 18th of May 2023 decision, which leads us to what the purpose of the bill here today, Mr. President. The Court of Appeal decision, of course, speaking to us, the importance of helping us to recognize, assisting us in recognizing that, okay, it was now necessary for us to validate the actions of our councillors and of our aldermen and so on. So, Mr. President, I believe it was critical, just to briefly timestamp, for the purpose, again, of the and the benefit of the viewing and listening public, to understand from a snapshot, a very brief snapshot of local government, this government's bringing of local government to the Parliament, and to the point of operationalization, what were some of the challenges that we have been faced with, and now we are here seeking the, of course, the cooperation and, of honourable senators in us being able to be able to validate, of course, the actions of our councillors and of our aldermen coming out of course, the Privy Council decision that came to us on the 18th of May 2023. So, Mr. President, as I would have indicated, my presentation, I didn't intend to be long at all. It's a very, very short intervention, but it was simply just to remind the viewing and listening public of the purpose of this bill. Certainly, the purpose of this bill is not the intention of the government, Mr. President, to hoodwink the population. This is not an assassination of democracy. This is not an irresponsible government, Mr. President. We acted legally with a High Court decision. We acted legally with a Court of Appeal decision. Yes, as Senator Vieira would have stated, which I totally endorse the Senator, that is what litigation is, unfortunately. Litigation is it's like a game of chance, it's a game of lottery. We were not successful at the Privy Council on the 18th of May, and we are here with a validation bill, Mr. President, in order to be able to validate the acts of our councillors, the acts of our aldermen. And with that being said, Mr. President, again, just to reiterate, we do look forward to the support of this Honourable Senate, recognizing that our simple process, purpose today, Mr. President, is simply to do exactly as the bill, the title of the bill suggests, an act to extend the terms of office of councillors and aldermen elected in December 2019 to provide for elections in 2023 and to validate the actions of the said councillors and aldermen between the 2nd of December 2022 and the 18th of May 2023. That is our purpose. Our purpose is not here to mislead the population. Our purpose is not here to hoodwink the population. Our purpose here is to comply and to make right based on the decision coming out of the Privy Council, Mr. President, on the 18th of May. With those few words, Mr. President, I thank you for the opportunity.
Senator Naked.
Mr. Vice President, I thank you for the opportunity to intervene briefly. And I would like to go straight into that a very unfortunate, vexatious presentation that we all had the fortitude to sit through from Senator Sargam Singh Suklal. I think the Senator, through you, Mr. Vice President, who likes to talk about the forum and Monday night report, I think she forgot where she was. Maybe she thought she was in a gym at the Hyatt or somewhere amongst her friends with personal trainers from Spain. But I think...
Senator Naked. Senator Naked.
I'll come in now.
Thank you. Just be reminded of your level of response to the speaker, the previous speaker, and also the decorum that is necessary. Just be mindful of it.
I'm very mindful, and I wish that same courtesy that you now extended and same sentiment was extended to the Honourable Senator, who for 3 minutes 2 to 3 minutes, launch a personal attack against Senator Jayanti Lakshmidial, who in her entire presentation showed the shortcomings and incompetency of this government and launched no personal attack against anyone. And I think it's not unbefitting that if you are to respond to a presentation from any senator, you should respond in kind. You do not need to get personal, and this is what the senator unfortunately did. And I do not like to respond in a personal manner, especially against somebody who I think her whole presentation was indeed vacuous and devoid of anything that made sense to the Senate. Because we had several senators stand up and say that, okay, you are validating, we know it's a validation bill, but you are validating something that you have clearly gone wrong on. You have made a mistake on. You were warned by the honorable opposition political leader. You were warned about it. You doubled down on it. You lost. You tried to justify that loss with all kind of equations that until now no one understands. And then you come here to the Senate and you double down again by trying to insist somehow that you had a judgment, as she said, a 33-page judgment in your favor. So somehow this government needs months to understand a 33-page judgment to read, and therefore cannot put anything that they talk about reform into effect. They cannot do not one thing they did. They haven't spoken about that. They spoke about a 33-page judgment handed down in their favor. But you lost. You lost in the most important and critical part of that judgment, which is at the Privy Council. You lost. And look at them, Mr. Vice President. Their hands in their faces in their hands, and it's clear that they have to sit through what the honorable senator obviously fell short on, which was there was no direct rebuttal of any question asked by Senator Wade Mark, Senator Richards, Senator Lakshmidial. No direct rebuttal. When are you going to call elections? Yes. You haven't answered that. You lost at the Privy Council. Can you explain that? No, they can't explain that. But you come to tell us about reform and about who jumping up with who. But be careful who you're jumping up with. Your Sindhu might fall off.
It might be a German.
It might be a German. No, it's not offensive. It's not offensive.
On a point of order, please.
You can talk about everybody.
On a point of order, 46-4. This is now degenerating.
No, it degenerated then. That's why it degenerated.
Senator, 46-4 is upheld. The language used and the tone it was used with is actually improper.
Actually?
Improper.
Improper.
Yeah. Senator, the standing order alludes to improper motives, and it has gotten extremely personal by the representation of a religious symbol. Yeah?
So here again, we had an entire contribution of 40-something odd minutes when she herself said that this whole bill could have taken 5 minutes. She went for 40 odd minutes on something that's not only empty rhetoric, but very vitriolic. There's no need for that level of personal attacks. But then what can you rely on when you have no substance to anything that you do? You failed on local government reform. You implemented nothing. You went all the way to the Privy Council, and Senator Jayanti Lakshmidial and Anna Ramlogan beat the pants off of you. Beat the pants off of you. What is your answer to that? No answer to that. You come here in the Senate and double down again to talk about, well, we win 2 here, we win 3 there. We win 2 was from Scotland. 1 might be from Kenya.
Anybody German?
Nobody care about that.
Any other
A point of order, please. 53(1)B. Repetitious.
I'm responding directly.
As much as you are responding directly, Senator Naked, the point of tedious repetition can come in if in that response you're repeating what has been said before. So what I just heard in the few minutes that I've been here is a repeat of what has gone before. So I'm just cautioning you at this point in time that we're going to run into tedious repetition if that continues.
Thank you very much, Mr. President. Then we can go straight into the claim that somehow COVID delayed them putting any kind of reform in. I think even the leader of government, he felt that that was a bit far-fetched. You know what I mean? That's kind of putting...
He couldn't hide it.
You know what I mean? He was amazed that they would claim that COVID somehow stopped them from implementing any kind of reform.
Embarrassing, in fact.
I mean, how can you uphold a presentation lacking substance? You go back to COVID. I'm surprised they didn't somehow blame Kamala as well. So here we have even one of the worst statements I've heard. Listen to this, Mr. President. Litigation is like a lottery. Litigation is like a lottery. Well, I tell you, for PNM lawyers, maybe. But for UNC lawyers, no. Litigation is about reasoning. Litigation is about calculations. It's about research. It's about skill. It's about proper documentation.
Teach that and hire Jim.
It's not about, well, I can imagine, you know, when you just show things and hope that one judge mightn't be Scottish, one might be Irish, you might look at it as maybe it's a lottery. But for the UNC, who has consistently beat them in the Privy Council, it's not a lottery. Fortunes are par for the course. And I think the Honorable Prime Minister will understand what I mean. It's par for the course. We beat them all the time at the Privy Council. All the time. So I can see why the senator, Mr. President, had to launch into personal attacks against the same person who beats her constantly. She had to launch personal attacks against Senator Lakshmi Dayal because she's the one at the forefront, together with Anand Logan and Ravi Balgobin Maharaj, as putting that licks upon the PNM.
Yes, that's right.
You know, as the more I think about it, Mr. President, I forgive the Honorable Senator. I forgive her. Because when you get that kind of licks, you tend to get confused. And you lose your point of orientation. You don't know what to say, you don't know what to do. I know why, because I used to beat people in football. And they don't know, they can't find their bearings. So what they do, they start to kick you down, personal, hit your elbow. So I understand, and matter of fact, I do apologize. I do feel sorry for the poor senator. Senator Lakshmi Dayal, you should be take it easy on the PNM next time in the Privy Council. Licks now for sure.
Get it now.
So,
Nice before.
back to the bill.
To get personal.
It's not about validation. You cannot validate what the Privy Council has made invalid.
Yeah.
You lost. They told you that what you did, the litigation that you passed, was wrong. It was wrong from the inception. They told you that. You come now, cap in hand begging. Cap in hand begging to the people who told you in the first place that what you are doing is wrong. We love to see all your beg. But it's unbecoming. Just come and tell us, we made a mistake. Tell the whole Senate, tell the whole population, we made a mistake. Apologize to the population, call election, and we might forget about it. But when you come, Mr. President, and you try to double down on a mistake, you look foolish. You basically look like your entire presentation. That can't be right. Just apologize to the people of Trinidad and Tobago. Said you tried to hoodwink, you tried to deceive, you tried to mama guy, and you failed. Why? The highest court of the land, which we should hold dear to, which we should cling to, which we should be thankful for, has said that this PNM is illegal. Wrong again. So I think we should all commend Senator Jayanti Lakshmi for not only her work that was done at the Privy Council, for a wonderful presentation, those that of hers, that of Senator Mark, that of Senator Paul Richards. And we ask, we implore, as most of the citizens of Trinidad and Tobago have to do with this government, for once in your life, for once in your life, for once in your life, be honest.
Not like people who
For once in your life, be decent.
I just still want mind my child.
Take that loss that hurts you so badly, that caused you to act so erratically in this Senate. Take that loss. Take it decently. Take it decently and say, please forgive us. Ask the country to forgive you with a remorseful heart. Yes. You understand, Honorable Randall Mitchell, Minister of Tourism. Sorry. Yes, I know.
He have a little decency.
Please.
A little bit.
So, Mr. President.
That's why he didn't get back his seat, because he was too decent for them.
Mr. President, I am glad we were able to turn what was becoming a very tense atmosphere into one that is more realistic, to try and tell this PNM government, from all the people of Trinidad and Tobago, you cannot play with the democratic rights of the people of Trinidad and Tobago. No matter how you phrase it, no matter how personal you get, no matter how you try to bring language from on high, democracy is the reality of our country. UNC will not let democracy fall through the gaps. We will not allow it. We will stand firm. We will stand there for the people of Trinidad and Tobago, and we will say to this incompetent, this corrupt, this illegal government that you will not pass anything in this parliament while we sit that will infringe on the rights of the people of Trinidad and Tobago. And in closing, Mr. President, in closing, Mr. President, you do not come to the Senate and said, this bill only needs 5 minutes, especially when you have had such an impact on the people of Trinidad and Tobago, their lives. I heard councillors talk about how they had hopes, ambitions beyond that, and they were more or less trapped by the legislation that they deceitfully brought in. I think the Privy Council alluded to that. So we are, again, Mr. President, it's clear. I think the fact that this government, that the people unfortunately have realized they got into government, that this government has run its course, this government has had its time, this government is no longer valid, this government no longer relevant, and for them to stay, they would have to bring some legislation to this parliament to get them to stay in government. Because no way the citizens of Trinidad and Tobago is going to allow this government with the deceitful manner to continue to govern and rule over a country where democracy is the norm. We will not allow it. And we wait, Mr. President, on international election observers to confirm what we know, that the next government and the winner of the local government elections will be the United National Congress. And I thank you, Mr. President.
Senator Dayal Singh.
Thank you, Mr. President. We owe it to our councillors, we owe it to our communities to get our house in order. We owe it to get this right. And this bill attempts to do so. It has 5 clauses. And the main clauses I look at is clause 3, which is to extend until the 18th of May the terms of our expired councillors. Clause 4, which serves to provide for election within 3 months, and clause 5 to validate the actions of decisions made by our councillors. The calling of elections is really, it establishes the importance of citizens' rights to vote. When they place their finger on the ballots, they are now able to feel that self of importance. It means something again. And it is important, I think, Mr. President, because you see, it now gives us a chance to be able to remove any non-performing councillors if we are faced with any in our communities. This gives us an earlier chance to do that, to get some relief. I think Ravi Balgobin Maharaj must be praised because his legal action ensures that democracy and the right to vote is maintained. It sends a clear message, not just to us, but throughout the Commonwealth, of the citizens' right to vote. So this Privy Council decision, judges, has a broader message, not just us. It sends a much-needed message about the power of the citizens to choose their representatives. At our last meeting here, we looked at parliamentary autonomy. And there I had argued that if we had probably gotten a legislative body within our parliament, we may have been able to look at laws, ask those attorneys in any sort of, if the Law Reform Commission or persons were under us, what does this law entail? And is there any way this law could be, there could any be an overreach in this law? Is there any way that they could look that sometimes things that we as parliamentarians here, as legislators, wouldn't look at things beyond it? Things that could have probably prevented what happened in the Privy Council. And again, this was a similar opinion expressed by Martin Daly, who even suggested sometime that there's a need for legislators to have access to legal advice on difficult matters. But I say all matters, because if you have matters coming here, we should have been able to approach them to get more exact law. The fact that we are here today to fix something means something went wrong. I was worried about Clause 5. And Clause 5 looks at the validation actions of the councillors and aldermen and whose terms have expired. And why I was worried about it is it's really, I'm happy to say that that worry I had has now dissipated with the proposed amendments from the Attorney General, who suggested somehow to give us a more exact interpretation of this. So Clause 5 in its amended version, I would be tended to support this version. But I looked at the question, Mr. President, about, the local government looking at putting it at 4 years and moving it from 3 years. And 3 years would have had the advantage of a mid-year review of any government in position to look and gauge how they are performing, to tell the government, hey, we may not like that, not just looking at councillors underperforming. Also, the fact that if you extend it to 4 years, I say, but why not 5? Because two things. We are faced with economic challenges. And sometimes it may make more sense, sir, if you have an election, local government election, in tandem with general elections, which could serve as a one election for all. So in my thing, I'm looking at if we have to go further with this, we should look at this. Again, it will save us from some political rhetoric which has been very insulting to, both parties against each other during elections, be it midterm or general elections. It saves the population some angle. So one set of elections may have the benefit of serving both the councillors and the members of parliament. So for our councillors' sake, I again support clause 3 and the amended clause 5. And I have to praise some of the councillors of the Tudor-Puna Piarco Regional Corporation. The chairman, Kwasi Robertson, has been very good to our community, has reached out, he is a tremendous person, and he has reached out to help our communities with our crime efforts. My councillor, Seema Ramsaran Augustine, again, we can WhatsApp all hours of the night to hear our concerns. Jalen Rupnarang in Curep, and also Travis Williams of Orserville. Those are people who serve, they serve. I can tell you that. I have used my councillors. I have, not even my councillor, but other councillors in different areas adjacent. And they have all answered our call and attempted. So they are genuine people. And again, the whole local government reform to put them in a better financial position. This is something I look forward to. So therefore, I must say now, we have to restart our councillors working with the plans they had. And while clause 5 gives them the power now, or gives any decisions they had made, the legal, give the legal blanket for it to continue. This is something that I am fully supporting. We had policies passed by the Tudor-Puna Regional Corporation in terms of certain crime initiative. The regional chairman, Mr. Robertson, actually had a plan where he was going to serve notices on people to remove illegal structures to help with the flooding. All that would have been in abeyance if clause 5 would not have been brought before us today. So bringing that in place today would let those plans go through, would let some relief, hopefully, with the flooding. So I want to comment on clause 4 of providing and holding government elections. So when I looked at this, and I'm seeing that moving it to 3 to 4 years, before time I should add, I'm thinking government should have gauged some opinions outside, not the minority opinion from the opposition, because we're hearing minority judges' opinion, majority judges' opinion. Let's forget the opposition here now. Let's look at the fact that other persons out there would have made comments about the postponing of elections. And I would like to quote, with your permission, sir, the article of Kimberly McCann in The Guardian, where it said, Manning, local government system has collapsed. And in this article, the late Prime Minister did say that he postponed the elections because the system has collapsed. It is not a matter of PNM or UNC. The system has collapsed. And I'm quoting what he said. Local government system. Therefore, we have to put something in proper place before we can go to the polls. So I understand his thinking, and I understand the thinking of other administrations, other persons who think, let's fix the law before we go to election. But again, you see, this is something that has caused a lot of debate. This is something that went up to the Privy Council. This is something we cannot take lightly. And I must say, our corporation seems to be working good. They seems to be having a problem with funds. So sometimes if they get the correct funding, they may be able to do their plans further. And probably with the other bills coming soon to us, with property, taxes, etc., we may be able to achieve that. So looking at this article, it mentioned Mr. Patrick Manning postponed the local government elections on 4 separate occasions since 2006, or 7 years. And when we look at this, we have seen there was a history of this before. And it was made mention by the Minister of Local Government that even in the 1970 and then around 1990, when the NER came into power, it was also postponed, so therefore there was a history of it before, where we give the councillors a life beyond their terms. But, if we had done so as we did so in the past, it may not have gotten to where we reach. If we had used the same technique, we would not have it would have saved a lot of taxpayers' money to hire some senior counsels on the government side to go all the way to the Privy Council to defend the action. We could have stopped after Ravi's first launch his matter in the High Court. We could have taken a remedial step. We could have stepped backward and said, let's go the old way. So I make mention, sir, that we have to, as I say, I may be hesitant to say that my rights may be taken away for 7 years by not being able to cast my vote, and I feel uncomfortable with that, because a lot may have changed when I voted a councillor in. And if saying that if successive governments keep speaking about bringing local government reforms, does that mean that tardy law passage would prevent me of my democratic right? Legislative delay causing infringement of our democracy. So I say government should have gauged what was in the public domain before they made that move. And I look at, and I like you to, for your permission, to quote what the Fourth Estate said, an editorial in the Newsday newspaper. And remember, these are independent press is vital to our democracy. And I would like to quote this. It was in October last year. The Newsday had an article, Fix Local Election Dates. It was Friday, the 26th of October. And basically it said there's too much uncertainty surrounding the timing of local government elections. And they mentioned it comes to an end in December with a period up to March in which the elections must be held. They mentioned further, however, it is within the power of the government to use its majority in Parliament to pass legislation deferring the poll. Indeed, this was what occurred in the years 2006, 2007, 2008, 2009, and under the tenure of Patrick Manning. And in 2010, local government elections are resumed under Kamala Persad-Bissessar. And it mentioned here now, the need to reform the system to drop fresh proposal to hold consultations has often been cited by governments as reasons to defer the polls. Same thing we are hearing today from the Minister of Local Government. And I'm saying, we heard it again today, and we have that dream, we have that support. We want to give the local government and the councillors, local government corporations and the councillors greater autonomy, greater ability to serve us. And the article, mentions that, but because local government elections are seen as midterm report cards, and because it's expected that the favorability rating of any government lags over time, such delays and maneuvers are often more reflective of political expediency than anything else. The current government has already been asked by opposition MPs to clarify whether it intends to hold off on the election pending legal reform. In reply, the government has kept the issue of timeline close to its chest. The article went on to say, in national interest for our democratic process, we need certainty and regularity. And they were actually calling for fixed days of it, fixed timing of this, and this is one of their recommendation. So this was in October 2022. But let's look at, so if you allow me to read now what another individual said, and this is in November 2022. And I want to quote Loop News, where Mr. David Abdullah actually quoted in this article that he said that and this was in Loop News, delayed local government elections as an attack on TT, 7th of November 2022. And why I looked at his opinion, because he actually then said, what ought to have happened in that is that the election should take place no later than March 2023, and then after those elections, a new legislation can be implemented, including giving those corporations and those elected councillors a 4-year term. He went on to say, the government, he added, therefore, that the intention to extend the position of councillors and other local government representatives by 1 year should have been signaled and made clear in the debate on the local government reform legislation. He said, so the Parliament would be aware as to what they were voting for and the implications of their vote in terms of setting an election date, and the citizens of the country, through that parliamentary debate, would also have been aware of what took place and what was planned by the government. So that was his opinion. So again, in making my opinion, shaping my opinion, I looked at one of our esteemed independent senators, that is the late Dana Sita-Hall, when she actually made reference, and I'd like to make reference, sir, to call local government elections now, a Guardian article on the 8th of the 7th month, 2009. And in it, it mentioned an 11th hour attempt by Prime Minister Patrick Manning to persuade independent senators to support a bill to extend the life of the municipal corporations in Trinidad was unsuccessful during yesterday's sitting in the Senate. So this, as independent Senator Dana Sita-Hall told legislators after Manning's contribution that she would be voting against the measure. She said, I am protecting the government from itself when I vote against the bill. She stressed if I were to vote in favor of it, I'd be condoning the thinking that you cannot have this change or reform without postponing the municipal elections. So again, those are opinions I brought in. They are independent senator, leader outside of a party, and also the Fourth Estate. But as I mentioned, we had the same excuses before. So we see legislative delay trumping our right to vote. And this can't be right. So we suspend democracy due to our failure to legislate in a timely manner. So I must say, we have to look at the passage of this local government bill, and it may really need negotiations between the government, the opposition, and really getting to the crux of what is needed, because it will benefit, and it can benefit our communities. I don't care, as I say, what minority or what Scottish judges say. I care about my right to hold councillors and their regional corporations accountable to properly serve my community. As I came here today, I heard thunder. Great clouds were gathering. And I looked and I felt a fear that our community in Real Spring Valson would be flooded again. We have challenges there. We have had challenges there. Rainy season is here. And I was wondering, could I call Councillor Seema to bother her? If there's flooding, could I call her now to get the sandbags and what, which we normally do? Could I call her to come and wash up? Could I call her knowing that she may not be paid? So therefore, this is why I support Clause 3, providing the terms of office of councillors, to extend and to provide it. They need it. So therefore, before I close, I want Mr. President to read a WhatsApp message I got from a councillor, and I direct through you, Chair, questions to the Minister of Local Government or the OG. And this is a concern by a councillor who I'm hoping somehow you could probably address. One question: the status of stipends for councillors, does it stop as of May the 18th? 2, will councillors and aldermen stipend continue until the announcement of the election date? 3, will stipend continue until the date of the election? Councillors also have staff to pay offices, rent to pay in their office. And they, this question is really to consider what exactly will be the position of councillors and aldermen on the commencement of this act. So I would appreciate if we could get that, answered, to at least give some feedback to the councillor who I know is listening to see what's happening in this debate. So I think we need this bill here today. I think we need to support our councillors. We need to support the corporation. We need to realize that if mistakes were had, we have to come in here and try to see if we could wrap things up, to fix things up, because fixing things is something that we need to do. We need to fix TNT to do better. We need to fix democracy to be better. We need to fix our councillors, and we need to fix our community. Thank you, Mr. President.
Senator Hislop.
Mr. President, thank you for the opportunity to join this debate. I won't be long, Mr. President, because I think we've exhausted, or I believe we've exhausted, I don't know if the opposition thinks we've exhausted everything, but I think we've exhausted all the clauses that we were to treat with today. But I just want to touch on a couple of things before I take my seat, Mr. President. I sat here today, and I don't know if it is because the arrangements have been changed in the chamber, but the screaming was a bit loud today and unnecessary, in my estimation. I sat there and I heard words as criminal and gang and kidnap, and I'm wondering, where are we? If we are really in the Senate chamber today. The level, the decibel level, if the EMA was supposed to do a noise pollution test within the chamber today, I'm sure that we would have been in breach of the law. Because for whatever reason, the UNC feels it necessary to shout, or the opposition feels it necessary to shout to get their point across. When you listen to Senator Vieira and even Senator Dial Singh and Senator Richards, and the level of contribution that came across the chamber today, the level of decorum was a true representation of what I believe the debate in the Senate should be. And no matter how loud the UNC shouts, when the election is to be called, it will be called. And I could say with no fear, the PNM is not afraid of any election. Was never afraid, will never be afraid of an election. And I don't know if they believe if they keep shouting it is going to be called tomorrow. But the Prime Minister is the only one who has that within his remit, and I know he will use his wisdom. I want to say, Mr. President, that when we talk about democracy, I heard Senator Mark and all the other opposition senators claim that this is an attack on democracy. But if you want to talk about democracy, talk about the PNM being the bastion of democracy from independence to now. We've had, Mr. President, we have had 60-plus parties fall at the feet of the People's National Movement in elections. So when you want to talk about democracy, you talk about a party that has been in governance in this country and has kept its record intact of calling elections and being part of the governance structure in this country. I want to ask, Senator Nakid kept shouting about licks and licks. I want to ask, how many elections have the UNC lost under the present leader of the opposition? Because so you beat us in the Privy Council, but how many, we tired beat all in elections. And we're going to come and beat again, because there's an old saying, or there's a phrase that became very popular in Tobago called, during a couple of those THA elections, beat and teach. And so the PNM has been able to teach. You see, there we go, there we go. You know, the Prime Minister said something this morning, Mr. President, that Trinidad and Tobago has been able, as a young democracy, has been able to manage its affairs without issue. We've had two little blemishes on our history, but when you look at Trinidad and Tobago's record with democracy, it is second to none in the Commonwealth, it's second to none in the world. We've had free and fair elections from independence to now, and you see, we're talking about the decorum again, Mr. President. You know, they have a love affair with the Privy Council only when they are in opposition. Because when they're in government, they want the CCJ, they want to get rid of the Privy Council. But whenever they're in opposition, they want to keep the Privy Council and get rid of the CCJ. You know, Senator Richard spoke about the government not seeing local government as important. I think the history books will show that, or I may have misquoted him slightly, but the history books will show that that this People's National Movement, this party, has been at the forefront of the reform of local government since the inception of local government to now. Our previous leaders, from Patrick Manning to even Dr. Rowley, has been at the forefront of trying to bring a level of governance into local government that is admirable, that the local government practitioners can be proud of being part of local government. You know, well, I wouldn't even speak about Senator Nakid because I have on my paper here, Mr. President, nothing. That's what I have. That's what I literally have written on my paper, nothing, because it was it was an entire contribution of nothing. It was a vacuum, and that was very unfortunate. I want to just share with us that what we hear about really and truly is about the reform of the local government system. We recognize that there is a significant shortfall with regards to governance. The delivery of governance at the local government level. Because the local government practitioners have recognized, or we have recognized, that the local government practitioners are the ones on the ground. They are at the forefront of service delivery. And it is only right that the government ought to give, or that any government should give the local government practitioners more authority, give the system more structure, because when you do that, it allows for a more efficient form of governance at the lowest level. And I don't even, Mr. President, I don't even want to use that phrase, at the lowest level, because that level is where governance is significant. Senator Diyal Singh spoke about, he saw the weather setting up and he's wondering if he can still call his councillor. And that's the reality for all local government practitioners. They're actually the first ones that the Burgess call before they call the MP and the ministers, because they are there with the people. And I can't see, you know, the opposition on the one hand says that they want to be for reform, but they don't show that by the way they debate, by the way they contribute, by the way they vote. Because if we're serious about reform, we would recognize, but I have this sinking feeling, Mr. President, that the opposition may be comfortable with the way the local government structure is. And it's sad that they may be comfortable, that the system may be broken and they may be comfortable with a broken system. When the government has been seeking, and the Prime Minister has been on record, that local government reform is one of the key things for this government. Because We recognize that if your local government system is working properly, then, and when you make the local government system more autonomous, the people on the ground feel it. The people in Real Springs and Valsayn and Barataria, they feel it because they are the ones who are affected when the drains are clogged and the garbage isn't collected. And this is one of the key, these are some of the key things that local government is responsible for. But you know, the opposition continues to talk about the PNM has a track record of suppressing the rights of citizens and all of these things. And I heard in the other place the opposition leader attempt to create a parallel between what transpired in the THA election, January, I think it's January 25th, 2021, if I'm not mistaken, and made the assertion that the government sought to take away the rights of Tobagonians by creating the 15 seats. And in her contribution in the other place, the Hansard says, I'm quoting from the opposition leader's contribution. How did we get here? The question is what she asked. This is not an isolated error. There has been a pattern of behavior. And the opposition leader went on to talk about, in the THA election in 2021, the PNM lost significant ground in the January 25th, 2021 election. There was a tie, 6-6. The PNM government, instead of utilizing the established procedure for resolving tie breaks, the PNM, in a stunning act of executive overreach, directed the EBC, and these are the words of the opposition leader, Mr. President, directed the EBC to carve out 15 more seats and kept the incumbents of the 6-6 tie that could have been resolved in the standing orders, that could have been resolved by recourse to the standing orders of this House. There is a provision that where there is a tie, you come to the standing orders of the House of Representatives, and that tells us how to break the tie. Mr. President, just to correct the record, first and foremost, you can't come to the standing orders, or you can't use the standing orders of the House of Representatives if the Tobago House of Assembly is not constituted. The Tobago House of Assembly was not constituted in the 6-6 tie. They were unable to elect a presiding officer, therefore the House was not constituted. So to use this and to even go further to say that the PNM, in a stunning act of executive overreach, directed the EBC to carve out. If I am not mistaken, and I'm sure the records will show, that the government came to the Parliament. The executive didn't direct the EBC to carve out 15. The 15 seats that were created, or the additional seats that were created to make 15, were done so from the standpoint that a recommendation came from the Tobago House of Assembly that this is where we want to go in terms of representation in Tobago, to move from 12 to 15. So when we talk about, Mr. President, I recognize Mr. Senator Mark is lost because he just came back into the chamber. So he's way off base in what I'm dealing with. And the point I'm making is that for the UNC to stand and say that the government is suppressing the right of the citizens of this country is far from it. Because it was the Prime Minister who went to Tobago and met with the representatives and gave them the options to work out something, to work out an arrangement for governance. And when that didn't happen, then the Parliament of the country had to act, because you couldn't allow governance to remain in a hung position, in stasis, for too long. And so, Mr. President, I want to reiterate the point that reform is what is needed with the local government system. And even when we were debating particular legislation a few months ago, we spoke about why I was the one who brought the THA model into the mix, to state that this is where the local government system in Trinidad should get to. And that's the thing about governance. Governance is an evolution. We have to evolve. We can't stay in one place for too long. The world is changing. And if we recognize that something isn't working, then we have to find another avenue for it to work. And if we have challenges in our local government system, then what this government is seeking to do, by all of these years of consultations and all of these bills that have been brought to the House, is to seek to create a better system of governance at the local level. The government wants to allow our municipal corporations to be more autonomous, to be stronger in its delivery. The Minister for Rural Development and Local Government spoke to the increase in the budgetary allocations, and I'm sure every single corporation will be grateful, including those who are not under the control of the PNM, and there may be some that the UNC now hold that will be lost in the local government election.
President, on a point of order, please. 53-1. Ask for your protection.
So, members, whilst the senator is making his contribution, we will just monitor the level of crosstalk. Continue, Senator Hislop.
Thank you, Mr. President. You see, whilst we are busy governing, Mr. President, all the UNC is concerned about these elections. You know, I've sat here the short time I've been in this chamber. All the opposition is concerned about is elections, and is elections for more licks. Because every single time the UNC has called for an election, what has happened? Especially under the present leader of the opposition, what has happened? We've lost the election. No, I don't have the power to call elections, and the elections will be called at the correct time, so don't worry.
Okay, all right, so the level of crosstalk, again, is getting a bit much, so much so that I'm straining to properly listen to the senator while he's making his contribution. So again, just monitor the level of crosstalk. Continue, Senator Islam.
Thank you, Mr. President. You know, I recognize Senator Leiter's enthusiasm. I know he's ready to get into the debate to shout, because that is what has been coming from. See, there we go again, Mr. President. Unnecessarily so. But I'm not going to be much longer, Mr. President. I'll wrap up shortly. So when we talk about, we've spoken here all day about what this legislation is seeking to do. The legislation is seeking to validate what has been done by the councillors within a particular period, and as a responsible government, we all know what happened in the Privy Council. There's no need to keep rehashing that. As a responsible government, we've come back to the Parliament, Mr. President, to validate, and so that the work of local government can continue. The elections will be called. The Prime Minister, I'm sure he knows the date, and he will announce the date for local government elections, and the PNM will be ready. The PNM will be ready as always. The only national party in Trinidad and Tobago is the People's National Movement, because when you could not win in Tobago, you chose to send a proxy, right? So the only party, the only national party, will be ready for elections. We will contest every seat, and we will win the next local government election. Mr. President, I thank you.
Senator John.
Mr. President, I intended to speak, and then I decided not to speak. But I heard the senator from Tobago, the younger senator from Tobago. So the older senator from Tobago had to get up and also make an intervention, you know. Well, you see, the Tobagonians have a soft spot for Tobagonians. I must confess, only one Tobagonian I have no soft spot for. And I heard my young senator from Tobago trying to rewrite history, and I suppose in trying to support his team. So I couldn't leave it on the record saying that it had to do with Tobago's business. But Mr. President, prior to just making the few points that I think I want to make today, something happened in the chamber earlier, and I was in the Senate in 2001. I think there's some advantage of living a little longer. And I really have never seen the Senate descended to the level it descended today. And I think that is why I didn't want to speak again, because I was so shaken by it. Because the opposition is not here just to oppose, but the opposition has a role, and the role is in the Constitution, actually. And it's only 6 of us. And we have to come, just as the government and independent whoever, they work on behalf of whoever sent them here or whichever interest they serve. We have to come and serve that interest also. And if our style sometimes a little vociferous and what have you, it's because we're not government, we are the opposition. And we really have to get our points across. And I think today Senator Lakshmi Dayal was at her very, very best, very excellent presentation. And really to have had the attack, you were not sitting in the chair at the time, Mr. President, but was really the lowest common denominator that I've ever seen exhibited in this House. And for that, if the PNM will not apologize to Senator Lakshmi Dayal, I'll apologize to her. Because I just think it was shameful. I'll excuse the Honorable Government Senator of maybe say she's suffering from, she's probably suffering from newness, and we'll leave it there. But Mr. President, you know, the bill, everybody went over what the bill was meant to do, and so I will not belabor that, that point. You know, I suppose people were very concerned, so they started to count their 10 fingers and their 10 toes, but that doesn't change anything. And as I've said, you know, just say you've made an error and let's move on with it as it were, because we know this is not about local government reform. You know, it really is about the PNM trying to extend their shelf life and trying to avoid the electorate. But that, you know, the Privy Council judgment was very, very clear, and no matter how we dress it up, it is what it is, you know. And really and truly, once I looked at the Honorable Attorney General's press conference, as did a large majority of people, citizens of this country, and I was astounded by what he had to say. Notwithstanding, I think he made one comment that he is not a politician. He's an attorney. And I think it is good that the Prime Minister is a better politician than maybe the Attorney General is an attorney, because at least the Prime Minister accepted the judgment and decision of the Privy Council. He didn't count his 10 fingers and 10 toes and so on. He said, I accept it. Now, what we want the Prime Minister to do is to go further and to take the election date out of his back pocket and call the election, because that is what is required at this point in time. So, Mr. President, we are here today because of the government's, well, I don't know if it is deliberate incompetence or manipulation, as it were, because we know, we have sat in these very benches, and every time a new piece of legislation comes, we always have to say, who is this targeting? It's always we always suspect it is some kind of ad hominem legislation, or it is something that will breach the Constitution. It doesn't skirt anything. We come here just like everybody else to work in the same manner in terms of in the interests of the people. And certainly, if the opposition says this is infringing on people's rights, you understand? We are not doing it to be obstructionists, as we are called. We are doing it because we believe that it is wrong. And certainly we'll bring the amendments, which are never taken up, and that is why we are here today. You understand? Because we have a government where that stick, as we say in Tobago, break in the ears. And a good Tobagonian president would have said, who preceded us and the honorable senator from Tobago, he would have said, habits grow in slow degrees, stream into rivers, into seas. And I believe in these old sayings coming from Tobago. That is where my value system is embedded. And he said, so things happen day by day, you accept them, and they keep creeping up until you are overwhelmed. You don't do anything more about them, it is the accumulation. Bad habits growing by slow degrees. And that is what we are seeing manifested here. So much so that people feel they could jump up and tell Senator Lakshmi Dayal, such an excellent representation of young talent. You don't have to agree with her, but certainly you don't have to go where the senator went. Yeah. I am really appalled. I tell you something, like me, I'm very strong. And certainly I was shaken to the point that I told Senator Mark, I'm not going to speak again. You can't do that. So, it's really what we do here. We argue and we certainly debate. Right? So today, as I said, the poetic word of our former President Robinson, it is coming back. But I just stood to talk about the THA election of 2021. Mr. President, the PNM would have lost significant ground in January 25th, 2021 THA elections when they had a 6-6 tie. Now, looking on, I felt as a senior statesman, and the Prime Minister being from Tobago, would have engaged the folks who would have been on the opposition side at the time, because there was a PNM administration in the THA. That did not happen. The Prime Minister found himself in January of, I think it was 2021, the 19th of January, if I'm not mistaken, and he brought a bill to the Parliament. Now, what he brought, in fact, was, there was a report from the EBC, report number 13, when in October of the preceding year, there would have been a report number 12. Now, that report would have said you have 12 electoral districts, that is all you have. I mean, a lot of the EDs would have grown just by 450 votes, what do you call them? Registrant, electoral registrant or something like that. So it was negligible. And they said in October of 2020, there is no need for any increase in the electoral districts. Lo and behold, on the 19th of January, and I stand to be corrected by the date, there was the Prime Minister himself piloting this bill to say, well, there is now 15 seats. That is what he did. What do you think that was? That wasn't normal. There was nothing in law that said that where this 15 seat came from. And as a matter of fact, Mr. Martin Daly in the Express of the 11th of December, that was after the election, he said, and I'm going to kind of paraphrase here. Not paraphrase, I'm going to read, but parts of it. Rafts of persons in both Trinidad and Tobago, journalists, economics, lawyers, and other professionals, as well as professional and trade associations, have been frequently verbally abused. So this is not a one-off, This is the way the PNM behaved when they are cornered. Yeah. You understand? This is Mr. Martin Daly, senior counsel. This is a real silk, You understand? And he said, Farley and his troops show that dissent, despite relentless personal attack and victimization, is alive and well and capable of being converted into electoral victory. Mr. Martin Daly, the PDP came into the political playground and gave a good carpet back to the political playground bullies on behalf of the victims of bullying. Many of these victims are ordinary citizens. That's what played off here. When the PNM cannot win, they take up their ball and they want to go home, they want to mash up the place. They say many of these victims are ordinary citizens, prejudiced by the acts and omissions of the constitutional bodies, which are supposed to provide checks and balances against abuse of power, but seem to have become less than robust under authoritarian pressure. These are third-party validated, this man, he writes in the papers, he's not kind to the UNC. He said, but it seemed to have become less than robust under authoritarian pressure. Important constitutional processes have been compromised as a result. He was talking about the Tobago election. This is Mr. Martin Daly. I'm just going to go in for a short part again, Mr. President. He's saying in relation to the increase of seats in the THA, and in response to other legitimate inquiries about the basis of decision it makes, the Elections and Boundaries Commissions had not been as forthcoming as it should. He said, I am yet to understand the constitutional basis on which the government required the EBC to make boundary changes in Tobago simply in order to break the 6-6 electoral tie that occurred in January. So, Mr. President, this is not a one-off for this government. This is the way, this is their habit, this is the practice. If they can't, by hook or by crook, they will get their way. And really and truly, it is not right, as the Honorable President Robinson has said, habits grow in slow degrees. And that is why every Monday morning, the UNC have this government in front of the courthouse because they don't listen, as I said again and before, stick breaking their ears, everything is a complaint and an argument, or they throw vile, personal attacks at people as if people mouth stitched down. But, so Mr. President, rather than utilize the established procedure for resolving tiebreakers, the PNM, in a stunning act of executive overreach, directed EBC to carve out the 15 seats. That's what I spoke about in Mr. Daly's article. And then it went on for almost a year, where really and truly the government was willing, they accepted that the THA could have ran without the resolution of the 6-6 tie right into December for one year, But what happened in early December of 2021? They lost the election, as will happen when the next local government election is called. The people are fed up and they're sick, and the more we try to twist and turn and change things around and try to bring the spin, it's just not working. It is just not working. So what the Prime Minister needs to do is really to take this election date out of his back pocket and to call that election, because that is what the people are asking for, that is what they are calling for in terms of resolving this issue. The Law Association, again, these are independent people. They can't say that these are people who are what? Everybody's UNC. So the Privy Council judgment, Mr. President, serves as a powerful lesson to the government. Mere general and ambiguous language is woefully inadequate when it comes to matters as critical as good governance and democracy. Right? It is crystal clear. The right of electors to elect their representative is no minor point. As everybody's talking that this could have been wrapped up in 5 minutes. You understand? They want us to come to this parliament and put our tail between our legs to sit down and then run away with this country. Run away with this country. But we are not going to have that. We are not going to have that. We are asking for no quarters and we are giving none. We are going to stand our ground and we're going to push back on behalf of the people of Trinidad and Tobago. Right? So, Mr. President, this ruling serves as a reminder that we, the people, expect a higher standard from those who enact our laws and those who are trusted with the responsibility of governing the state. So now that we have cleared all of that, as we urge the government to abide by the rule of law principle that is enshrined in our Constitution, and that law dictates that the government call the election now.
Senator Welch.
Mr. President, thank you for giving me the opportunity to speak on this Municipal Corporations Extension of Terms of Office and Validation Bill 2023. It is a short bill. It only involves 5 clauses, and the clauses themselves are fairly brief clauses. But it is, nevertheless, an important and a significant bill which needs to become law as soon as possible, and it is a necessity for practical purposes. Otherwise, we will have an impractical situation developing, and this bill has been brought here for the very reason of the implications of the Privy Council decision in the matter of Ravi Balgobin Maraj. Therefore, I can say offhand and from the very inception that this bill has my full support. I will vote yea when the time comes, because it is a necessary exercise. So I am in the government's camp on this one. But, and there is a but, although I am in that camp, it does not necessarily mean I am the happiest of campers. And I will explain why. It doesn't mean that I'm around the barbecue pit, barbecuing and having drinks with the other campers. I am there because it is necessary. But having regard to the history of how we have come here, there are certain aspects of the journey which I am not at all satisfied with, which has brought us here. And let me explain. First of all, Mr. President, and I will be fairly brief, I am sure. First of all, Mr. President, let me just look at the provisions very quickly before I get to the point I had just made. According to Clause 3 of the bill, the terms of office of the councillors and aldermen, which expired on 2nd December 2022, are hereby extended until the 18th of May 2023. The Privy Council has ruled that that term of office expired on the 2nd of December, effectively. However, there was the mistaken assumption and the premise that it did not expire, and those persons continued in office until such time as the Privy Council, by its decision of 18th May, made that clear. However, they would have carried out very important functions. They would have carried out very important responsibilities. And therefore, it is necessary to ensure that what they would have done between the 2nd of December and the 18th of May is validated. And the only way it can be validated is by this bill becoming law. The bill is also important, that extension is also important because on the 2nd of December 2022, when the terms of office of aldermen and councillors expired, an election would have become due within 3 months of the 2nd of December 2022. That would bring us to somewhere about March 2022. The time to validly hold that election has since passed, and one cannot go back in time because one counts the 3 months from the date of expiration of the term of office, which is the 2nd of December 2022. The only way one can revive and make viable an election period is by the extension of the office, the expiration of that office from 2nd December to 18th May 2023, so that a new 3-month period to hold the election would now begin from May 2023 and therefore expire in August. So that's another reason why this is important. Clause 5 of the bill is important as well because it provides, which I mentioned before indirectly, for the validation of all acts which occurred after the lawful expiration of the office by extending the period of the validity of that office. All acts are now made valid by the Clause 5 of the bill. And I also want to commend the Attorney General with respect to Clause 5, because it certainly saves some of the time I had proposed to spend dealing with this. because I intended to try and convince the Attorney General that that phrase and thereafter exercise the functions of councillors and aldermen up until the commencement of the Act. It was my intention to try to convince the Attorney General that that is incompatible and irreconcilable with the provisions of the bill itself. And secondly, it is also a violation of the de facto doctrine, and therefore it needed to be deleted immediately. From my observation of what took place in the House, the Attorney General has defended it. But on this occasion, in the Senate, without any opposing contribution, he has accepted the impracticability of this clause and its irreconcilability, and of his own volition after sober thought has indicated that it would be amended by way of deletion and withdrawal. So there is no need for me to go further on that issue. What concerns me, though, is that if the intention is that the extension of the term as effected by the municipal corporation, as effected by the Miscellaneous Provisions Local Government Reform Act, if the extension of the term from 3 years to 4 years for councillors and aldermen were intended to apply to the incumbents as well, then it is important that this be made clear in the provisions because of the significance of its impact, which constitutes the postponement of an election, the postponement of a democratic right, even though it may not be a constitutional right, it is still significant as observed by the Privy Council. And if one is thereby extending that term, it seems to me that there is a corresponding duty in drafting this legislation, this act which effected that amendment, to make that expressly clear. However, that was not done. But I respect the fact that it is not every situation that one anticipates in advance. It is not every situation that one caters for in drafting provisions, and it is only when there is a legal challenge one may come to realize perhaps this should have been made more clear and more precise in its terms. But I'm afraid it seems to me, however, that there was sufficient notice before this provision was enacted that there was a need for some clarity with respect to it. Because I have listened to Senator Mark, I have also followed some of the observations that were made in the lower house with respect to this matter. And from what I have heard and the quotations from Hansard that I have heard, it is evident that during the piloting and earlier debates of this bill in, let's say, 2020 and thereabout, and in 2019, the issue was raised as to whether what is proposed here would apply to incumbents, or whether it was only intended to apply to future councillors. This was before the act was passed. So therefore, it would have become clear at that point in time that it was not expressly stated to apply to incumbents. It was not made clear if that was the intended effect. before the bill became law. And therefore, that was an opportunity there and then to actually address the matter and fix it during the process of debate. And it would have only required 3 or 4 lines to say this provision is intended to apply to incumbent councillors on commencement of this act. It would have only required a few words to say that. However, the position taken by the position taken by the Attorney General then and at the time was that it was not so intended to apply to incumbents. And therefore, in those circumstances, the amendment was made, it became law, without any express indication that it was intended to apply to incumbents, because the Attorney General at the time, according to the Hansard that was quoted from by Senator Mark, indicated that there is no intention to postpone the elections. And if indeed that was the thinking at the time, that it was not intended to apply to incumbents, that is perfectly reasonable. Because quite often, the intention when legislation is passed, unless it is stated otherwise, is that it is not intended to have retroactive effect. It is also reasonable in the sense that if one is bringing such a new measure, one may not intend to impose it on an existing situation, but wait until the term of office has expired and then allow that new measure to take effect, the 4-year measure to take effect from that moment when new local government elections take place. So it appears to me that if it were the intention of the government at that point in time, that it would apply only to future councillors, that was not an unreasonable position. It is quite reasonable because, as the Privy Council said, to apply it to incumbents and postpone a vote by is, to some extent, a violation of the statutory democratic right of a voter. So the man on the priority bus could be forgiven for thinking that when in November 2022, this act was passed, the Miscellaneous Provisions Local Government Reform Act, amending the term of office of councillors and aldermen, taking effect from November 22, it was intended that it would apply to future councillors and not the incumbents, so that when the incumbent's term of office expired in early December, that expiration would take place and a new set of councillors coming in would serve for 4 years. However, the position was clearly taken, and again, the man traveling on the priority bus route would be forgiven for thinking that the government, in its wisdom perhaps, in November 2022, decided for practical reasons, and it may well be for good reason as well. I'm not doubting the bona fides of the government on the issue. It may well be for good reason to postpone the election by a year, and the passenger on the priority bus route might think, as the government worked out, how can we effect this postponement perhaps as an afterthought it was felt that you see this Municipal Corporations Act, we can enact it and argue that its terms apply to the incumbent. Whether that was the thinking in the first place doesn't appear to me to be very clear on the evidence. It appears that that thinking about the interpretation of the provision originated when the decision was taken to postpone the election by a year. And again, I emphasize, not to deny anyone their vote. The government is there vested with the authority to act for good governance and peace. And their policy, I accept as a presumption that their policy decisions are based on that principle. But in the final analysis, the effect of it is that when this became law, the government was relying on a provision which did not make it clear in express language that the term of incumbents was extended by a year, and because it did not make it clear in express language, and because it did not use the opportunity to make it clear, so clear, it now found itself in a position of having to argue that that is the interpretation by necessary implication, or by looking at the statute as a whole and by comparing its other provisions. But the lesson is, where things can be made clear, they should be made clear, and one should not have to rely on the principle of necessary implication. So, going on the principle of necessary implication, an assumption that the provisions would apply to incumbents, it was enacted. They remained in office until up to October the 18th. And then the Privy Council ruled that that interpretation was wrong. The government acted on an incorrect premise in putting this legislation into effect, that it only applied to future councillors. I have heard in this chamber and outside of this chamber as well as even by non-lawyers, forceful arguments. I say forceful only to indicate not necessarily its merit, but the verbosity of it, to the effect that the majority got it wrong. It has even been taken to the majority in the Privy Council got it wrong. It has even been taken to the point where, to the extreme where, one started adding up the amount of judges in the Court of Appeal and the High Court and the dissenting judges in the Privy Council and saying they exceed the number of the majority. That is an argument which is surprising and which is without merit, and it is something which one ought not to be getting into the back of and advancing. It is almost a violation, I would say, of the rule of law and the principles. The fact is The Privy Council is our apex court. It is the highest court. The fact is, a decision of the Privy Council can be a unanimous decision or a majority decision. Whether unanimous or in the majority, it is the same effect. And where that decision is in the majority, I submit and advance that it is out of order to be delving into the scrutiny of it and trying to undermine it and question it and suggest my legal reasoning is superior or that of the dissenters, and it is wrong. That is a violation of the court system, the rule of law, and the constitutionality of the system of justice. And it is the first time I have to say, in my relatively short 36 years as a practitioner, I have ever seen an approach like this. I do not condone it, and I do not associate with it. And I dare say that it is wrong. And Mr. President, one final point on that issue is that I would not try to dignify that approach by trying to show the attractiveness of the judgment and reasoning of the majority compared to the minority. I agree with the majority decision, but that is enough, that it is the majority. There is no room for further scrutiny. It is sufficient to say that is the majority and that is what prevails. So rather than undue scrutiny, what the principle now is to learn from that judgment and the lesson to be derived from it. And that is where we collectively in this parliament going to pass legislation and intend it to have certain effect, especially if it is a significant effect. We must scrutinize it and ensure that it is plain, it is clear, and it carries in its terms the effect we intended to have, rather than relying on this principle of implied and implication by necessity. And that is what we must take from that decision going forward. And it is a point which I made on earlier during a debate this year, and I just digress to make the point, Mr. President. Perhaps it was not on legislation which was being prominently featured as this bill, but it is a point which I made, where there is the opportunity to make something clear, make it clear. And that was during the debate on the Firearm Amendment Bill, where I have not gone to the extent of trying to find Hansard and that sort of thing, but where the Hansard would reflect that I expressed my concern that when it comes to the issue of tasers, if what the Parliament is doing is trying to include tasers within that framework and that definition, then it should expressly come out and say so. And it does not take anything more than 2 or 3 words to actually do it. I had expressed that concern on that occasion because in order to come to the conclusion or the opinion that tasers are within the Firearm Amendment Act, you had to take one provision, add it to another, and take 3 words out of a third provision, bring them all together, and come to that conclusion. So it is a warning which I give, and it is a warning which I warn myself because there is a principle of collective responsibility in this parliament, which includes me, that we need in the future to be conscious and be careful of legislative measures and their meaning where it can be made clear. Do not let the opportunity pass. We ought not to feel any embarrassment or shame over the fact of what has already occurred, because it is not unusual that things are not anticipated, and it is only when the court gives guidance we tend to appreciate with hindsight what could or needed to have been done. Except in this case, as I pointed out, having regard to the history which Senator Mark had pointed out as to the interchanges between the leader of the opposition and the then Attorney General, I see that as a prime opportunity to have taken measures which would have led to us today using this time perhaps to debate something else. I would wish to make just one or two other points, Mr. President, in point form. And one is this. It has been referenced to the fact that postponements have taken place in the past, extension of terms, etc. But I am pretty sure, even though I have not had the time to examine them since they were raised here, they were done in a manner which made the position clear. So it is not an argument in support of what occurred here to say, well, this has happened in the past. Because with closer scrutiny and examination, we might find that in those instances in the past, a more clinical approach had been taken. Another point I would wish to make is that we keep speaking of just extension of the office, an extension of the office by 3 years to 4 years, and perhaps that is throwing one off from the real significance and impact of the decision. It's not just the extension of the office, 3 to 4 years, but it's the consequential impact, which effectively that leads to, which is the postponement of the election. That is the pivotal matter when it comes to that. And the democratic right which is being spoken of as being violated. So, Mr. President, again, I say we move forward. I have no doubt in my mind that these comprehensive changes have been made with good intentions by the government. I do not regard it as some deliberate attempt to violate anyone's rights or any such thing. It forms part of an entire package of local government reform, significant, which looking at the previous legislation as a whole, the Local Government Reform Act, the several amendments indicate a lot of thought, a lot of time has gone into it, and I commend the policymakers for that effort indeed. But as I've pointed out, and will do again, good intentions are not enough, because as good as your intentions might be, if what is produced amongst a spinning top in mud, in the sense that we have gotten nowhere and now we have come to rectify the past, then effectively you are taking 2 steps forward and 10 steps backward. So we need to match good intentions with good legislative action. And when use every opportunity that provides itself to put legislative measures in place which effectively carries out that good intention. You cannot be sloppy about it. You cannot ignore advice, no matter from what quarter it comes, whether it is the opposing side or whatever. Wherever you get that notice from, you act on it and take it seriously. And this is why I went into the example of what occurred when the bill was piloted in 2019 and 2020 to demonstrate there was enough time and opportunity before it became law to rectify, because it was brought to your attention. So we are where we are, and no one can change that. And because we are where we are, and we need to rectify the position, I repeat, I am in the camp of the government with this bill and will vote yes to it, but I'm taking my corner in that camp and having my beer and barbecue chicken all by myself. Mr. President, this would be all.
Attorney General.
Thank you, Mr. President. We've had a long day, and I do not propose to be long. Let me acknowledge the quality of the contributions that we've had today, in particular the contributions from the independent bench. And perhaps I should begin with the last member of that independent bench, Senator Welch. I thank him for his unequivocal expression of support for the bill which we are here today on. But let me make it clear at the same time, as appreciative as I am for that reasoned, sensible, and commendable decision that I part company with Independent Senator Welch if, and perhaps I misunderstood him, if the suggestions that fell from his lips were to suggest that freedom of speech in this hallowed chamber is restricted. Because I think that one of the most important qualities of the contribution which we must bring to this chamber in particular as an expression of the freedom which we exercise throughout the length and breadth of this country is the right, respectfully, to exercise freedom of speech, to make commendation as well as criticism. And therefore, I start my wind-up by repeating what I have said throughout my pilot, and it is to say that this government accepts unequivocally the decision of the majority of the Privy Council, and it is why we are here. But in saying that, I do not relinquish, either on my own behalf or on behalf of others for whom I have great respect, the right of those persons to say that I depart from the reasoning even as I accept it, because the nature of the civilization which we proudly belong to and which we are committed to improving with every breath in our body is to develop and evolve our capacity to better ourselves. And one of the most unique ways in which we who belong to the species of Homo sapien can advance is to exercise that God-given right of thinking in acute, critical terms to develop our capacity to build, to evolve, and to better our civilization. So, as much as I accept, and on behalf of the government proudly proclaim, that we accept the decision of the Privy Council, and we are here for that reason, I do not for one moment accept that it is not my right to say why, as accepting as I am, it is yet a decision that I have difficulty with for reasoned decisions, which I'm always happy to discuss with my good and learned friend, Senator Welch. Moving on from that, I pay tribute to the other contributions which have been made, Mr. President, by those other senators who have spoken today. And I welcome the endorsements that I have listened to from the independent bench who have articulated their critical support, and I accept critical support. I think that there are just one or two things that I will dwell on very briefly, because as I said, I don't intend to prolong my wind-up this evening. One of those is to correct something that Senator Mark, in his usual impassioned terms, I think allowed himself to say, which was that the government, or rather the opposition, had made a proposal in the other house with reference to deleting clause 5. And I just want to put on record that the understanding which is recorded in Hansard, and I took the trouble before coming here to order a copy of Hansard. I'm not going to read from it, but I will simply make reference to the page numbers. It is the unedited urgent request copy of Hansard of the 29th of May 2023, and it records all the contributions which we made in the other place. And the record will show unequivocally that the Leader of the Opposition, Member of Parliament Saddam Hussein, Member of Parliament for Barataria San Juan, Member of Parliament for Chaguanas West, Member of Parliament Siparia, all recommended, and this is where I think I need to correct the record, that Clause 5 be deleted in its entirety. There was no suggestion from the opposition in the other place for any amendment to Clause 5. And indeed, the amendment that is sought to be made in the House today by Senator Mark is exactly that which was recommended in the other place by the opposition, the entire deletion of Clause 5, which is a far cry from the recommendation that I will be moving at committee stage for an amendment of a part only of Clause 5. So I just want that to be correct for purposes of the record. The pages of the Hansard that I have that record the other side's contribution are pages 34, 76, 87, 103, and 104. And they are there to be read by those who would take the trouble to read them. The other point that I would make, Mr. President, very briefly, is that there is, and I say this in response to an invitation that came from Senator Dayal Singh, there is a clear position, and this is in answer to the question that he said had been sent to him and he was hoping that some assistance would be given. There is a clear position fallen from the Privy Council. The amendments that were proclaimed do not apply to incumbents, and with effect from the 18th of May 2023, the offices came to an end. The whole purpose of this validation bill is to give life and continued efficacy to the acts and functions of those officers whose terms came to an end with the decision of the Privy Council of the 18th of May. So I hope that that assists in answering the question which concerned the member of his municipality who wished to have the position clearly articulated. I want to commend the other senators on the independent bench for their clarity in accepting the fact that the three objects of this bill are very clear, as Senator Vieira and others have articulated. And therefore, Mr. President, without any further ado, I thank you and I beg to move.
Honourable Senators, before I continue on with the procedure, I would ask the Acting Leader of Government Business to, at this point in time, move the requisite procedural motion.
Thank you very much, Mr. President. In accordance with Standing Order 14.5, I beg to move that this Senate continue to sit until the completion of the business at hand, inclusive of the matters on the adjournment.
Honourable Senators, the question is that this Senate continue to sit until the completion of the business at hand, inclusive of the matters on the adjournment. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate will continue to sit until the completion of the business at hand, inclusive of the matters on the adjournment. Honourable Senators, the question is that a bill entitled An Act to extend the terms of office of councillors and aldermen elected in December 2019, to provide for elections in 2023, and to validate the actions of the said councillors and aldermen between the 2nd of December 2022 and the 18th of May 2023 be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
So an act
Act to extend the terms of office of councillors and aldermen elected in December 2019 to provide for elections in 2023 and to validate the actions of the said councillors and aldermen between 2nd December 2022 and 18th May 2023.
Attorney General.
Thank you, Mr. President. In accordance with Standing Order 66-1, I beg to move that the Municipal Corporations Extension of Terms of Office and Validation Bill 2023 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the Municipal Corporations Extension of Terms of Office and Validation Bill 2023 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Okay, honourable senators, there are 5 clauses and a preamble in this bill. There have been 2 circulated amendments thus far, one from the Attorney General in Legal Affairs, as well as another from Senator Mark. So those are the ones that we have, and when we get to the respective clauses, we'll treat with those amendments. As such, we shall now begin.
Clauses 1 to 4.
The question is that clauses 1 to 4 stand part of the bill. The question is that clauses 1 to 4 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 4 now stands part of the bill.
Clause 5.
The question is that clause 5 stand part of the bill. We'll start with Senator Mark's amendment. Senator Mark?
Yeah, Mr. Chair. Under clause 5 of this bill, the government had knowledge of this Privy Council judgment 3 days before its issuance, formally, on the 18th. The government had sight of the Privy Council's judgment, an embargo judgment. So the Attorney General was fully aware of this judgment before it was issued on the 18th of May 2023. The government sat on its laurels for that entire period, allowing councillors and aldermen to function, knowing fully well that the Privy Council had determined that they were operating illegally from the 3rd of December right up to the time when that judgment was handed down. So here it is, Mr. President, Mr. Chairman. We were saying in our proposal to delete clause 5 that at the material time when this clause was placed in this piece of legislation, the government knew and they facilitated, right, this particular, don't tell who said I say 3 times.
Intervention.
Yeah. So what we are saying, Mr. Chairman, is that the government and so on simply committed an illegality for the entire period up to this time as we speak. And the government is guilty of not acting properly. And they showed utter contempt for the Privy Council's judgment. And they have now come to this Senate to try to undo what they knew all along they ought to have done. And that is cut off all councillors and aldermen from carrying out any future functions after the 18th and allow the CEOs and the mayors and chairmen to carry out those functions as they are going to do, Mr. Chairman. So what we are suggesting is that this illegality that this government has engaged in is unacceptable, and the opposition will have no part of that arrangement that the government deliberately, calculatedly, and premeditatively executed and allow councillors and aldermen to carry out illegal actions and take decisions when they knew, Mr. Chairman, that the Privy Council judgment was in their possession 3 days before the 18th. On that basis, we are advising that this entire clause be removed.
Senator Vera.
Thank you, Chair. Mr. Chairman, through you, I'd like to ask Senator Mark, just for my own edification, if we were to go along with his proposed amendment to delete Clause 5, what effect would that have on the municipal corporations, and what would be the position regarding the work done in those municipal corporations since December 2022?
Yeah, Mr. Chairman, I'm saying if you look at Clause 3, you'll see where Clause 3 captures the terms of the office of the councillor, right, and aldermen, which expired between this period, I hereby extended until the 18th of May. Thereafter, the offices that are supposed to be alive are the offices that are in the MCA, which is, Mr. President, whenever the offices of aldermen and councillors expire under the law, it is the chairman, the mayors, the deputy mayors, and the administrative staff, inclusive of the CEO and administrative officers, who conduct and execute the duties of the 14 regional corporations. The government, through the Attorney General, has to explain to this Parliament and to the country why did the government not take action to uphold the Privy Council judgment and the law, and why they sat on their laurels for almost 1 week and a half. I remember reading in the newspapers where councillors from the PNM corporations were saying they were conducting business as usual. And the reason why they were doing that is because the Attorney General and the Minister of Local and Rural Development never contacted these people and issued an order. That is what's happening. And they are coming here to get the Parliament
Mr. Chairman, I object.
to deal with an illegal.
No, it's re-debate.
So, again, members, there's a simple procedure that we follow, that the mover of the amendment is allowed to indicate why, briefly, as to why he's moving that amendment. Senator Vera has asked a question to which Senator Mark has responded. We have Senator Dunarine who wishes to make an intervention, as well as Senator Lakshmi Dayal. I will ask the AG just to respond at this middle part, and then I will allow Senator Dunarine and Senator Lakshmi Dayal to contribute. Attorney General.
Thank you, Mr. President. My request to intervene is really to ask clarification from Senator Mark, if I may.
Well, I will allow you to do that when everybody has said their piece. It will make it much more efficient, because then you can respond to everybody at one time.
Well, not the clarification I seek to get from Senator Mark, because it's clarification that's only in his knowledge.
Okay. Continue.
Would Senator Mark please advise me, how is it that he has come to the information that tells him that the government was in possession of the judgment 3 days before it was publicly released? Could he please advise me of that?
Senator Mark.
I am not compelled to answer the AG on any matter. I am not compelled to answer you on any matter.
No. All right, so question asked, answer given. Senator Dionarine.
Thank you, Chair. I have a question to Senator Mark, because I myself am seeking clarification. In the event that we accept this proposed amendment by Senator Mark to remove clause 5, my simple question is, what exactly in this act or in this bill would speak to validating the actions of these aldermen and councillors for the period in which the act is dealing with, December 2nd, 2019 to May to the 18th of May 2023.
So that's a similar question asked by Senator Vera, to which Senator Mark did respond. As far as I remember, he spoke to clause 3 in his opinion specifically. Go ahead, seek further clarification. Do you need further clarification?
Yes, thank you, Chair. And clause 3, in my respectful view, speaks to the terms of the office, not necessarily the actions that was done or executed by these councillors and the aldermen. So I am just seeking clarification.
Okay, so I'll allow Senator Lakshmi Dayal before Senator Mark responds to that, and then the Attorney General will close off with his final response to comments made. Senator Lakshmi Dayal.
Yes, thank you, Chair. It is not the terms of the office, as in terms and conditions that's being extended by paragraph 3. It is the terms of office. If your office is extended to the 18th of May, then everything you do is valid. This clause 5 was inserted there because there was an attempt to now rectify what transpired after the 18th of May, when there was no clarification given and certain things were done. And then, even more dangerous, and the issue raised by the opposition and the concern we had was about up until the commencement of this act, meaning that there was need for assent and so on, so that councillors and aldermen may have been able to continue to function, and we may have been validating things that could have happened yesterday, when councillors and aldermen may have been doing things. We are not inside of every corporation. So this entire clause 5, if you were to take off now what the Attorney General is proposing to take off, having been called out on it, and you're taking off and thereafter exercise the functions of councillors and aldermen up to the commencement of this act, then clause 5 would sort of be superfluous, because the office is saved to the 18th of May. With respect to how the knowledge came about the embargo judgment, I just wanted to respond to the Attorney General's concern. If Senator Mark doesn't want, I will. It was made in a comment by Mr. Martin Daly in the media, appearing on the news on the 19th of May, the day after the decision was handed down. He spoke about embargo judgment and questioned why the government did not act when they had knowledge of it prior. So I just want to put that on the record, since the concern was raised.
Okay, Attorney General.
Thank you, Mr. President. Thank you very much. I'll say 3 things, Mr. President. One is to delete the clause in its entirety, as Senator Mark requests, would be a very dangerous state of uncertainty, and I entirely reject the request to delete the clause in its entirety. I do that here, as I did in the other place when precisely the same amendment was sought to be made. The second thing that I say is that I can't speak for what newspaper columnists or other persons speak to the extent that Senator Lakshmi seeks to answer the question that I asked Senator Mark, that is to say, what was his source of information that the government was in possession of the judgment. What I can say is that I had been advised by the attorneys for the state that they had been issued to the attorneys a draft judgment which they were not allowed to disclose to clients, and it had been disclosed to the attorneys for the purpose of the attorneys stating whether there were any grammatic or other corrections to be made to the judgment. And there was a very strict contempt of court embargo. I was advised by the attorneys representing the state that if they even attempted to disclose the judgment to the client, which I represented, or discussed its terms, both the client and the attorneys would be held in contempt of court. So that's why I'm very interested to know how Mr. Senator Mark is seeking to interrogate me about my knowledge of a judgment which his knowledge of is tantamount to being in contempt of the Privy Council.
No, Senator Mark. Enough. Minister of Tourism, Senator Mark. So all comments have been responded to by the Attorney General. Senator Vera, is this something new?
Yes, Chair. Well, I had asked a question of Senator Mark earlier, but I just wanted to comment that my understanding of Clause 5 is that it addresses a concern that was raised by the Privy Council about the bill not having transitional provisions, and that the reason we need to maintain Clause 5 is that it is in fact a transitional provision clause.
So I shall now put the question. Honourable Senators, the question is that Clause 5 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no. No. I think the noes have it. Okay, so Honourable Senators, we shall now put the question to Clause 5 in terms of the AG's amendment. So AG, I'll allow you to make your comments in relation to that.
Thank you very much, Attorney General, Mr. President. Thank you very much. I beg your pardon. The amendment has been circulated, and if we go to the third line of Clause 5, the third line of Clause 5 begins with the 18th of May 2023. The words thereafter to be deleted are, and thereafter exercise the functions of councillors and aldermen up until the commencement of this Act. So those words should be deleted so that Clause 5, if those words are to be deleted, will read, where the councillors and aldermen under Section 3 exercised the functions of councillors and aldermen between 2nd December 2022 and 18th May 2023, the exercise of those functions and all acts or things done pursuant thereto shall be deemed to have been as valid and effectual as if the Municipal Corporations Act expressly empowered them to exercise those functions. And that's the amendment I ask for.
Any responses? No? Okay, so then I shall now put the question. Honourable Senators, the question is that Clause 5 be amended as circulated by the Attorney General. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that Clause 5 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 5 as amended now stands part of the bill.
The preamble.
Honourable Senators, the question is that the preamble to the bill be approved. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The preamble to the bill is approved. Honourable Senators, the question is that the bill as amended be now reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate.
Thank you, Mr. President. Mr. President, I wish to report that the Municipal Corporation's Extension of Terms of Office and Validation Bill 2023 was considered in the Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on the Municipal Corporation's Extension of Terms of Office and Validation Bill 2023. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Extend the Terms of Office of Councillors and Aldermen elected in December 2019 to provide for elections in 2023 and to validate the actions of the said councillors and aldermen between the 2nd of December 2022 and the 18th of May 2023 be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Extend the Terms of Office of Councillors and Aldermen elected in December 2019 to provide for elections in 2023 and to validate the actions of the said councillors and aldermen between the 2nd of December 2022 and 18th of May 2023 be now read a third time and passed. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Extend the Terms of Office of Councillors and Aldermen elected in December 2019 to provide for elections in 2023 and to validate the actions of the said councillors and aldermen between 2nd December 2022 and 18th May 2023.
Acting Leader of Government Business.
Mr. President, I beg to move that this Senate do now adjourn to Friday, June the 2nd, 2023 at 1:30 p.m.
Honourable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised on the motion for the adjournment of the Senate. Senator Mark.
Thank you, Mr. President. Mr. President, I have two matters that I'd like to raise on behalf of the citizens and the people. The first deals with the need for the Minister of Finance to provide a status report on the loans extended and shares invested by the First Citizens Bank in both Cornerstone Financial Holdings Limited and Barita Investments Limited, given their impending reorganization. Mr. Chairman, there is in fact a document I have in my possession. It is Cornerstone Financial Holdings Limited. It is on page 17. It deals with their financial audited accounts or report for the period ended September 30th, 2022. Now, before I get into this actual statement, I have raised this matter of FCB lending monies, foreign exchange, US currency, to a Jamaican company by the name of Cornerstone Financial Holdings Limited. This is an offshore company. You don't know the names of the directors. We don't know who the shareholders are. And I raised this matter since 2021 to get answers. I now have answers. Mr. President, in this financial statement of Cornerstone Financial Holdings Limited, which is an unlisted company on the Jamaican Stock Exchange, we see where under long-term loans, the First Citizens Bank loaned to this company $25 million US. Then we saw in that same, and that's 2022, Mr. President. Apparently they got the loan in 2021, and the loan remained outstanding in 2022. Then there's another loan for $15.1 million US. They got it in 2021. It remained outstanding in 2022. And the last loan I see on the statement is for $20 million US, which they got in 2022. Mr. President, it would mean that Cornerstone Financial Holdings Limited got from the FCB a sum of $60.1 million. And what is even more amazing, I have a document here from Anthony Wilson, which is stating that they could have gotten up to $80 million US. And the only collateral is, Mr. President, shares in a company called Barita, which is owned 75% by Cornerstone Financial Holdings Limited. Is himself to himself. The question that we are asking is this. The loan was supposed to be repaid, according to the document I have in my possession, on sometime in April of 2023. The loan has now been extended, Mr. President, to 2027. Now, I have also in my document, in my folder, a document that says, and I read, Barita to be delisted from the Jamaican Stock Exchange. Now, my issue and the need for clarification is twofold. Could the government tell the people of Trinidad and Tobago what portion of the $60.1 million US that is in this financial statement of Cornerstone Financial Holdings Limited has been repaid? That's the first area we want clarification on. We also would like to know if any further loans were extended to Cornerstone Financials after the $60.1 million loan that was granted. If so, how much? We are reading where Barita, which is owned 75% by Cornerstone Financial, and of which FCB has 7.2% ownership in Barita, with shares of some 90 million shares. We would like to know the state of play with those shares. What is the state of play with those shares, Mr. President? So here it is, FCB. I am a shareholder in FCB. There's a shortage of foreign exchange in Trinidad and Tobago. You want to go abroad, you can only get $200, and you have to beg to get it. Yet still, a fly-by-night organization called Cornerstone Financial Holdings Limited, less than 5 years in existence, is an offshore company. We don't know their directors. We don't know their shareholders. Yet still the government bank, which is our bank, lends to that company Mr. President, according to the audited financial accounts of this institution called Cornerstone Financial, we are seeing, Mr. President, we're on the books $60.1 million US. So what we are asking is the level of exposure.
Senator, you have 2 more minutes.
The level, thank you, Mr. The level of exposure of our bank called FCB in the event that this company, who we are learning from the documents I have before me, its major client is Barita. They own 75%. That company is about to be delisted. And when that happens, what will happen to the 90 million shares that are owned by FCB in Barita Investments Limited? So these are some of the issues that the shareholders and customers of FCB are asking. So I am calling on the government to provide some clarity to the country on this matter. One, in closing, 60.1 million, how much has been repaid? What is the quantum that have been loaned since then? And in terms of the shares, what is happening with the delisting of Barita Investments Limited? What will happen to the shares owned by FCB on behalf of the citizens when that takes place, Mr. President? These are the 2 issues I would like to have clarified.
Finance.
Mr. President, as it relates to the loans extended and shares invested by First Citizens Bank in both Cornerstone Financial Holdings Limited and Barita Investments Limited, given their impending reorganization, I am advised that pursuant to Section 55 of the Financial Institutions Act, Chapter 7909 of the revised laws of the Republic of Trinidad and Tobago, First Citizens Bank Limited, or the bank, as a licensed financial institution, is not permitted to disclose information in accordance with the section below. 1. No licensee, financial holding company, controlling shareholder, significant shareholder, or affiliate of a licensee, and no director, officer, employee, or agent of a licensee, financial holding company, or other controlling shareholder or affiliate who receives information relating to the business or other affairs of a depositor or customer of the licensee or of any other person shall disclose the information unless A. The disclosure is required under compulsion of law. B. There is a duty to the public to disclose the information. C. The interest of the licensee requires disclosure. Or D. The depositor or customer expressly or impliedly consents to the disclosure. 2. No person who obtains information referred to in subsection 1, directly or indirectly from a person referred to in subsection 1, shall disclose the information without the consent of the person to whom it relates and the person from whom it was received. 3. Notwithstanding subsection 1, a licensee or a person authorized by the licensee may, with the consent of the depositor, customer, or other person concerned, exchange information with another licensee. 4. This section does not apply to information which at the time of disclosure is or has already been made available to the public from other sources, or to information in the form of a summary or collection of information so framed as not to enable information relating to any particular person to be ascertained from it. 5. A person who discloses information in contravention of this section commits an offense and is liable on summary conviction to a fine of $600,000 and to imprisonment for 2 years. Regarding public notices on the reorganization of Barita and Cornerstone, it should be noted that under the laws of Jamaica, this is a matter for the regulator in Jamaica, the Bank of Jamaica, which is equivalent to our central bank. It should be further noted that in March of 2023, the Bank of Jamaica confirmed that pursuant to Section 71C2 of the Banking Services Act 2014, or BSA, the Supervisory Committee of the bank, at its meeting held on 1st of March 2023, raised no objection to the proposed reorganization of the Cornerstone Group on condition that the off-balance sheet vehicles, Burita Finance Limited and MJR Real Estate Holdings Limited, be consolidated in the financial group for prudential reporting purposes pursuant to Section 71(2) of the BSA. At this time, therefore, First Citizens has no cause for concern arising from this reorganization. Regarding FCB's investment in Burita, the value of FCB's shares in that company has increased by over $7.5 million or over 50 million TT dollars since the shares were acquired by FCB, and FCB has so far received over 24 million TT dollars in dividend from this investment.
Minister, you done?
Yes.
Yeah. Senator Mark.
Thank you, Mr. President. Mr. President, the second matter I want to raise here is the need for the government to make public its response to the auditor's findings in CLICO's annual reports for the period 2018 to 2022 on the market value of the assets of Methanol Holdings International Limited. Now, Mr. President, we got a statement from the minister sometime on the 15th of November 2022 when the very minister who is here today told us, and I quote, the valuation was completed in 2022 and shall be reported in CLICO's 2022 financial statements, end of quote. Since then, Mr. President, I have seen, on behalf of the party, the CLICO financial report for 2022. There was no independent valuation report contained in the 2022 CLICO financial statement as promised by the Honorable Minister. So the question that we sought to clarify when we went into this report issued by CLICO for 2022, what did we see? We saw an in-house valuation conducted by CLICO. Now, the question that is being asked, and we need clarification on, are very simple and straightforward. And I hope that the minister can provide answers. We had two valuation reports. One, according to the minister, an independent valuation report. And we saw in the 2022 CLICO report an in-house valuation report. Subsequently, or subsequent to that, Mr. President, what happened? The government sold 36% of the 56% owned by the company known as CLICO. And those shareholdings were under the heading MHIL. The question that is being asked is that when NIF bought 17% of the 36% shares that CLICO had to divest under the Insurance Act, which allows it only to own 19.99% shares in MHIL. The question that the country is asking, what was the value placed on the 19% shares that was in fact purchased by Corporation Seoul? Corporation Seoul, we understand, bought 19.5 or 6% of the CLICO's 36% shares. And the other, or the remaining, was purchased by the National Investment Fund, known as NIF. So 19 plus 17 would give you 36. I would like to ask the minister, through the president, which valuation report was used to determine the value of the 19% shares that the corporation Seoul purchased and the 17% shares purchased by NIF? Was it the independent valuation report? Was it the in-house valuation report? The country would like clarification from the Minister of Finance on exactly those questions. And most importantly, the very minister who is here today, when he last came, he told us everything was hunky-dory. Everything was fine, except one thing, Mr. President. The share register was not updated. So the ownership of 36%, 19% Corporation Seoul, 17% NIF. Who owns those shares as we speak? Because I would like to ask the minister, through you, whether the share register has been updated. Because in January, it was not updated. In February, it was not updated. In March, it was not updated. We are now on the 1st of June. So we would like to know if the register of these shares that's supposed to be transferred to Corporation Seoul and to NIF have the register been updated. That is what we would like the minister to tell this honorable House. Has the shareholders register been updated? That is the issue. Or is there a dispute? Is there a dispute? Is there bacchanal taking place? And the minister needs to tell the country the truth. Mr. Chairman, Mr. President, in closing, there's a $700 million difference between the independent valuation and the in-house valuation. That is why we need the government to clear the air as to which one was used to sell Corporation Seoul 19% shares and NIF 17%. Was it the in-house? Was it the independent? Because there is a lot more to be disclosed. Not now, not today. I'll pause and allow the minister to clear the air on behalf of the citizens of Trinidad and Tobago. CLICO shares belong to the taxpayers. And if you sell CLICO shares, give us proper value for those shares. So, Mr. President, I want to thank you for giving me the opportunity to speak and to raise issues on behalf of the citizens who would like to know what is happening to their 36% shares, which valuation report was used, and what was the value attached. And I would like to just say in a minute, could the minister provide this parliament with the shareholders agreement, the sale and purchase agreement, and the final valuation of these shares? Thank you, Mr. President.
Minister in the Ministry of Finance.
Thank you, Mr. President. If Senator Mark had taken the time to read, interpret, and understand the publicly available information on CLICO's financial statements, the Honourable Senator would have seen and understood that CLICO's 2021 financial statements at page 61, under item 4.3, Statements at Investments in Subsidiaries, make the following clear statement regarding the valuation of MHIL shares. I quote, "The company's investments in subsidiaries are stated at fair value and categorized as level 3 of the fair value hierarchy. The total carrying value of these assets is $2.61 billion. In 2020, it was $2.58 billion, representing 19.8%, in 2020, 19.1% of total assets. The company has not disclosed a description of the valuation techniques and the quantitative information about significant unobservable inputs used in the fair value measurements for the significant subsidiary, as a disclosure would bring CLICO MHIL into contempt of a court order. The final determination of the matter is in the Court of Appeal. However, the information has been presented to the company's auditors. It should be clear from this that the auditors wanted to do their own analysis, investigation, and research to establish the value of MHIL, rather than rely on valuation submitted to them by CLICO. However, based on a valuation done in 2022 by Charles Rivers Associates, a leading global consulting firm headquartered in Boston, Massachusetts, USA, that offers economic, financial, and strategic expertise to major law firms, corporations, accounting firms, and governments around the world, the mid-range valuation of CLICO's 56.3% shareholding in MHIL was determined to be $337,010,000 US, or 2.3 billion TT dollars. In particular, Charles Rivers Associates stated as follows, and I quote, "As of the valuation date, June 30th, 2022, the mid-case reasonably estimated fair value of MHIL's aggregate equity on a non-marketable basis is $596,162, or $59.61 on a per-share basis, with a low case value of $518,278, or $51.82 per share, and a high case value of $665,810, or $66.57 per share. The mid-case reasonably estimated fair value of CLICO's 56.53% holding of MHIL shares on a non-marketable basis is therefore $337,010, with a low case value of $292,983 and a high case value of $376,382. This valuation was commissioned while CLICO was under the supervision of the central bank, with the approval of the central bank and accepted by the central bank in 2022 as an appropriate basis for the sale of CLICO shares in MHIL to third parties. The government, therefore, has no problem with this valuation. Thank you.
Honourable Senators, the question is that this Senate do now adjourn to Friday, the 2nd of June, 2023 at 1:30 p.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate now stands adjourned to Friday, the 2nd of June, 2023 at 1:30 p.m.